open the public hearing of the Select Committee on Social Media and Online Safety via video and teleconference. In accordance with the committee's resolutions, this hearing will be broadcast on the Parliament's website, and the proof and official transcript of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I do remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now welcome representatives of Google to give evidence today. For the Hansard record, I ask that you would please state your full name and capacity in which you appear before the committee.
Good morning, Chair. My name is Lucinda Longcroft. I'm the Director of Government Affairs and Public Policy for Google here in Australia.
And good morning, my name is Samantha York, also from the Government Affairs and Public Policy team at Google here in Australia.
Thank you very much. Just some technical issues to commence, to advise you that although the committee does not require you to give evidence under oath, I advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'd like to thank you very much for making a formal submission for the committee, to the committee, which has been published, and I have no doubt all committee members have availed themselves of that. I'm mindful of the time and of the number of questions that committee members have indicated that they would like to ask. So unless there's sort of any strenuous objection, I propose that we potentially move straight to questions. Is that okay with each of you?
Yes, Chair.
Thank you. Thank you very much. We do appreciate that. Questions from the Deputy Chair.
Chair, and thank you to the witnesses for attending today. I thought I might just start with a big picture question, which is that does Google take responsibility for YouTube's conduct? My experience over the years with interacting with Google is that Google has been very responsive about its own conduct in sort of Google proper, so to speak. But on a number of occasions over the years, issues that I've raised about problems that YouTube seem to have disappeared into a black hole. So how do you deal with issues at YouTube? Am I talking to the right people, or should I be talking to someone else to get a response on those issues?
Thank you, Deputy Chair, and good morning. Indeed, you are talking to the right people. YouTube is an integral part of Google, and we have a One Google philosophy, and we take full responsibility for the activities of all our platforms and services.
Okay. Look, I just want to get into YouTube's approach to transparency. There's obviously been a lot of attention recently from leaked internal documents at Facebook about the impact of its products on issues like youth mental health and broader democracy. Commenting on these leaks, Alex Stamos, who's now the director of the Stanford Internet Observatory, noted that, quote, "I'm sure other products have the same impacts and problems, but they are either too small, like Twitter and Snap, to build these big expensive teams that don't drive revenue, or they have a strategy of not looking, like YouTube. It's a commonly shared view amongst academic researchers and NGOs that YouTube offers policymakers and researchers an objectively lower level of public transparency about the way its products work, the way it enforces its rules, and its own research about the impact of its products than it seems that Facebook has done. So while Facebook receives deserved criticism for the harmful consequences of its products, we need to acknowledge that some of this criticism of Facebook is fueled by transparency tools that it itself operates. So the first question is, why does YouTube not offer an equivalent of Facebook's widely viewed content report or its CrowdTangle service?
Thank you, Deputy Chair. I respectfully do, of course, reject that view. Google and YouTube are deeply committed to transparency and to full transparency into our operations. And of course, we look deeply. We care about the content on our platforms. We do not tolerate abusive content. and we take action rigorously and effectively against it. And we are transparent. In fact, we do publish numerous transparency reports, including the YouTube community guidelines, which in just the last third quarter of 2021 demonstrated, for example, that we removed 6.2 million videos, including over 22,500 here in Australia. They give full breakdowns of the nature of those removals, whether they be for child safety, violent, pornographic, or other content. And we correspond through our quite extensive teams here in Australia. We have over 2,000 staff here in Australia, closely in collaborating with the government, regulators, and members of parliament to ensure that there is full transparency and oversight of the operations that we have here in Australia and globally.
With respect, I'm not talking about content moderation here. I'm talking about what content is recommended and consumed on your platform. That's what the widely viewed content report on Facebook provides transparency of, and what the CrownTangle service provides transparency of. So why don't you want to show people what people are consuming on YouTube and what your recommendation engines are driving them towards?
Thank you for the clarification, Deputy Chair. Indeed, we are also committed to transparency around the way in which our algorithms and recommendation systems work. We publish a blog, we publish YouTube guidelines on the way our recommendations work. We publish on our websites very clear directions as to how YouTube works, how search works, and these give quite extensive, in one case, 170-page report on the way in which our recommendation systems work, surfacing content that is, in most cases, the most relevant and useful, as well as safe for users. So we are committed to that transparency in the way our recommendation systems work as well.
But unlike Facebook, you don't share what is actually widely viewed content and what your recommendation engines are actually sharing. And unlike Facebook, Twitter, you don't provide APIs to approved academic researchers or external researchers to validate what you claim about the way that your algorithms work.
We do work closely with external and independent researchers whose works from as broadly as Harvard or the University of California, Berkeley, Pew Research, The Economist, are all taking very close attention and third-party observation into our systems, and we ensure that that research is widely recognised and published. We also pay, of course, very close attention to it internally because as Google employees, we care deeply about the nature of the material that appears on our services. And we have a business interest in ensuring that our users are served with trusted content of the highest integrity.
So is Google familiar with legislation proposed in the US Congress that would authorise the Federal Trade Commission to force platforms to disclose in real time what information is spreading on them? Are you familiar with provisions in this legislation that would force cooperation with academic researchers studying the way that platforms operate and the impacts of these operations on users and society more broadly? Given the criticism of external researchers, academics and NGOs about their difficulties in getting transparency on YouTube in the face of your claims that things are completely transparent, why shouldn't government be considering regulation to provide this transparency to ensure that it's being provided so that we can have assurance about what's going on your platform?
Deputy Chair, we welcome regulation that is well tailored and sensible and reasonable, and we work closely with the government. In fact, we are currently working on 9 separate regulatory processes here in Australia alone. We work closely with the Privacy Commissioner, the eSafety Commissioner, the Australian Communication Media Authority, among many others here in Australia. And we welcome regulation that ensures that we can give trusted services to our users here in Australia. I am familiar with the many different regulatory initiatives being taken over the world, but wouldn't speak to the detail of US-based legislation.
Can you come back to me with an answer on notice about your views on that specific legislation providing FTC oversight on providing external researchers with access to that?
Yes, happy to take that on notice.
So I've got a few questions about the internal governance structure at YouTube. So YouTube's Chief Product Officer, Neil Mohan, recently described his role at YouTube as, quote, I'm responsible for all of our products, everything you use as a viewer of YouTube, everything our creators use. I work closely with our partners across Google in terms of solutions for our advertising partners. I'm also responsible for our trust and safety organisation. So everything that has to do with our content policies, what governs the type of content we allow on the platform and the content that we take down. So am I correct in understanding that this individual runs both the product team and the trust and safety functions at YouTube?
Deputy Chair, I'm not familiar with the details of all of Mr. Mohan's full responsibilities, but indeed the senior leadership of YouTube takes responsibility of all its teams, including trust and safety teams. We have over 20,000 persons employed by Google globally that work 24 hours a day, 7 days a week, reporting up to the very highest levels of the organisation, including Mr. Mohan and Mr. Wojcicki, who heads YouTube.
I think this does go to the issue I raised before, that when I ask specific questions about the operations of YouTube, I often don't get answers from people at Google. It seems like there's a lack of understanding about what's going on there from the representatives of Google that I deal with, but I'll perhaps inform you of how this works. That's what he's told people on the media, that he is in charge of both product and safety. In your view, you're a government relations expert, is there an inherent conflict between a product function, a business function, and a trust and safety function and an integrity function?
No, Deputy Chair, there is not. The safety of our users, their trust in us is essential. It is the core of our services. We make money because we invest strongly and heavily into the security and the privacy of the users who visit our services. In fact, in 2019 and last year, we invested over $38 billion in research and development, much of which was committed towards that security. So while we are a profitable company because of the trust and integrity of our services, and because we put users first, there is no inconsistency in the security and trust that we provide to users in our services.
Well, let me give you a hypothetical. A frequent criticism of YouTube in the past has been this so-called radicalisation funnel, where the recommendation drives further engagement to keep people watching longer, use YouTube's recommendation algorithms or recommend more and more extreme content to drive further engagement, for further watching, leading some vulnerable people down a rabbit hole of radicalisation. There's been plenty of media coverage of this and plenty of academic coverage of this. Now, putting to one side your view of whether that radicalisation funnel is actually operating on your platform, if it did operate in that way, wouldn't the increased product engagement generated by this effect conflict with the trust and safety goals of YouTube?
Deputy Chair, I wouldn't engage in a hypothetical last night of that nature. In a 2020 report by the University of California in Berkeley, in fact, they found the opposite of that YouTube's recommendation algorithms lead against pushing people towards radicalized or extremist content. And other similar studies by like the Pew Research Center have found that in fact our recommendation algorithms push people towards popular mainstream media content. And it's because of that that we have the confidence that we are able to present material which is useful and trusted for our users. Some 19 million Australians who are visiting YouTube and our other services on a monthly basis.
It's difficult for us as policymakers to assess all of this, though, because the way that your recommendation algorithm operates has changed significantly over the past few years. And when I first raised my concerns about this radicalisation funnel before the Christchurch atrocity, I got the same answer. I think that I'm right in thinking that the way that recommendation algorithm operated was quite different back then, while I was still being told it was okay by Google. Parking that, can I ask how Mr. Mohan's short-term incentives are structured in the dual functions of his role? How are his performance incentives on engagement weighted against his performance incentives on trust and safety?
Thank you, Deputy Chair. As I mentioned, the trust of our users is the core of our business. It overtakes all other incentives. If we lose the trust and if we fail to provide safety for users here in Australia and elsewhere, our business would fail. And as a result, it is the primary purpose and core criteria for our work.
So in a recent article in Wired magazine, Gillard Edelman argues that social media platforms need to establish a, quote, separation between church and state, between the pursuit of advertising revenues and other social values, in the way that traditional news media organisations have had to do so in the past. But just being clear, you see no potential, theoretical or real, for a conflict between a product's financial performance and other social values.
No, Deputy Chair, because as I said, our products would fail if we failed to serve our users with both useful and trusted content.
Okay. A week ago, the International Fact-Checking Network, a coalition of 80 international fact-checking groups, including RMIT, ABC, Fact Check in Australia, sent an open letter to the CEO of YouTube stating that, quote, YouTube is allowing its platform to be weaponised by unscrupulous actors to manipulate and exploit others and to organise and fundraise themselves. The letter continues, as an international network of fact-checking organisations, we monitor how lies spread online. And every day we see that YouTube is one of the major conduits of online disinformation and misinformation worldwide. The letter identifies numerous examples of this dynamic, including many COVID-19 misinformation narratives. The letter further states that many of these videos and channels remain online today, and they all went under the radar of YouTube's policies, particularly in non-English speaking countries in the global south. We're glad that the company has made some moves to try and address this problem lately, but based on what we see daily on the platform, we think these efforts are not working, nor has YouTube produced any quality data to prove their effectiveness. Do you find correspondence like this concerning?
Of course, Deputy Chair, I'm aware of that correspondence, and it is deeply concerning to us. We care. I care. I'm an Australian, a mother, as well as a Google employee. These are deeply important and concerning events, and we pay close attention to them.
Okay, so what are you doing about it?
Indeed, the fact-checking letter references some quite extensive work that Google is already doing and committed to continuing to doing and extending to ensure that factual and truthful information is surfaced on our platforms. We have large international networks working with the Google News Initiative and international fact checkers. And here in Australia, we support, for example, the AAP, and I reference the particular impact of that letter on multilingual fact checking and the vulnerabilities around languages. So here in Australia, our partnership with the AAP and then in turn their work with the SBS has worked to address fact checking in 3 languages, in Mandarin, Arabic and Vietnamese, to ensure that Australians receive, of all nationalities, receive factual information. We also here in Australia have established with Crosscheck Australia, in partnership with First Draft, a bureau in Sydney to ensure that Australians, including a coalition of large and small news publishers, have training and access to fact-checking resources that cross across the many diverse cultures here in Australia. And we are committed to increasing fact checks across our information platforms, particularly search and YouTube. And we are increasing our collaborations with fact-checking organisations. So it is something we take very seriously. It's something we are deeply invested in. But the idea that that our systems are not working is something that the facts don't bear out. As I mentioned, that the community guidelines report that we publish, and it is transparent, is one of a number of transparency reports that are published on our websites on a regular basis. As I mentioned, in the third quarter of 2021, we removed some 6.2 million videos. The investments that we make, quite heavy investments that we make in both technologies and those over 20,000 staff globally who work on content moderation, have ensured that we are increasingly more effective. 95% of the videos that are being removed are flagged first by our automated systems and then reviewed by highly trained trust and safety teams. We have also introduced a new metric to help with transparency, both to guide our efforts and to ensure that we are accountable to governments and policymakers like yourselves. And this is the violative view rate. The violative view rate was introduced in 2017 and shows that even since that time, we are getting more and more effective in removing material rapidly so that harm isn't caused to our users. The violative view rate showed that in the third quarter of 2021, the view rate was 0.09 to 0.11%, which translates to the fact that for every 10,000 videos viewed on YouTube, between 9 and 11 only between 9 and 11 come from violative content that violates the broad range of community guidelines and policies that we enforce robustly across our platforms.
I mean, where that leaves me is that we have this continuing dynamic where I ask questions, or policymakers ask questions about issues on the platform. Google says it's fine, we're dealing with it. Policymakers and NGOs raise further questions. Further initiatives are announced, while at the same time Google says it's fine.
Deputy Chair,
there is a continuing representation saying it's not an issue. We're dealing with it.
It is an issue.
Interventions are working, but we're also doing all these new interventions. Can you see the disconnect here? Like, I've been engaging with this conversation with Google for my entire period of Parliament, and I feel like it's deja vu all over again.
We have engaged with you closely, Mr. Watson. We appreciate your concerns. It isn't fine, and we don't believe it is. We pay close attention to this. It is deeply concerning to us, and we care. We are not only investing money and resources, but constantly working with external experts, with governments and policymakers to find ways to improve our services, to ensure that we are serving our users with the most trusted information and removing harms from all of our populations, including the most vulnerable.
If I can just add to that, Lucinda, Mr. Watts, we never consider our work done here. This is an area that we are constantly investing in, as Lucinda has alluded to, and doubling down on and receiving feedback from valuable stakeholders like yourself. And we will continue to improve. And while we acknowledge that we've made some good steps in this direction, there is more work to be done. And we will always put our hand up and very honestly attest to that there is more work to do and that we will not stand still.
Yeah, I mean, I don't want to litigate fine distinctions, but when I hear evidence that says that the evidence doesn't support that YouTube's interventions aren't working, I hear that as saying that this is not a problem, that the issues raised in this fact-checking letter aren't real issues.
Deputy Chair, these issues are real. They are concerning. We are deeply concerned and we are heavily invested in addressing them. We are making good inroads on the issues and the problems, but we have work, as Samantha has said, we have work still to do, and we will continue to invest those resources to work with people like yourself and policymakers around the world to be accountable and transparent to governments and to those who are concerned enough and thankfully concerned enough in our community to ensure that they keep the spotlight on this work and that we keep to engage with them.
Okay, I just want to ask one more set of questions on this topic and then I'll throw back to the chair if that's okay. So one of the issues raised in this fact-checking letter was dealing with repeat offenders on the platform, and that an overwhelming volume of this misinformation comes from actually people that continue to propagate misinformation. You know that I and other Labor colleagues have raised these concerns with you about United Australia Party's presence on your platform in the past. Their YouTube page is riddled with videos spreading COVID-19 misinformation, undermining public health efforts during a pandemic and a vaccine rollout. One ad that we flagged presented incomplete extracts of the TGA's adverse event report for COVID vaccinations, which the TGA had said could be, quote, seriously misleading. That was removed eventually, but not before the UAP had spent somewhere up to $100,000 promoting it in advertising. UAP has now spent nearly $5 million on advertising on YouTube since August 2021 across 57 videos. That's around 98% of the total political spend on YouTube in Australia since then. Doesn't this indicate that you need to be a lot more proactive in enforcing your COVID misinformation policies to ensure that this misinformation is taken down before the harm is done, and particularly before advertising dollars are being used to amplify this misinformation?
Deputy Chair, I fully agree that our COVID misinformation policies need to be robust, rapid and effectively enforced. They are, and we are constantly working to improve them. In fact, when the COVID-19 misinformation policy was introduced, that prevents and forbids COVID misinformation, be it around remedies or around denial of the pandemic, introduced at the start of the pandemic, we've now removed over 1 million pieces of COVID-related information, including from February 2020 until March 2021, over 5,000 pieces of information here in Australia. In the first quarter of 2021, that was part of the other 30,000 videos that we removed here in Australia. So both our Australian-based teams and those over 20,000 trust and safety people globally are working constantly to enforce those COVID-19 misinformation. Here in Australia, we take action against all persons, regardless of their political status, regardless of who they are or who they might represent. And that includes actions against members of all political parties in Australia to every side of the spectrum. We do not allow political bias on our platforms. And that includes rapid takedowns of material according to our transparent enforcement policies of issuing warnings and strikes. And for the repeat offenders that you had mentioned, if they receive 3 strikes in a 90-day period, their YouTube accounts are terminated for life.
Do you accept that it is a failure when COVID-19 misinformation that is subsequently taken down is promoted with advertising funding?
It is certainly against our principles. Our ad policies.
But not against the principles. Is it a failure of your systems when you can have someone that repeatedly shares COVID-19 misinformation have the capability to amplify that misinformation by putting advertising money into it? We know that Mr. Palmer has said that he wants to spend tens of millions of dollars on promoting his content, up to $80 million. We're in the middle of a pandemic. We know he is a repeat offender, yet you are doing nothing to stop him amplifying content on your platform.
We certainly are doing everything in our power to stop him from, and every other person who might promulgate misinformation relating to COVID or other on our platforms. We do not seek to profit from that information, and our ad policies and our enforcement is in line with that.
You do not seek to, but you have in the past. What are you doing to stop that happening again?
We are increasing our investments in security. We are increasing the efficacy of our secure systems, our automated machine learning and artificial intelligence systems that pick up over 94% of all of this content. We enforce our ads policies. In relation to other vulnerable areas like elections, for example, we have special election transparency policies that have implied even stricter guidelines around who can advertise on our platforms. So while, of course, we do not and are not comfortable with any mistakes that are made, we are rectifying those mistakes and taking all available action, putting all our resources, considerable as they are, into trying to ensure that that misinformation has no place on our platforms and cannot harm our users here in Australia or globally.
I could probably save you some money. It doesn't require artificial intelligence investments to understand that Craig Kelly and the United Australia Party are sharing COVID-19 misinformation. They have in the past, they will continue to do so in the future. We know that many of the accounts that Mr. Kelly...
Sorry, I might just ask, sorry, Deputy Chair, I might just ask that you rephrase that, please.
I'm happy to have it stand as a comment. Mr. Kelly and the United Australia Party have both received strikes in their accounts on YouTube. Why don't you provide transparency about those strikes? Why don't it surely is a matter of public interest when we have a serial repeat offender of sharing COVID-19 misinformation who has stated publicly that they want to spend tens of millions of dollars promoting this misinformation. Surely it is in the public interest for us to know how many strikes they have received and when you are finally going to put the foot down and say that you're not going to enable this sharing of misinformation.
Deputy Chair, we are transparent in our community.
Okay, how many strikes do they have?
Information. We do not, however, publish full information about the details of the strikes issued against the many Australians of private and public nature for good reasons. The vast majority of those who receive warnings or strikes on our platforms do not mean to do harm, and we give them the opportunity to correct their work. When a first strike is issued, we remove privileges of that channel owner for a full week. If a second strike is received in a 2-week period, in a 90-day period, then we take down the privileges for 2 weeks. And as I mentioned, in a third strike, that information and that channel is terminated perpetually. We preserve and balance the privacy of users on our platforms with the need for the public and for accountability to our members of parliament. And indeed, in a committee at which we appeared at the end of last year, we provided confidential information to committee members, to members of parliament, about particular strikes that had been issued, and that in that way ensure that we balance the rights of privacy with the rights of account and the need for accountability in our policymakers and members of parliament.
So I reported 9 videos on the UAP page that contained COVID-19 misinformation. You took down 6, but we don't get to 3 strikes from doing that.
If a number of videos are found to be violative at the same time, they're bundled into one strike in a period of time.
I'll remember to stretch them out next time. Thank you, Chair.
Thank you very much, Deputy Chair. Thank you to the representatives of Google for your time here today. I'm just mindful there's a lot of committee members who do wish to ask some. I'm just going to flag in advance that we may go a little longer than 11 o'clock, if that is okay with you. Could I just confirm, Ms. Longcroft, that you did say in your first response to the Deputy Chair that Google will not tolerate abusive content? I think they were the words that were used.
Thank you, Chair.
Yep.
We do not tolerate abusive content or harassment on our platforms.
Okay, and I think the context of another question and something else I took note of was your comment that you were talking and then you talked about because we put users first. I appreciated your submission because it did give me an opportunity to understand some of the perspectives that Google have in relation to social media and online safety. And I noted that you do have you've indicated your long-standing commitment to the safety of our users. As somebody who has experienced significant online abuse, not as a public figure, absolutely, but actually, a number of years ago in a private individual capacity, and knows all too well the impact of this on an individual. I was interested in looking through, and I noted your work with the government to keep Australians safe online, your products and policies to keep children safe online, example of online safety policies you provided. You provided a lot around children, a commitment to promoting the well-being of Australians online, comments in relation to digital trust, transparency and accountability. I couldn't see an area that's focused specifically on the commitment to keeping adults safe online. I'm just wondering, and I couldn't see any commitment, any area where you'd outlined, and perhaps it was just missed in the submission, where there was a commitment or an outline of your policies to keep Australians safe online by ensuring, as you said, that Google does not tolerate abusive content. I'm just wondering if you can outline specifically your policies around ensuring that you do not tolerate and how you do not tolerate abusive content.
Yes, Chair, thank you. And thank you for acknowledging our submission. Indeed, we are committed, of course, to protecting and preserving the safety and security of all Australians. Our submission did focus on some of the more vulnerable groups, such as children, where we do take extensive action. But we are, as a premise, of course, committed to the safety of adults, of all users on our platforms. As late as 2019, we updated our policy on harassment and and bullying online. We have an extensive range of community guidelines for YouTube that prevent harassment, cyberbullying, take action against violent and graphic content, take action against harmful and dangerous content and hate speech, and explicit and implicit threats on our platforms. And we, as mentioned, do enforce these policies through large trust and safety teams, as well as through the automated systems that catch content, and through trusted flaggers, people here in Australia who raise concerns with us relating to content that would be harmful to any adult, to any person here in Australia. I could hand over to my colleague Samantha, who also leads on our online safety activities here in Australia, and might detail some of the development and the collaboration that we have with regulators, as well as with the legislative processes.
Thank you, Lucinda. Just to add very quickly, Chair, that we do work very closely with the eSafety Commissioner. Obviously, her powers have been significantly expanded under the recently passed Online Safety Act, which comes into effect next week. We're very much looking forward to working with the Commissioner as her powers extend to adult cyber abuse and the way that that is manifesting across all of the digital platforms that she has purview over. I would also just highlight, as Lucinda has done, that our policies apply across the board to all Australians, not just to those vulnerable groups that were identified in our submission. And to also just highlight that there are a range of existing laws that relate to harmful content that directly apply to Google and YouTube as we go about our business. Those include the Defamation Act, the Racial Discrimination Act, the Privacy Act, the Online Safety Act, as I've mentioned, and the Enhancing Online Safety Act that preceded the Online Safety Act, which addresses cyberbullying towards children and image-based abuse. So there are a range of laws in place that certainly put legal obligations on us to protect Australians, both adult and minor, but also in addition, our policies are an overlay across those laws that do also protect adults.
Thank you. That's a very comprehensive answer, and I have moved now to a teleconference hybrid model because there was some challenge with the hearing, the sound quality, so hopefully this is a little bit better. I've got some examples of some content that is online, and I'd like to ask you whether it meets the very comprehensive standards that you've outlined. Before I do, I just want to ask you whether you consider the threshold at which you apply a removal policy to be of a high or low standard? Firstly, generally.
Thank
So
you,
is the
Chair.
threshold high or is the threshold low? How do you set the determination for what is abusive or harmful content?
Thank you, Chair. I'm glad you raised that issue. It is a complex and very serious question as to where the thresholds and where the standards are set. Of course, we abide at the very first level by any Australian laws or any laws in the countries in which we work, and that material is taken down expeditiously, and we work very closely with Australian courts and with Australian law enforcement officials. That threshold is absolute. In material then that we do not believe and would not tolerate on our platforms, we have the extensive range of community guidelines that I've outlined and policies in relating to ads, for example. You had asked how they are set and how the standards are met. And this is a complex matter because a platform like YouTube, for example, has as its premise that it is an open platform. The value and our mission of making the world's information universally accessible and useful to people is, I think, a reflection of the core importance of that information and of a diversity of information for democracy. So we balance that against these standards that we create by close collaboration with experts and with governmental authorities. The thresholds is designed to make that balance real.
Thank you, Ms. Longcraft. I take your point, but I'd also observe that community standards are not complex for the vast majority of Australians. And I guess my question, just a simple short answer if this is okay, because I've got a number of questions. My question firstly is in relation to the community standards and the thresholds that you've referred to. Is it one policy for all, or do you have different standards when it comes to A, individuals, B, community organisations or groups, and or C, public figures? Is it one and the same, or are there different thresholds depending on who you are?
Thank you, Chair. There is one standard, and that is applied robustly to all content, regardless of the nature of the person or entity that posted it. But context matters. Our teams are trained to take into account the context, whether it is a public figure, for example, that is making a statement, whether it is educational, artistic, scientific, or documentary. That context is carefully calibrated in determining whether material should remain up or whether it would be harmful to our users.
Okay, thank you. Let me provide you some examples that I found. These are not the worst examples. These are the ones that are appropriate to read out. And even so, I'm not going to use all of the language. Would this standard breach your community? Would this comment breach your community standards? Would a user of your platform be censored or banned for calling a man or woman a whiny little bitch? It's a simple yes or no answer at this stage.
Chair, I understand that you are referring to a particular case that relates to a public figure here in Australia. And again, those standards would have to take into account the context of the person, the nature of the person who had made the comment, and in determining whether in any particular case, and I wouldn't comment on a particular case, but those very clear policies would be met.
I hear that, but I could pull up a lot of examples and it wouldn't matter whether it referred to a particular individual or these comments, which are not unique. I will make that very clear. They are not unique comments. They are examples, whether they would actually breach your standards or not. The second one is a silly C, and you can fill in the blanks.
While I might personally find comments objectionable, our standards are enforced and our guidelines are enforced by trained, trust and safety employees who look both at the nature of the material in very clear connection to our specified policies and the context.
I'll keep going. How about calling somebody a DICK hole?
Chair, I wouldn't comment on the particular cases that you are mentioning, but I think this draws to the importance of a decision not being taken according to what I, Lucinda, might like or not like, what might offend me or not. The diversity of opinion that has to support our democracy on our platforms in Australia is a leading democracy. How we address these matters here in Australia in this committee is being closely regarded by countries around the world. Companies like Google are in a position of enforcing guidelines that need to be agnostic of our personal views and take into account expert standards and context in every case.
Okay, no, I take your point and I thank you. I'll ask you about another one that with language that indicates that somebody should kill themselves or put a bag over their head to suffocate themselves. Would that be removed if requested?
We have clear policies that address mental health issues. And of course, through the pandemic, those issues of mental health, of suicide, of self-harm have been exacerbated. And those policies are applied. In YouTube, we have a process by which our algorithms are determined to and designed to remove violative content, but also to reduce content that, while it doesn't violate our policies, is at the borderline of those policies. We raise up authoritative content. So, for example, in the case of, as you've mentioned, self-harm or suicide, we have given close to $5 million of grants to the Australian Department of Health to surface authoritative information through this COVID pandemic. In the case of mental health, we direct users towards Lifeline, Butterfly, and others.
Yeah, I hear that, Ms. Longcraft, but I'll just say again, I referred earlier to the fact that 20 years ago, I was subject to some of the most vile and horrific abuse online, and the impact of that I suffer that today. I know full well the impact on mental health. I know full well the long trail of trauma that abuse like what I have read out actually does to an individual, regardless of whether they are a member of parliament or a public figure or a member of a community organisation or an individual. So I say again, is there any, given that you've talked about the content, I'll come back to this particular one that I did not, obviously it's a 4-letter word, it begins with C and it finishes with T. Is there any context in which a woman, it's considered to be okay to call a woman or any person, any human, a silly, beginning with C?
I certainly wouldn't use that word, but I couldn't speak to the particular context of the particular material that you're referring to, Chair. And I am very careful not to make pronouncements that take my personal views into account in determining the agnostic process by which we apply our policies to all Australians and to all content, and the context in which a comment, nasty as it may be like that, is made.
Ms. Longcraft, abuse is not agnostic. Abuse is very personal, and online safety is of extreme importance to this committee and to every single member of this committee. Those comments I read out, I've got 3 or 4 pages of them and I could continue, but I think the point is made. My question is very simply, if these do not meet what I would consider to be a threshold standard for removal, do you think some changes need to be made?
Thank you, Chair. Changes are constantly being made. As Samantha mentioned, the Online Safety Act will come into force in just a few days. Australian defamation law is in a 2-year process of reform, which we have closely lent into and collaborated with at the Attorneys General level. We are constantly revising our own policies, constantly investing, as I said, in the secure systems and the technologies that can ensure that we are keeping up with community standards, that we address new threats as they arise. This is deeply concerning to us, and we will continually commit to making our processes better, to our enforcement better, and to listening to policymakers such as yourselves to ensure that we are responsive and accountable in our processes and systems.
All right, well, let me ask you a different question. Do you have specific policies in relation to gendered abuse?
We do have a policy and several policies that forbid the treatment or hate or aggression or threats towards a person based on certain characteristics, which includes gender.
Okay, so what about a comment? Would this be removed? A comment about a woman, I bet she rages so hard a natural disaster occurs every time she has her period.
Thank you, Chair. These comments, of course, are distressing, but the context in which they're made is taken into account in determining whether Australians and users all over the world should have access to them and to the diverse range of content that is essential to support our democracy.
Okay, so are you affected? If I flip what you're saying, I'm hearing you're saying there are some contexts in which the comments I have read out are okay. If I put it in plain language, that's what I'm hearing. Is that correct?
Chair, yes, there are some contexts in which there are some situations and circumstances in which the context of a comment would mean that it tips the balance in terms of remaining up and being accessible to our users to enable them to make their own determinations about the nature of the comment. But where we see that they are violating our standards, we take swift action against them.
So would it take legislation to actually make sure that online platforms have community standards and comply with community standards that the ordinary Australian would see are completely breached by many of the comments and all of the comments that I've read out today? Is that what it would take in order to ensure that abuse is no longer something that is left online and allowed to continue? And I'll go further. Why is it? We heard from a witness earlier this week, Ms. Molan, and she actually made a very valid point where she indicated, why am I being told that for my safety perhaps I should get off an online platform, when actually why isn't it the perpetrators being kicked off? My question is, What policies does Google have or will you consider implementing to ensure that perpetrators and people who choose to degrade, demean, dehumanise individuals, community groups and public figures do not get access to your platforms?
Chair, indeed, we do have the policies. We have an extensive range of policies. We are committed both to continually enforcing and upgrading those policies. We are also aware that we cannot do it alone. You talked about regulation. We welcome regulation, which is tailored to this area. There is legislation. The Online Safety Act will come into force on the 23rd of this month, and we will comply with it as we have worked in very close collaboration, Samantha included, with the Safety Commissioner, as well as with the Privacy Commissioner, to help balance the various legislative processes and the competing demands of this society of Australians to have access to information as well as to be protected from harms online. We're deeply committed to that, but we will work with partners, with yourselves, to ensure that we do the best possible job for Australians and our users.
Okay, I thank you. I am conscious of time. There was a comment you made in relation to a response to the Deputy Chair where you indicated the words I wrote down were because we put users first, but the specific reference I was interested in was putting users first, which is a very commendable thing for any entity to do, any business organisation to do or corporation. But my question is, which users? Individuals or those with paid content? Who gets priority when you are putting users first when those priorities compete?
Chair, I'm sorry, just on the sound quality, the question was, who do you put first, users?
Yeah, thank you, Ms. Longcroft. I understand we are dealing with some technical difficulties, so thank you. Can you hear me more clearly?
I can. I can.
Okay.
Thank you.
Thank you. So I was interested in a comment that you made earlier in one of your responses to the Deputy Chair where you ended with saying, or began with saying, because we put users first. It was an interesting comment, a very valid one and an important one, but it brought up a question for me because you have a number of different users. You have individuals, you have young people, and you've outlined a number of policies that you've put in place to keep young people safe. But when you have competing priorities, the individual user or the paid content, which one comes first in relation to your policies? Which one is more important?
All Australians, all users who come to our services to receive information, to be entertained, to connect to their loved ones, all users on our services are equally important in that respect. We do, however, pay particular attention to vulnerable groups of users, be it women in vulnerable situations or children, for example. And for that reason, we have invested particularly and are making particular upgrades to our services to ensure that children in a various range of contexts have greater protections. We also pay greater protection in certain circumstances. So, for example, with the upcoming federal election in Australia, we are working with the Australian Election Commission, we're working with members and senators and with the law enforcement officials of Australia to ensure that there is integrity in our services for all Australian voters and for their representatives in the context of an election.
Okay. I'm in the interest of time, I won't continue down this, but I will say I am troubled by different standards that seem to depend on a context. If you are a public figure, that the ordinary person would say is not okay in any situation. I'm troubled by that because I think my belief is that abuse is abuse and it should be applied robustly across the spectrum regardless. And I'll leave that comment as a comment. I want to just go very quickly to algorithms. The Deputy Chair was talking about some of these and you indicated about your automated algorithms, etc. I just find it interesting, and I was making this comment in one of the earlier public hearings. I've actually appreciated using social media. I find it very important, very valuable. I get a lot of information from it. Very, it can be a great experience. We want it to be a great experience for all people. If I go further, in looking at particular issues or in searching for particular products, I often find it very helpful that I get these targeted advertisements or information that pops up, and that can be of great help. Of course, we also know that it can cause other issues, which will be the subject of another conversation. But what I don't understand, or I guess my question is, if companies like yours, because it's not just Google, but if companies have such technology that they can target so well, so efficiently, so effectively that people say they must be listening to my conversation, such is the efficacy of this, why can't you flip it and use it to target and actively make sure that when online abuse, harm and threats are made towards an individual, a community or a public figure, that they are taken down and the user banned, or, you know, if repeated or whatever you do. But why can't it be flipped to be used for good in that way? What are the impediments? Is there a technology impediment? Is there a profit impediment? What would be any impediments, if any?
Chair, you've exactly described the way in which our algorithms work to do exactly that. Our algorithms are designed to help people discover information that is most useful and relevant to their query or to what they're looking for. In the case of search, for example, that's very much based on the query they pose, but in YouTube also to the way in which they use the platform. But our algorithms are also, and recommendations are designed to remove content which is violative, to raise up content which is authoritative and particularly useful from sources that are fresh or from recognised media outlets, for example, or otherwise which have become very popular on the basis of their integrity or their trustworthiness, and to reward creators who are known to produce information which is safe and useful. So it is exactly the way in which our recommendation algorithms are designed to work, that removes content which is harmful or abusive and raises up content which is useful and safe.
If I can also add to that, Chair, it's quite straightforward to automate a process whereby if you do a search looking for a new pair of Nike trainers, for instance, and we present targeted advertisements to you based on your search query, it's very easy to automate that. Your intention is made very clear to us that you're looking to buy a new pair of sneakers. In applying these automated strategies to the context of harassing and abusive content, as Lucinda has detailed, the context is so important, and it's very hard to automate an algorithm to interpret context in the same way that we as humans do, which is why we can't completely automate and I guess remove content that is considered to be harassing and abusive. It needs an additional human review to look at that context to determine whether a comment is being made in the context of a stand-up comedy performance, or whether it's being made in a joking way between friends, or whether it's being made in a very malicious and insulting way.
Okay, I might just ask then that you take on notice, given your response and the time, that you take on notice and just provide the committee with an indication of the context with which, what specific context with which the examples I read out would be allowed. I will cede way, because we do have a number of questions, to Mr. Kelly, who I believe is online.
Thank you, Chair. Yes, I am. Am I right to fire?
Yes, we can hear you. Yes, we can hear you.
So I'm sorry, I didn't catch the witness's name. Mrs. Longstaff, was it? Is that correct pronunciation?
Thank you, Mr. Kelly. Longcroft, but
whatever. Sorry, the line, the receptions are not the greatest. Look, a couple of minutes ago, you talked about the importance of diversity of opinion in a democracy. Could you explain to me how you define COVID medical misinformation?
Thank you, Mr. Kelly. Yes, COVID.
So where is the line between what is misinformation and what is a genuine, valid, alternate opinion in a democracy.
Thank you, Mr. Kelly. Indeed, our COVID-19 misinformation policy, which was developed at the start of the pandemic, is fully published on our website. It is quite detailed. It takes into account very clear guidelines from global authorities like the World Health Organization, as well as trusted medical and scientific authorities and governmental authorities. And it is constantly reviewed and revised as scientific and medical information is updated. And we work very closely with global experts. As I mentioned, here in Australia, we work closely with the Department of Health and defer and ensure that users who search for COVID-19 information are directed towards them. The standards and lines of what is COVID-19 misinformation, for example, might refer to denial of a pandemic, or to claims that ivermectin is an effective treatment, for example. But the details of that policy
can you just stop there, please? Let me just take you to that. I have a peer-reviewed study in front of me that says, by experienced medical researchers, which says in the conclusion, in this large study, regular use of ivermectin as a prophylactic agent was associated with significantly reduced COVID infection, hospitalisation and mortality rates. So what you are saying, you would block the content of peer-reviewed studies.
Mr. Kelly, I wouldn't speak to a particular example of which I'm not aware.
I think that you were just cited the example of ivermectin, and you said that you did not allow claims, I think it's here in your thing, contents that recommends the use of ivermectin or hydroxychloroquine. And here I've just quoted to you a peer-reviewed study that says something that is contradiction to you. So it is clear that you would block peer-reviewed science.
No, it's not clear, Mr. Kelly, because the context in which that information is made available to our users is taken into very careful account in determining whether the information would be harmful in accordance with the clear parameters of our COVID-19 misinformation policy. That context might be educational, it might be scientific, it might be artistic, for example. And so in any particular case, when our automated systems or our trusted flaggers raise concerns with us, as we appreciate the damage, significant harm that can be done by COVID-19 misinformation to populations like Australia and around the world that are dealing with the significant harms and effects of this pandemic, we take very seriously both the nature of the harm as well as the context.
Okay, let me ask you another question. What do you do where there is a different opinion between World Health Organization and local government authorities? Let me give you an example. Yesterday, the chief scientist of the World Health Organization said, and I quote, "There is no evidence right now that healthy children or healthy adolescents need boosters." Now, that is contrary to what we are hearing in Australia from government health regulators. So how do you, where there's a conflict like that, how do you do that? Because I would, if I were reading if I read your standards, the chief scientist of the World Health Organization should be taken down. That statement should be taken down and blocked.
Mr. Kelly, I wouldn't speak to that particular example, but this is the perfect case of illustrating why a diversity of opinions and views of authoritative and trusted sources.
But you're not allowing your standards specifically deny people that have alternate views and diversity of opinion from those opinions.
No, with respect, Mr. Kelly, our policies allow diversity of opinion. They ensure that with a given context, that information of diverse opinions from authoritative and trusted sources, or with context to allow our users to determine the veracity of the material themselves, is available to them. And we are constantly, as I said, over 5,000 pieces of COVID misinformation in Australia alone, over 1 million pieces of content globally have been taken down in accordance with those policies. But there is a great deal of material up that shows a diversity of opinion that you have been able to access yourself. And given that context, it's the careful line.
So you talk about you allow diversity of opinion. Would you take down a speech from a member of Parliament?
Mr. Kelly, I wouldn't speak to a particular case, hypothetical such as that, but indeed, particularly in a democracy such as Australia,
it's not a hypothetical. It's something that YouTube exactly did, and I can give you countless examples of it. So you're saying you have a diversity opinion, you say you allow these alternate opinions, and you say where they're given context, but you still review the content of speeches in the parliamentary Hansard and delete them.
Mr. Kelly, our policies are applied regardless of the nature of the person, the position they hold, or
well, hang on, that's not true. You were just speaking
Sorry.
to the chair, and the chair said that you just said you apply different standards for public figures. So public figures can be abused online, so you have a different standard for public figures when it comes to abuse. But you don't have a different standard for public figures when they're able to express what should be a legitimate opinion.
Yes, Mr. Kelly, it is complex, but the standards are the same. The context in which the
hang on.
taken.
Can I just clarify that? You say the standards are the same, but you said before to the chair that you apply different standards to public figures when she was raising a whole series of online abuse, that you seemed to indicate that was okay because it was directed at a public figure. So if you're saying you have the same standards, that seems to be completely contradictory to the evidence that you gave earlier.
Thank you for allowing me to clarify, Mr. Kelly. The standards are the same. The context, including whether the person who made the comment did so in a public capacity, is taken into account by our trained trust and safety reviewers in determining whether material would be harmful to users or should remain up on our platforms.
Okay. When it comes to COVID medical information, are those people that make those decisions, are they medically trained?
They are trained in applying both our policies and our decisions, and they are working closely with medical authorities, with scientific authorities and experts around the world.
Right, but they're not medical doctors. They have no special medical qualifications themselves.
Among the over 20,000 staff, I'm sure that they have many different qualifications, but they are not acting in that capacity. We defer and work closely.
They are. If they're making a determination, I can give you countless examples of doctors, medical doctors, qualified medical doctors and qualified medical professors that have expressed opinions in relation to COVID that have been taken down by your organisations and have been censored by your organisations. Now, I'm trying to determine that censorship, is that censorship being done by people of equal qualifications, or do we have a situation where we have non-medically qualified people censoring qualified medical people on medical issues?
Mr. Kelly, our services and our policies are applied by experts trained in applying those policies, working with global experts, both internal and external, in the different areas, whether it is in misinformation or extremism, bullying or other. And the overall objective is to ensure that Australians and users of all of our platforms are preserved from harm, while they are able to access the most diverse sources of information that are possible.
Okay, you talk about harm. Now, one of your policies here is content. You ban content that recommends the use of ivermectin and hydroxychloroquine for the prevention of COVID. Now, there are medical protocols published in peer-reviewed literature that recommends ivermectin and hydroxychloroquine for the prevention of COVID. So aren't you causing harm by denying people having access to that information?
No, Mr. Kelly.
You don't think so? So you think it's quite acceptable for people with no medical qualifications to ban and censor and deplatform medical experts and professionals that have an alternate opinion, as you said, diversity of opinion in a democracy, to use your words? You think that's acceptable?
Mr. Kelly, our policies are devised in close consultation and deference to experts in the different fields in which they apply, and they are applied and enforced again and revised in close consultation with those experts.
Okay. Well, what about if these experts that you have are wrong? Who determines, who checks your fact checkers?
We do, as I mentioned earlier, work with fact-checking organisations and give significant resources and support to fact-checking organisations, both in Australia and globally, to ensure that there is accountability and to ensure that that the information we provide to users is up to date, trustworthy, and has integrity.
Okay. Also, does Google or any of its subsidiaries have any direct financial interests or indirect financial interests in the COVID vaccine manufacturers?
I have no knowledge of that, Mr. Kelly.
Is that a question you could take on notice?
I'd be happy to take that on notice.
Thank you. Thank you, Chair.
Thank you, Mr. Kelly. I believe Ms. Hammond has some questions, and I'd just like to thank our witnesses for your time and your willingness to give us additional time as well. Ms. Hammond?
Thank you very much, Chair. Thank you very much both for your submission and for coming in today. I'm aware of time and the detail of the questions I'm asking, so I might ask for these to be placed on notice. The Secretariat will follow up and give these to you. You've mentioned that there's 2,000 staff in Australia. I would like the proportion of that in EFT terms, equivalent full-time, as opposed to whether they're just bodies, and how many of them work in the safety and the safety team, and I guess the qualifications and criteria behind them. You've also mentioned that there are 20,000 people worldwide working in your safety team. Again, I'd like that information in terms of equivalent full-time, also as a comparison and measure rate against how many work in the advertising, the marketing, the systems development. I mean, they can be globalised, but as a percentage of your entire workforce, again, with their training and with their the inherent requirements, I guess, of their job. And the final, I guess, two additional questions to that. In terms of executive level management contracts, no details. I don't believe that this would be private, but you will obviously take that on board and give us a response. KPIs in executive management contracts as to whether they are linked to, are there any references to online safety security of the platforms you provide. And finally, and this may be publicly available, but I'm not sure, but again, if it is publicly available, you can send that back through to us. There's the proactive schemes that you run to monitor safety and security of your platforms. We're all familiar with companies having to undertake audits and having internal audit teams for financial purposes. Do you have security and safety and audit teams to monitor all of those policies that you talk about? Do you have internal audit teams or even independently sourced audit teams to check whether those policies and processes are working? And how often do you do it and how much do you invest in that? As I say, that's a lot of questions there, and I'm happy to put them on notice. Thank you.
Thank you very much, Ms. Hammond. I can be happy to commit to follow up for all your questions.
Thank you.
Thank you, Ms. Longcraft. I might add some questions on notice to that, and just given they're in the same theme, I'll also ask that in the same table or the same manner and context that you also identify how many staff members, FTE members in Australia that you have who are wholly, completely, their whole job is devoted to keeping women and children safe online, and also as a percentage of the overall staff numbers in Australia, please. And also your response to a survey where 30% of women who were surveyed it had indicated they experienced online abuse or harassment. 42% of women who had experienced online abuse said it was sexist or misogynist in nature. 20% said it included threats of physical or sexual violence, and just a specific and detailed approach to how you address those concerns with individuals, community groups and public figures. Can I thank our witnesses for attending and for your time today? We do appreciate it, particularly at short notice. We also appreciate your willingness to take on notice a number of questions. And I am just providing you a formal set of words to indicate that for additional information, including responses to the questions on notice, to please forward it through to the Secretariat by the 3rd of February 2022. And I'd also like to advise that you will be sent a copy of the transcript of your evidence, and you will have an opportunity to request corrections to transcription errors. I thank you again for attending today, and I'm now going to suspend this public hearing for just a minute or so to allow our next witnesses to attend. Okay, I will resume the public hearing now, and I now welcome representatives of Meta Platforms Incorporated to give evidence today, and ask that for the Hansard record for you to please state your full names and the capacities in which you appear before the committee.
Thank you, Chair. My name is Mia Garlick and I'm the Regional Director for Policy across Australia, New Zealand and the Pacific Islands.
And thank you, Chair and Committee. My name's Josh Machin. I'm Meta's Head of Public Policy in Australia.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'd like to thank you for your detailed submission that you have made in advance to the committee and which is available on the committee's website, and indicate that we do have a number of questions from the committee, and unless otherwise indicated, we would very much like to proceed directly to questions, if that is okay with you. Thank you.
Of course.
Thank you very much. Questions from the Deputy Chair.
Thank you, Chair. And thank you to the witnesses for appearing here today, and thanks for your engagement on these issues in the past. Can I start by asking some broad questions about where we are before getting into some specific issues that I want to explore? So as I read your extensive submission to the committee, I was struck by something of a disconnect, because you outline at great length all of the things that Facebook is doing to address potential harm on your platforms. And as your submission tells it, your newsfeed algorithms and your groups don't polarize people. You're removing more harmful content on the platform year on year, and you're more transparent than ever. But in recent times, we've seen a slew of former Facebook employees coming forward with often very hard critiques of the internal culture of the company, and often backed by substantial cases of leaked internal documents that tell a different story about how the company works. So how do you reconcile this? And should the committee believe the official line or the growing number of critiques from former employees like Frances Haugen and Alex Stamos?
Thanks. Thank you, Deputy Chair. I think, there has been a large amount of sort of public commentary and leaked documents, and the sort of the overarching sort of argument or claim that these are all built up to support is that we put profits before safety. And I want to reassure the committee that this is categorically not true. Safety is at the core of our business. And if people do not have a positive experience, if they do not find our services useful, then they will not continue to use them. And that is why we have been steadily increasing our investment in safety. I think in 2021, we spent over $5 billion in online safety. And we're steadily iterating on our investment in proactive detection technology, in new tools and in new partnerships and resources, so that we can continue to ensure that people have a positive experience and continue to want to use our services. Okay.
Well, a number of submissions to this committee have suggested that government and regulators need to move beyond regulatory models that focus on moderation of individual pieces of content and look at broader systemic interventions seeking to address harms caused by social media platforms. In this context, I want to ask you about what content moderation expert Evelyn Dweck has called the toxic content dial at Facebook. What she's talking about here are in the break glass measures that Facebook takes in emergency situations to, as Monica Bickett, the Facebook VP for Content Policy, puts it, quote, limit the spread of content that our systems predict is likely to violate our community standards in the areas of hate speech, graphic violence, and violence and incitement. These break glass measures have been, Facebook has said that they've used them around the 2020 US presidential election, contentious legal proceedings in the US, and other high-risk contexts. As Mr. Weck puts it, quote, when Facebook detects heightened social tension, it puts in place policies to promote authoritative information and add, quote, friction so that the content on the site moves more slowly and more calmly than usual. These kinds of decisions about what platforms choose to amplify or to add friction to are the most important in content moderation. So my question is that if there is a toxicity dial like this inside Facebook that you can use in emergency situations, why don't you choose to dial it down permanently? Why not turn down the dial on hate speech and incitement to violence and this kinds of harmful content on a permanent basis?
So I'm happy to open with that and then throw to my colleague Josh to share more details. I mean, I think over the years we have been steadily increasing our proactive detection of harmful content like hate speech. And certainly what we've been seeking to do through our Community Standards Enforcement Report is develop new metrics to try to get a sense of what we can, whether we can measure the success of our investments. And so obviously we've got the proactive detection technology rate that we are disclosing through our Community Standards Enforcement Report, but also very importantly, we've got the idea of prevalence. So prevalence is the amount of time that harmful content is seen. And, with hate speech in particular, for example, as, we've had improvements in the artificial intelligence, both through the use of classifiers and the ability of artificial intelligence to not just look at simple objects, but also complex objects, we have been able to decrease the prevalence of hate speech over the period that we have been reporting. So I think when we first started disclosing prevalence on hate speech, back in 2018, it was around 0.10%, and now it's down to 0.03% in terms of prevalence. So it's certainly something that we're continuing to work on. And Josh, I'm not sure if you wanted to add anything on that.
That's right, Mia. I'd make one additional point in relation to your question, Deputy Chair, which is there's been a lot of progress in the ability of technology to detect harmful content, but it's not perfect. There's a long way to go. And certainly there are plenty of instances where technology might miss content, but also instances where it may over-enforce or it may remove material which is not violating our community standards because it's incorrectly understood what it's applying. And so as well as having technology that can detect as much harmful content as possible, we obviously want technology that's also precise and that minimises the number of appeals that people need to go to, because that can also be a very disruptive process. If someone's post is removed incorrectly and they need to appeal it and go through the systems and processes associated with that, that can be a challenging experience as well. So although I just wanted to make the point that although technology's made incredible progress, certainly not a silver bullet. We can't dial it up in order to be more effective. We're continually working and investing in the technology to improve its efficacy, both in what it's detecting, but also its precision. But I just want to sound a note about its limitations as well.
Sure, but my question's not about content moderation of taking down of individual pieces. It's that from the public record, it seems that there is a dial that Facebook can turn in the way that its newsfeed algorithm operates to add friction to divisive, harmful content at times of social tension. And I'm just asking, that sounds great. Why can't we have that all the time?
Yeah, maybe I can add a little bit of additional information to what that refers to. So we have our community standards which outline what we remove, and those remain consistent all the time. There's no change to the types of material that we'll remove even in particular times of heightened social tension. But what those references relate to is particularly how our ranking algorithms operate in relation to Facebook newsfeed and about in Instagram feed. And this is an area in which there's been a lot of pretty innovative, interesting work happening, particularly over the last 12 months in this space. We've released, in addition to our community standards, which talk about what we remove, we've released content distribution guidelines, which talk about the steps that we take to lower the ranking of particular types of content. that's been a tremendous evolution of where we've been in the last couple of years. And I think you'll know pretty well from the types of academics that you're citing that this dichotomy of thinking not just about whether content should be taken up or removed, but for borderline content, what additional steps can you take in order to limit its distribution and what categories should fit in there is really an area of ongoing debate and focus. So there's a lot of work that we've done in that space in the last 12 months, but there's a lot more to go. And so it's an area where I think you'll continue to see work from us about the types of categories of content that might fall in there, the types of tools that might be available to users to give them more control over whether they would like to see more content from their friends and family, for example, rather than from public pages, which they may find to be more meaningful. So it is an area of continued focus and progress.
So I understand what we're talking about here. I'm asking why we can't have it all the time. But let me give you a specific example of the way that this kind of editorial discretion in the way your newsfeed algorithm operates is exercised inside Facebook. I want to take you to a specific account from Shira Frenkel and Cecilia Kang's recent book on the inner workings of Facebook that described the effects of turning this dial in the wake of the 2020 US presidential election via a series of, quote, break glass emergency measures. And this is the quote that I'll just read to you before I get a response. These included an emergency change to the newsfeed algorithm, which would put more emphasis on the, quote, news ecosystem quality scores, or NEQs. This was a secret internal ranking Facebook assigned to news publishers based on signals about the quality of their journalism. On the one side of the spectrum were outlets Facebook ranked as most trustworthy, such as the New York Times and the Wall Street Journal. On the others, outlets such as the Daily Caller, which had repeatedly been cited by Facebook's fact checkers for publishing false and misleading stories. Under the change, Facebook would tweak its algorithm so people saw more content from the higher scoring news outlets than from those that promoted false news or conspiracies about election results. Zuckerberg approved the change. For 5 days after the vote, Facebook felt like a calmer, less divisive space. Quote, we started calling it the nicer newsfeed, said one member of the election team. Quote, it was this brief glimpse of what Facebook could be. Several people on the team asked whether the nice newsfeed could be made permanent, end quote. So my question is, why can't we have a permanent nicer newsfeed in Australia?
So I don't want to, comment on allegations and claims that sort of by former employees, but I do want to reassure the committee that when it comes to how our newsfeed operates, and in particular, I mean, as we make ranking changes, particularly in relation to publishers, we have worked to be very transparent about what some of those criteria are. And that includes, for example, whether a particular page, complies with our community standards, whether it is part of our news publisher index and a range of other integrity measures. And so this is a very consistent approach that we have in relation to the quality of the content that does get served through the newsfeed algorithm.
So,
could I add one additional point, perhaps to clarify my answer from earlier? Maybe I didn't explain it very well, but I think the direction that we're heading is that we believe that people should be given more control over how algorithms work, that it shouldn't be a decision that we're making. We want to be transparent about the steps that we're taking that feed into how our ranking algorithms work. But we also want to give individual users greater tools and control so they can customize their newsfeed to look more like what they would like to see. If they want a newsfeed that doesn't include any politics, for example, because they only want to engage with family and friends, then they should have those tools available. If they're a political junkie, like I am and other people on the committee, maybe they want a newsfeed that's entirely politics. And so giving users that agency and additional level of control is the direction that we're heading in relation to newsfeed. So people can customize it in order, if they want a nicer experience, then they have the tools in order to do that.
Well, we'll come to the merits of that. But just on this specific issue, Frenkel and Kang report that this nicer newsfeed was ultimately abandoned for fear of perceptions of political bias and because of concern that it had, quote, led to a decrease in sessions. Users were spending less time on the platform. Now, many former Facebook employees who have spoken out against the company have told similar stories about business functions, product teams, and government relations teams and lobbying functions trumping the recommendations of those working on integrity issues. Why is this such a common complaint of those who have left Facebook?
Well, I think the important thing to note is that with respect to the integrity teams, those have been rolled out across the company. And so it's actually, steadily over the years been baked into every single thing that we do. And I do want to challenge the notion that newsfeed is there to, keep people scrolling through, because certainly, we have made adjustments and changes and been transparent about those in relation to newsfeed to enhance people's meaningful interactions and to ensure that the most relevant content is at the top. We recognise, though, that a lot of people have a lot of questions about how our ranking algorithms work, and that's why we've released the content distribution guidelines to increase the transparency around what is happening in the newsfeed algorithm. But certainly some of the ranking changes that we have made in the past that are designed they have caused people to spend less time on the platform. But for us, so long as the time that people are spending is relevant, useful and intentional, then that is the longer term business interest that we have, is ensuring that people have a positive experience on the platform.
And so your submission outlines 5 values that guide how Facebook makes decisions about the way its newsfeed algorithm operates. So that's friends and family come first, a platform for all ideas, authentic communications, you control your experience, and constant iteration. Can I ask, why aren't there any values that deal with the societal impact of your product, about its impact on democracy, on social cohesion? Why are those missing there? I mean, do you recognise that there is a broader obligation that a product, a service of your scale, of your influence has to our democratic institutions and our social cohesion?
Certainly, I mean, those are sort of the principles that govern newsfeed, but I think there's also a series of principles around the integrity measures that get applied to newsfeed. So to reduce and limit engagement bait, scams, spam, misinformation. And so, as we're thinking about how the algorithm works, obviously people choose who to friend or what pages to follow or groups to join. And then, we're looking at a range of different signals as to how that is ranked. But before that sort of ranking process runs, there's also an integrity process, which I think is speaking to a lot of the concerns that you're raising. And I think that's also why, we're providing that transparency on a granular level to let people know why they're seeing a particular post, and why we're seeking to increase our transparency around what the factors are that go into the algorithm.
Okay. So I hear these assurances that Facebook takes safety and integrity issues seriously, and that you're proactively working to improve it. And there are many examples of that in your submission and the evidence that you've given today. But sitting where I'm sitting, if we wind back the clock, and as I say, we've been having this discussion for many years, I have to say Facebook's actions do not seem to bear this out from my perspective. Facebook's been very slow to act on the major issues that we've confronted that have a broader societal impact over my time in Parliament. And I just want to give a few specific ones. So a 2018 study from Victoria University in my electorate identified extremist, anti-Islam, anti-Muslim narratives to be prevalent on Facebook throughout that year. But despite them engaging with you, and despite growing evidence of the radicalising effect of hate speech and hate groups on social media platforms, it wasn't until 2 weeks after the Christchurch massacre in 2019 that Facebook banned praise, support and representation of white nationalism and white separatism on the platform. The QAnon conspiracy group wasn't banned on Facebook until more than a year after the FBI labelled it a domestic terrorist threat, despite the platform, Facebook, being key to its growth and connecting millions of followers to the cause. And while Facebook did implement the nicer newsfeed in the lead up to the US presidential election, the relaxation of these measures and the failure to stop the steal narrative from gaining momentum did play a key role in enabling the participants of the January 6th insurrection to organise their attack. And in fact, the Facebook Oversight Board's call for Facebook to engage in an open reflection on its role in that attack hasn't been discharged yet. So given this record, I can see how much you're doing in this space, but convince me that I should believe you that the culture is going to cause you to act proactively to stop the next thing happening. I mean, why aren't we going to see a January 6th insurrection style attack in Australia that you don't step in to stop?
Thanks, Deputy Chair. I think there's sort of a number of things to unpack in that. So I might start off with some baselines, and then obviously Mr. Machin can add any additional factors. I mean, I think in respect to the ban around white supremacy, even before that sort of broader ban, and you know, we have made that ban and removed over 200 different groups. There were specific individuals here in Australia and organisations that had already been banned just more generally under our dangerous organisations policy. And so, you know, that work was sort of underway before the broader ban. And obviously, you know, in the lead up to all elections, we have cross-functional teams that are alive to the different risks and issues and concerns. And we work very closely with the relevant government agencies to make sure that we're being responsive to their questions and concerns, and that we're all talking about the same issues and concerns and respecting applicable law. Josh, I'm not sure if there was anything else you wanted to add, because that was quite a lengthy question.
I just go particularly to your point, Deputy Chair, about what about the next issue that comes up? What steps do we take in order to identify issues as they emerge? And particularly domestically in Australia, there's been a lot of progress, I'd say particularly over the last 12 months in some of the areas that you'd identified. Things like we've established an advisory group on combating online hate and funding research, particularly in the area, and some of the priorities that have been identified by our work with those and other stakeholders who are concerned about that particular issue around electoral integrity and the risk of foreign interference or violence around the election. We've been closely in touch with key security agencies and departments within the government about potential risks or threats that could arise in the context of the upcoming election for months now, perhaps well over 6 months, I would suggest. And we continue to build really close relationships with online safety partners within Australia, particularly to hear about the experience that young people, parents, other safety experts in the community have. And so I think the important thing is, particularly locally, to make sure we have those relationships with not non-government experts, government agencies, security agencies and law enforcement, and also I think policymakers like yourselves who are very well tapped into what you're seeing in your communities, to make sure that we are continuing to take that feedback and to act. And so we can certainly give you other examples of steps that we've taken very quickly in response to feedback that we've received from those groups. But in terms of your question of are we putting in place the systems in order to be getting feedback in order to pick up issues as soon as they arise, there's been a lot of work in progress on that front.
All right, well, let's use a specific example that this committee has heard from in evidence from witnesses today. The committee's previously heard evidence from Ms. Rita Jabri-Markwell of the Australian Muslim Advocacy Network. She's a member of the Global Internet Forum to Counter Terrorism's Legal Frameworks Working Group. And last year, she published research with AMAN about the effects of dehumanising minorities on Facebook. Ms. Jabri-Markwell told this committee about a specific issue that AMAN's been dealing with, that, quote, the group had successfully brought a vilification action for Senator Fraser Anning under the Queensland Anti-Discrimination Act. He had spread the demographic invasion conspiracy theory, also spouted by terrorists, the Christchurch terrorist and Anders Breivik. The tribunal ordered the removal of 141 hate artefacts, and while this seemed like a great win, getting Facebook, which is now known as Meta, to cooperate by removing the offending accounts was unsuccessful. Despite 80 breaches of the Queensland law, Facebook did not see these as breaching their policies to the extent that removal of these accounts was required. It was also an exhausting process that took 18 months. Today, Fraser Anning's pages continue on Facebook. He divides his time between spreading hatred about Muslims and asylum seekers and spreading COVID misinformation. So why did Facebook not respond to AMAN's requests on that specific issue? Can you respond to your engagement with that organisation? There's quite emotional evidence that was heard by Ms. Jabri-Markwell in that hearing. Markwell.
Yeah, absolutely. I mean, I think we've been increasing, as I mentioned at the start, our enforcement and our proactive protection of hate speech, so that we can reduce the burden on community groups to have to bear the emotional burden that we heard in the testimony of having to report this type of content to us. And also we've been working to be responsive, of course, to applicable laws and court decisions. So I think, Josh, you were sort of leading on a lot of the engagement on that. So if you want to talk about the work that we did to comply and respect to that decision.
I'll add a couple of additional points, Deputy Chair, because we're very conscious of the hate that Muslim Australians can face, Islamophobic comments online and offline, and it's an area we've been doing a significant amount of work. But one thing I would add is it's probably worth noting we have engaged pretty concertedly with the Australian Muslim Advocacy Network, and they made a very good point about a gap in relation to our policies, in that we allow people to criticise concepts, so that includes movements, political parties, and also includes religion, even though we recognise that can be quite uncomfortable, particularly when it relates to people's deeply held beliefs. That organisation pointed out to us that there are examples of hate speech where a religion or commentary about a religion is used as a proxy to be hateful towards adherents of that religion. And so we took the feedback from that organisation, spoke with a range of other experts in the area of hate speech in Australia and globally, and effected a global change to our community standards and our policies in response to that feedback that had been provided. And so I did just want to give the committee assurance that when presented with feedback such as this, we have acted in relation to those particular posts relating to Mr. Anning's account. Every one of those posts is unavailable on our platform. If they violated it, we reviewed them. If they violated our community standards, we took them down. And if there were posts that didn't violate our community standards, out of respect for the decision made by the Queensland Tribunal, we've restricted access to them within Australia. So we've been responsive to every example of content, suggestions about our policies. We continue to want to engage closely with the Australian Muslim Advocacy Network and other members of the Muslim community, other groups who can experience hate speech. I think there's more work to do. We also want to help to address some of the root causes of hate that happen in our community as well by working on counter-speech initiatives, supporting their work in order to address the actual root cause, because of course addressing the content on our platform is part of the solution, an important part. But we also want to work with them in order to minimise this type of hate occurring in the community at all. So just to give you that assurance that we continue to take that feedback and act on it.
Yeah, I'll just ask one question before handing to the chair. And just to confirm, you said then that the account is still operative. You've taken down these posts, but the account is still operative.
I think that's correct.
Yeah,
yes.
Okay. So would it assist Facebook in dealing with issues like this for the Safety Commissioner's powers under the Online Safety Act to be connected to state anti-discrimination regimes, as some witnesses have proposed to this committee?
Well, certainly we would be very open. In fact, we'd encourage Australian policymakers to look at what can be done in relation to hate speech, online and offline. I think state-based discrimination laws are obviously intended to provide remedies for particular individuals who can show some disadvantage that they've received on the basis of that discrimination. And I think the difficulty with hate speech is it's not always targeted at individuals, and the ability to draw a connection with damages isn't always particularly clear either. Similarly, with many of the online safety powers, perhaps they may be easier to apply when they are targeting an individual than when it's a commentary about an overall group. And so this is an area in which we can see a gap. We're very happy to work with Australian policymakers on it. We do think it's an area in which we'd suggest the committee should focus on.
Great, thank you. I have more questions, but we will. The chair is definitely managing the flow of this committee, so I will cede to the chair.
Thank you, Deputy Chair. Questions from Ms Hammond, and then I'll jump in.
Thank you very much. I just want to pick up on something the Deputy Chair was just asking then, and I may have misinterpreted your answer, but you said that something was taken down because it breaches your community standards and out of respect for Australia, for an Australian court decision. Now, can I just get a bit more clarity on that? How do you develop your community standards? And surely you must comply with laws in all different countries. It's not a question of respect. Surely it's a question of complying with laws in various different countries.
I'm happy to begin on that one, and then Mia can pick it up. So the way that we develop our community standards standards is by working with experts in areas like human rights, free speech, and particular subject matters in order to set the rules for what we do and don't allow on our platform. And so in many cases, that's going to go well beyond what's the case in relation to local laws. But in some instances, it won't. And particularly, the thing that we need to be very cognizant about is we set consistent global standards that apply across all of our users all around the world. And so there are some countries, authoritarian regimes in particular, where we may have reservations about what some of those local law requirements are, particularly where there may be inconsistency with internationally accepted human rights norms. And so in Australia, it would be an incredibly difficult task to create a set of community standards that could incorporate all of the possible legal requirements in every jurisdiction. And so our community standards set the baseline, the standard of what we do and don't allow. But in instances in a jurisdiction like Australia, where there may be a piece of content that isn't covered by our community standards, and there can be some that would be quite unexpected. There can be comments about biosecurity or about academic, what are they called, like cheating services, I guess, that can violate particular aspects of state or territory law. And so the way that we work in relation to those is we build relationships with regulators at all levels of government who are able to refer content to us. And if we do see something where there's a gap, Australian law does go beyond the global policies that we have, that's when we take action to restrict access to it within Australia.
And Ms. Hammond, I might just build on that and say we do, as part of our Transparency Centre, we do have disclosure about where we have restricted access to content, where it has violated a particular court decision or Australian law and it didn't violate our global policies. And I think when you go through that, you can see that there are some quite unique use cases that are not covered in our global policies, but obviously we're wanting to respect Australian law and Australian standards and restrict access to it, but also provide transparency so people are aware of that.
Well, I would have thought that it's not a question of wanting to respect Australian law, and I think there would be a lot in Australia who, we do have a healthy democracy and we do have a free and open election system. I think there would be a lot of people in Australia who would say, well, you may be an international company, but when you're operating in Australia, you must comply with Australian laws. We do. All other international companies do. So how proactive are you in actually, do you have a team, not who responds to if it's raised with you, do you have a team that proactively seeks to ensure that the platform that you set up is compliant with Australian law? And I'm an elected representative for the people in my part of the world in Australia. I'm only interested in Australia. Do you proactively seek to ensure that your platform complies with all Australian laws?
Absolutely, Ms. Hammond. I mean, obviously we've got sort of an active online safety reform process underway at the moment with the new law, I think, taking effect on Sunday. And so we have teams set up to identify our compliance approach to that. Similarly, with privacy law reform, we have teams set up. So where there are very specific laws that are designed to ensure that digital platforms are meeting Australian standards, absolutely, we have compliance teams that are looking at that. I guess what we were talking about is where it's, I think Josh used the example of the sale of cheating services. That one we may not necessarily have a compliance team set up to proactively address that, and that's where, when the issue gets raised with us by a regulator, that's when we can work on ensuring compliance, because there are a very diverse range of different laws, particularly at the state and territory level.
So that's a reactive approach rather than proactive.
Some of the smaller state and territory laws, it does tend to, we need to build a relationship with the different stakeholders so that we can ensure that we're being respectful of that. But where it's the bigger laws that are, designed to ensure that we are giving the Australian policymakers assurance about our respect for those laws, of course, we will have compliance.
Because I imagine that with some of those state and territory laws, if you aren't in compliance with them, there's no repercussions to you, are there?
I might have to take that one on notice. I mean, I think there's a diversity of different laws where there are repercussions for us. I mean, certainly with suppression orders, etc., there are different repercussions, and there are other court orders as well where I think there probably would be repercussions, but I'm happy to come back to you on notice if that's helpful.
Thank you.
Could I also, Ms. Hammond, perhaps make one comment, particularly in relation to online safety, but obviously knowing it's a key concern of yours and the committee, that in many instances, it may be in some ways a question that's obviated by our community standards setting a bar that goes far beyond local law. And so obviously we proactively invest in artificial intelligence to detect any content that violates our community standards. And so because we do go beyond what the law requires, there's significant amounts of work that we're doing, not just to meet legal obligations, but also to go beyond and take an approach that we think is the best one in order to ensure a safe environment for our users. So I just thought, particularly in response to online safety related concerns, that might be an important issue.
I think some of my colleagues, if they ask questions, may actually pick up on that point. I see, I mean, it is a tricky position, but there would be some that would say that in going beyond what the local laws of an area require, you are in fact setting your own legal system, if you like. So it may well be that something's been discussed and debated in an Australian Parliament and voted against, but if it then appears that that forms into your local laws, you are in fact in that way superseding local legislature and the local legal system. And I get it's difficult. You operate in an international environment, but these are issues that I think people do raise about the influence of your platform. Now, just on that, we heard evidence earlier this week from somebody who some vile commentary was made on Facebook, and they submitted a request for it to be removed, and they got an automated response saying, no, it doesn't breach. And then to take anything further was just too difficult. How do you respond to that? Your complaints process, if something is posted about somebody on, so it's not their Facebook site, it might be on another publicly accessible Facebook site, and they approach you, what is it, just an automated, is the first level just an AI generated yes, no? How does it work?
Sure, I'm happy to start on the answer to that, and then we can maybe get into specifics of that particular situation. So we use a mixture of human review and automation. So I think we've talked a bit about some of our proactive detection technology, and we also use classifiers to, when we get user reports in, to send them to the right team, and particularly if it's in relation to bullying or harassments or threats to safety, we try to triage those and prioritise those. If it's, you know, a fake page for, you know, something that is not going to necessarily cause emotional distress, then, you know, that might, we might get to that slightly later than things that will cause emotional distress or threats to physical safety. And then the team will review that, and then we can, we will send a notice to people, and then there is the option for them to appeal it. I'm not sure, I think the testimony that you might have been referring to was the testimony of Ms. Molan, and I want to reassure you that the types of threats that she received absolutely violate our policies, and it's absolutely distressing to hear of her experience. And also, you know, unfortunately, it is very common for women in public life to receive those types of threats. You know, we're regularly talking to female journalists as well who are receiving that type of comments. And, you know, as soon as we became aware of that issue, we did remove the account of the person who had made it, although, you know, they had deleted some of the comments, and then there had been blocking of that account as well. So I think some of the tools that we have had been used, but obviously we took further action because of the vile nature of that commentary.
Did you take further action after it became public knowledge, or as a result of her initial complaint?
Yeah, unfortunately, we haven't been able to locate that original complaint, and so you know, I think a police report was made, and we worked through that process to make sure that we were taking appropriate action.
Did you want to add to that answer? Sorry, my light just went. Mr. Mackin, did you want to add to that answer?
I think Mia's provided all the information that I would, but I'm happy to provide more information if you have more questions on that.
Okay, my final question, because I'm aware that there's lots of people wanting to ask questions. My final question is the threshold for accounts is set at the age of 13. That's across a lot of these platforms. You're not alone there. Why is the age of 13 deemed to be the age at which somebody can make a responsible decision?
Yes, I think that is a feature of US law in relation to the, I might get the title wrong, I apologise, but it's the Child Online Privacy Protection Act, or the Deputy Chair probably knows the title and can confirm or correct the record, or I can in the transcript. But that is, I think, why so many of the US provided platforms and services have that as the threshold. But we have a number of things that we do to try to make sure that even from, say, 13 to 18, that we're providing additional protections for the teen accounts as well, recognising that, that young people using our services, while they find it tremendously beneficial to be able to connect with friends and family and participate in community groups and things like that, that they are given additional protections because they are at a slightly more vulnerable state.
Okay, thank you. Thank you, Chair. Thank you.
Thanks, Ms Hammond, and to our witnesses, I'd like to thank you for your time and just ask that with your indulgence we continue for a period of probably 15 minutes to half an hour, just depending on the nature of questions, because there are a number, and I do thank you very much for your agreement. Mr Makin, is that okay, Ms Garlick? Thank you very, very much. I'm not sure where to start. It's been a very important conversation, and I do want to thank you for your responses and for your willingness to be here. I think I'll start with an experience I had that ended up being a positive one, of having to resolve something myself that occurred on Facebook a couple of years ago, and I thank both of you for your assistance, but which as a result made me a lot more alert to some of the challenges that the ordinary person might face when dealing with challenges online. I come first to just as by way of example, because this probably highlights the question I'm asking in relation to what I see might be a problem. I know that there was a particular local business in my electorate. They were being impersonated, and their business was being impersonated, and many people, their response, many people, they tried over and over to have this impersonated account removed. And so what they then did was issue a plea to their Facebook followers, please also report this particular impersonating page so that we can actually try and get it blocked. And when I saw that, obviously with some assistance, that was able to be removed. But it did strike me, when somebody reports something in, say, for example, impersonation, and it could be an impersonation of an individual or a business or a community organisation, misrepresentation, we talked about disinformation. When somebody or an entity, organisation or individual reports something, is it dealt with the first time, or does it require multiple instances to get through your automated system to sort of get attention? Does that make sense? How do you sort of raise your flag to say, how does somebody easily raise their flag to say, I need help? Because it's a global entity. Facebook is a global entity.
Yeah, that's a great question, Chair. Thanks very much for mentioning it. And of course, we're very appreciative to you and to all other members of Parliament who help connect us with constituents of yours who may be having difficulties on our platform. We really appreciate it when you're able to do that, and always do our best to assist. Perhaps I'll mention, I think our reporting processes will vary a little bit depending on the type of content that is being reported. So, for example, a piece of content that's being reported because it is a pro-terrorist piece of content, we'll make sure that we have expedited processes in place because of the risk of real-world harm that might arise from a particular piece of content than compared to bullying and harassment. Not to suggest that bullying and harassment is not important, but the imminence and potential harm that can arise from some severe types of content necessitate us prioritising them. And as Mia said, across all of those types of content, we use a combination of technology and human review. So there are limits to what technology is able to identify and to work out themselves. But similarly, I guess I would point out that it's not always better to have a human to review a particular piece of content. If you take something as severe as, say, child sexual exploitation content, we're very conscious of the health and safety of our review team. And in fact, we don't want humans to be looking at that type of content. That's part of the reason we've invested so much in technology, so it can detect that type of material itself and take action without necessarily needing a human to review it, because of the potential harm that can come to that individual person as well. And so I think depending on the prioritization, depending on the particular type of content, it can receive a different priority. But I think one of the most important things that we can do in order to make sure that people are able to raise issues with us is to make sure that we've got very close relationships with local organisations and individuals who can bring things to our attention. So there's a lot of potential regulators or departments that people may now go to if they have concern about something, not just the increased powers for the eSafety Commissioner, which we very much welcome, but we have a really effective Small Business Commissioner who people might go to. We have really great state and territory consumer protection agencies. As I mentioned earlier, people may go to their Member of Parliament, they may go to a safety NGO. And so the approach that we try to take is to have a no closed door with all of our local partners, so people can report through the platform or via our contacts.
Yeah, thank you, Mr. Makin, and I understand that and respect that. A couple of things, though. Trying to get to that open door, I think, is the first point. But sometimes that is a very hard thing to do, and some of the entities that you mentioned, people use that as a mechanism of last resort when they've actually tried to make contact and they actually can't get through. I guess part of my question is, do you think there might be a simpler way for direct intervention or access or response to concerns raised by members of the public, by individuals? That I would hope that it wouldn't take a member of Parliament to raise it, but that, Mrs. Smith down the road can actually simply say, hey, this is an issue, and doesn't have to start an online campaign to say, let's get lots and lots of people reporting this to Facebook to somehow get the system to look at it. I understand that you're a global entity that creates challenges of its own right, but you have individual users, and each of those individual users, I think, Ms. Garlick, you emphasised the importance of online safety, which I guess we would all see as incredibly fundamental. When you say online safety, what does that mean to you? Is that simply in terms of establishing criteria that meets the technical aspects of existing law, or is that looking from an end user perspective to say, how do we ensure that all end users are safe?
Thank you, Chair. I also wanted to just answer sort of one of the first parts of your question around whether multiple people reporting a post gets it higher up in our review queue. And I do want to just clarify for the record that that is not how the system works. One report is sufficient, and actually mass reporting doesn't sort of change where things are. So I agree with you that there is more that we can be doing, and we've certainly been trying to, through our Boost program for small businesses, make sure that we're regularly engaging with local chambers of commerce and small business communities. Obviously, some of this has been slightly thwarted due to the pandemic, but we're looking forward to getting on the road again and going out and making sure that we're understanding issues and concerns. And we certainly have a range of different business sort of resource centres where we try to help small business owners understand if and how they can troubleshoot things themselves. But I think more broadly to your question around online safety, I mean, sort of the overarching principle, of course, is, do people feel, we have our values that underline our community standards, which are around, sort of freedom of expression, dignity, safety, etc., privacy. and integrity, but then there's also the practical manifestation of that, and that relates to, you know, bullying and harassment, that relates to additional protections for public figures, things like that, where we try to look at the different use cases where people might feel intimidated or not feel safe using our services, and then what is the best solution in terms of policies, tools, enforcement, resources and partnerships.
So let me just go to that. And Mr. Mankin, I think you indicated that the community standards are applied consistently at all times. I think I heard that. Is that correct from a response earlier to the Deputy Chair?
I think in
as well?
Ms. Hammond's question, I was making the point that they're applied globally. In the same way, we have consistent global standards.
Yeah, thank you. Okay. Because I have a number of posts as per a conversation with an earlier witness of posts that have been put up, and yet I think the Deputy Chair talked about a toxic content dial. I think, you know, you've referred to some algorithms being able to sort of effectively remove certain things. I'll just have a look at some of the examples of some language that have been used. And I'm just wondering if you could indicate whether they breach your community standards policy. One is a 4-letter word beginning with C.
Do you want to read them all out, or do you want me to answer individually? What's the most helpful? And also, by the way, you know, we're happy to take this on notice and come back.
Yeah, sure. Dumb, B-I-T-C-H. You could also add whiny or whining like a. A putrid little mutt. Another one, I wouldn't call you a whiny little B-I-T-C-H. That would imply some degree of intelligence and good breeding. You're a maggot. Another one, she comes across as a bit of a dominatrix. I can imagine a few of them begging to whip her because they're naughty boys. Another one, and I'll give you a personal example. Whore deserves to have sliced open with a chainsaw. I'm not advocating violence, but if any of these people were set on fire, I won't insert that word, set on fire, I'd toast marshmallows in the flame. None of these were removed with any degree of algorithm. And in fact, in relation to the last one, and I did not choose to read out the worst of the language, I took that to the AFP to have that removed. I'm just wondering if you could comment further in relation to those very real examples of how your community standards, community standards reflect those of what I would have thought were Australian community standards when it comes to abuse and online abuse, and also when it comes to your reflection of the importance of online safety.
Absolutely, Chair. And I think these are very important issues, and I maybe can share a little bit of sort of the progression of our community standards over time, because I think, you know, in the early days, we certainly made distinctions between private individuals and public figures. And, you know, where private individuals were reporting content as bullying and harassment, we would sort of err on the side of assuming that there was something going on that we didn't understand it if it was not on its face bullying and harassment, and err on the side of removing. And in the early days, certainly allowed a wider array of content to be discussed in relation to public figures. But I think, sadly, we've seen over the last couple of years that, you know, the nature of commentary, particularly about female public figures, has just become incredibly abusive and quite sexualized. And so over the last couple of years, we've made a number of changes to our policies, particularly in relation to public figures, to try to remove gendered abuse and sexualized commentary of that nature. And then we've also worked to try to provide greater tooling if we're not always getting it right, so that people can, for example, use hidden words to block certain either emojis or abusive comments in messages. They can turn off comments on a per post basis so that they don't have to bear witness to this. They can moderate these things out. So we're trying to use a mixture of updating our policies, building out our enforcement of our policies, and then also providing tooling around this as well. But it's
So if
helpful
I just come, yeah, sorry. If I just come back to what you were saying before, I guess it's a really simple question for me. In all of these instances, the algorithms did not pick this up. And if I reflect back, unless I have a direct relationship or an ability to be able to reach Facebook directly in a person, how does an ordinary individual, I'm a public figure, I have access to more means than others, but how does an ordinary individual gain access and quick reparation, if you like, to be able to remove harmful material, abusive material, dehumanising and degrading material when it appears online?
Absolutely. So all pieces of content on the service have the ability to be reported to us. There's a little drop-down arrow on the top right on most pieces of content, and that's the best way for an individual to report that content to us, and then that goes to our teams of reviewers. So I think, you know, the thing with the proactive detection technology, I think, you know, we have made progress. There's still more work to be done to continue to expand what it can achieve. And I can understand that some of that terminology does violate our policies, but we still need to improve the technology to proactively detect it. And so I'm grateful if people are able to report it to us.
So let me just go back to something, and look, I might be a little bit naive here, but what I don't understand, and it's been a question that's I've been musing over during the course of this inquiry. I often see posts on my Facebook feed where it says this content has been removed. So we were talking about policies about disinformation and misinformation, etc., where there appears to be a very proactive response, and then it must be up to, it's never happened to me, so I don't know, but it must be up to the individual or the entity that has posted that to actually prove that their information is correct and not misinformation or disinformation, I would gather, in order to have that republished. Is that how that works?
On the misinformation point, Chair, the policies that we enforce, the types of misinformation that we remove, are those claims that we consider can cause real-world harm because people
No, I
take
hear that. But, yeah, sorry, that's not my question. I'm not in any way sort of wanting to comment on that. Sorry, Mr. Macon, I'm going to interrupt to make sure I clarify and provide accuracy. I'm actually talking about, I'll finish the observation and ask you to comment then on the full observation, if that might be a better way to do it. So you have the capacity, you have the technological capacity to identify and to do that in real world time, if you like, using algorithms, your vast resources, etc. I guess my question is, what would stop you or prevent you from taking such a proactive approach to abuse online as well, where you almost flipped it and required the person writing, for example, some of those statements I've read out, to have to indicate why it was not abusive or harmful before it was republished in order to help reduce harm? That's my, does that make sense? That's my question. I can see it done in another context. Is there any reason it couldn't be done in this context?
I think it's a great question, Chair, and it's certainly something that we have been looking into. So recently on Instagram, I think it might have been last year, we started rolling out comment nudges, where if a person starts typing in a comment and that does look to us based on the sort of the algorithms that we've built up to try to proactively detect bullying and harassing content, if it starts to look like it might be like that, we say, do you really want to post this? You know, it could, be considered harassing. Click here to learn more. So this is certainly an area that we're exploring to go towards. And I think over time, I think I mentioned earlier, the machine learning technology is improving. And so I think this is something that we do want to continue to explore.
Thank you. I'm mindful of time. I have a number of questions, but I might cede to Mr. Kelly, who I know has some questions, and then if we have time as well, Mr. Sharma. Thank you.
Thank you, Madam Chair. Firstly, a disclosure, I did have a Facebook account. As is publicly known, Facebook did remove me from my platform, and I've accused Facebook of engaging in grossly improper conduct, and I believe that publicly said that Facebook have blood on their hands because of the conduct that they've engaged in by blocking information on early treatments. Ms. Gullick, how many...
encourage you to rephrase that.
I believe that Facebook have publicly stated that Facebook have blood on their hands because they have blocked access and censored access from qualified medical professionals from around the world that have detailed early treatment. My question is to Ms. Garlick, how many members of Parliament have Facebook accounts?
I apologise, Mr. Kelly, I don't have that number off the top of my head, but I do know a large number do.
Would you say the majority of members of Parliament have Facebook accounts?
That's my impression, yes.
Okay. Do you believe those Facebook accounts are used by members of Parliament in the performance of their duties?
It's not possible for me to talk about, I think people have private accounts, they have public pages. I assume that most of the pages that are set up are there to connect with constituents and to share updates about their activities.
All right, so a member of Parliament would use that page in the performance of his duty, as you said, to connect with constituents, to inform constituents what they're doing. Would they also use that page with the messenger service as where constituents would send them messages to respond to?
I assume that is sometimes the case. I do know that I think it really depends on the individual MP. Some MPs don't want to receive messages in that way and have express instructions about how to contact the office and go through the usual channels.
Mm-hmm. Okay, so basically what I hear you saying is that your platform offers members of Parliament an important tool in their kit bag in the performance of their duties as a member of Parliament.
I feel like that's a comment and not a question, but yes, I think it is a tool that MPs can use and senators.
Right, as a performance of their duties as members of Parliament.
Well, I don't know that I'm qualified to opine about sort of parliamentary procedures in that way, so I'm happy to sort of come back to you and take those questions on notice if that's helpful.
I'm saying, surely if a member of Parliament uses Facebook as a platform to communicate with their constituents, which I think you agree with, that's part of the duties of a member of Parliament.
I think people use our services in a range of different ways, and so I don't really want to commit to any one generalisation for all of the members of Parliament. But I assume that we're leading to a particular question, so I'm very happy for us to get to the substance of that.
Okay. Well, do you believe that it's a duty of a member of Parliament to communicate with their constituents?
I really wouldn't want to opine on the duties of members of Parliament. I assume that's part of the parliamentary procedures and training that MPs get and
yes or
senators
no
get.
Answer. Do you believe that members of Parliament have a duty to communicate with their constituents?
I'm not versed in what the duties of an MP are. I apologise. Obviously, as a citizen, I appreciate it when my local representatives communicate with me, and certainly as a politics junkie, I love to track and see the different ways that our elected officials are engaging in the public sphere.
Okay. Let's just assume for the minute that it is a duty of a member of Parliament to communicate with their constituents. Is Facebook a tool that they would use to communicate with their constituents on political matters?
Certainly it is a tool that people can use, yes.
And members of Parliament would use that tool to communicate with constituents on political matters?
Yes, that can be part of what it is. Yes.
Right, okay. Okay, does Facebook comply with all Australian laws?
As far as we are aware.
Okay. So therefore, if you agree that members of Parliament use Facebook as part of as to communicate with constituents, and you said you were still unsure that that's whether communicating with the constituent is a duty of a member of parliament. Let's just assume that it is. Wouldn't your blocking of members of parliament's Facebook page be an interference in their duties?
But it might be helpful if I talk a little bit about how our policies are applied in this regard, because I certainly obviously we have the global policies that we've been mentioning throughout this hearing, and where it comes to harmful health misinformation or hate speech or other policies that we have, those are applied, fairly consistently across the board, regardless of who is saying those.
Okay. Who determines what is harmful information or misinformation? How do you determine that?
So in relation to the current COVID-19 pandemic, we've been working with health authorities and regulators to determine the specific claims in respect of which we will be removing those based on the advice that it is it's harmful to the way in which we're all trying to manage through the pandemic.
Okay, what about where there is differences of opinion, where you have certain medical experts that hold opinions that are contrary to, say, the particular government medical bureaucrats?
I might throw to Josh here, because I think he has been dealing most closely with some of the health authorities. But I do think, this is I think it's a 1 in 100 year pandemic, and the nature of the claims that we will take action against do change as the health advice changes. And we do try to make sure that we're working with local authorities as well as global health experts so that we can all be doing our part to keep Australians safe and connected through this pandemic. But Josh, do you want to talk about some of those specific claims and things that have changed over the course of the pandemic?
Yeah, sure thing, Mia. So, Mr. Kelly, the claims that we consider to result in real-world harm, the false claims that can result in real-world harm, are informed by consultation with the most eminent health organisations, including the World Health Organisation, and we speak with stringent regulatory authorities, including the TGA here within Australia.
Okay. Can I ask you a question on that? Yeah, just you talked about the World Health Organisation, the TGA. What about where they have difference of opinions? Let me give you one example. On remdesivir, the World Health Organisation does not recommend remdesivir. The TGA does. So we have a difference of opinion there. Who takes priority, the World Health Organisation or the TGA?
Well, we work with a range of different experts. It's not one organisation privileged over another. But the question that we will be looking at is, will claims about a potential treatment potentially discourage people from being vaccinated or taking the globally accepted steps in order to protect themselves from the virus?
Okay, let me take you on that point. Yesterday we had the chief scientist of the World Health Organisation state, and this is a direct quote, "There is no evidence right now that healthy children and healthy adolescents need boosters." So that would be contrary to what you're saying. So would you censor the chief scientist of the World Health Organisation?
Well, perhaps the example I can give you is...
Would you censor someone questioning the or someone quoting the chief scientist of the World Health Organisation because of that statement, which is contrary to what Australian our medical bureaucrats are saying here?
Well, the claims that we will remove or that we consider to reach the level of real-world harm are those that will discourage people from taking steps like getting vaccines in order to protect themselves.
Well, isn't that exactly one example? The chief of the World Health Organisation yesterday, doesn't that statement that they made, there is no evidence, and I quote directly, there is no evidence right now that healthy children or healthy adolescents need boosters. So doesn't that discourage people want to have vaccinations? So therefore, what you're saying, that you would censor the chief scientist of the World Health Organisation.
Well, I mean, I think we've got a very specific list of their COVID-19 claims, and it does take a little bit of time for us to be consulting with the relevant experts to identify which specific claims we will be removing. And maybe it's helpful for us to come back to you on this one with notice. I mean, certainly, in respect to my children, I've been advised by our local medical professionals not to get boosters. So, but the different, the health advice over the course of this pandemic has changed, and that's why we do work with a range of different experts to identify where there are specific claims that can interfere with people's ability to protect themselves during this pandemic. And to come back to you with the specifics of those claims.
If somebody said
that
hydroxychloroquine is safe and effective in the treatment of COVID, would that be banned from your platform?
We don't allow people to make definitive claims about alternative treatments or cures. So that can include claims that hydroxychloroquine is able to cure COVID.
Okay. What about leads to a significant recovery and also is effective in aiding recovery and reducing mortality? Would that statement be allowed?
Well, you're correct that it does depend on what someone is.
Asking you that those statements I am reading from a peer-reviewed study that has been published. Now, this peer-reviewed study was registered with the TGA. It is an Australian study by Australian medical experts, Australian researchers, and it says, I'm quoting directly, it goes here, the study suggests the treatment protocol with hydroxychloroquine, that goes on, is safe and effective in the treatment of COVID-19. Our study's findings are in line with international literature whereby the treatment of COVID with hydroxychloroquine has shown to be effective in aiding recovery and reducing mortality. So what you basically are saying to us, that this peer-reviewed study, although it might be contrary to what our authorities are saying here, would be banned from your platform.
Well, the series of claims that we've developed have been developed in consultation with the eminent health organisations in the World Health Organization, stringent regulatory authorities, people who can provide advice about these claims. And we recognise that advice can change. And an example is around, for example, claims related to vaccines causing blood clots.
If the advice can change, how can we have proper debate on advice changing if you are silencing one side of the debate and you are silencing medical experts and medical professionals?
Mr. Kelly, sorry, Josh.
You go now.
Well, I was going to say, I mean, that's why we've made it very specific claims and we've been very transparent about those claims. And those are the ones that we are enforcing against at this point of time. And obviously,
it seems clear as mud to me, just on transparency. So I asked that question again. If someone makes the statement that hydroxychloroquine is safe and effective in the treatment of COVID and leads to significant quicker recovery and that has been shown effective in aiding the recovery and reducing mortality, is that something that would be allowed or not allowed?
I think one of the key points I'd make here, Mr. Kelly, is we allow for debate on our platform. We allow for people to discuss items in a scientific sense, but where they are making direct claims, false claims about the efficacy of alternative cures, the best advice we have.
Who determines? This is the question. This is the point I'm getting to. Who determines where we have significant divergence of opinion, and we have medical experts around the world saying that these other treatments are safe and effective, which I agree is contrary to what our medical bureaucrats are saying here. But where we have this different medical opinion, how can we have a debate if you as Facebook are shutting down and censoring people that are studying these things and censoring and shutting down medical experts?
Mr. Kelly, just in not wanting to interrupt you, but I will just observe it is now 12:30. There's a number of other committee members who are keen to ask questions, which I think will be placed on notice. But I'm wondering if you could perhaps, at the conclusion of this question, indicate further questions on notice or conclude with a final question, please.
Thank you, Chair. Well, I'd like to conclude with a final question. When you have your Facebook fact checkers place a fact check over something, is that a factual assertion that you are making that something is false, or is it just a statement of Facebook's opinion?
Yeah, thanks. So the way that I'll separate out the claims that we remove because they can cause real world harm versus the claims that don't reach that threshold but may still be false, which are the ones that are eligible to be fact checked by our independent third party fact checking partners. So these are all organisations accredited to the gold standard. They're all members of the International Fact Checking Network, and they have full independence in their determination of whether a claim is false. They apply their editorial judgment, their expertise in fact checking, and they advise us, and we apply those labels based on their expert advice.
Okay. One final question, Chair, with indulgence.
If you could have unnoticed, Mr. Kelly, I'm just mindful of the time. We're about 45 minutes behind, that's all.
Okay. Thank you, Chair.
Thank you very, very much. And if I could just ask the indulgence of other committee members, including myself, to place further questions on notice to Meta Platforms Incorporated, more commonly known as Facebook and Instagram. We would appreciate that very, very much. To our witnesses, can I thank you for your time, for your willingness to give us additional time. We do appreciate that. And ask you that any additional information that you have been asked to provide during the course of today's hearing or are asked by way of questions on notice, they will be sent through to you by the Secretariat. And could you please forward your responses to the Secretariat by the 3rd of February 2022 to advise you that you'll be sent a copy of the transcript of your evidence and you will have an opportunity to request corrections to transcription errors. I thank you again for your time and attendance and indicate that we will pause, once again, suspend the hearing for a minute or two to allow our next witness to appear. Our public hearing of the Select Committee on Social Media and Online Safety via video and teleconference. And I now welcome representatives of TikTok Australia to give evidence today. And I ask that for the Hansard record, for you to please state your full names and the capacities in which you appear before the committee.
Sure, thanks, Chair. My name's Brent Thomas. I'm the Director of Public Policy for TikTok Australia and New Zealand.
Thank you, Chair. I'm Lee Hunter. I'm the General Manager for TikTok Australia and New Zealand.
Chair, I'm Julie de Bayencourt, and I'm the Global Head of Product Policy for TikTok.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Would you like to make a brief opening statement before we proceed to discussion, or are you happy for us to go straight to questions?
Madam Chair, we do have a short opening statement. If I could read that, that would be appreciated.
Yes, thank you. Could you, I will just note, we do have your submission and we will have all been familiar with that as well. So if there's anything in addition to what's already in the submission, that would be helpful. Otherwise, we can go straight to questions. Thank you.
Sure, thanks, Chair. Members, TikTok is an entertainment platform. We are not the go-to place for news and politics, and we aren't about who you know or who you follow. We are about inspiring creativity and bringing joy to our users, and we know that maintaining a safe environment is key to delivering on our mission. Safety is always a top priority, and we've built to improve because we know there is no finish line. Excuse me, Chair.
Mr. Thomas, yeah, there seems to be an issue with the broadcasting. There's an echoing delay issue I think many members can hear. If you don't mind, what we might do in the interest of time is pause that opening statement, ask you to table it. I'm very sorry to do this, but I'm conscious of time. We might ask you to table that opening statement. We'll move to questions from the committee, perhaps with some other representatives, and hopefully we'll get the delay echo issues sorted out. I'm not sure if it's your end or broadcasting. Questions from the Deputy Chair?
Thank you, Chair. I'm sorry about that. And thank you for representatives of TikTok for joining. I just want to ask some big picture questions, and I should premise this by saying I recognise in your submission your invitation for committee members to attend your Transparency Centre and see how that works. And I think logistics pending, that'd be a good thing to take up. We'll do our best to do that. I just as a general point, this is something that a point that I made to Google earlier about YouTube. There's a lot of the focus of the political debate falls on Facebook on matters like this because they generate a lot more transparency on the way that they report, on the way that their algorithms and their recommendation engines in newsfeed work. We see a flood of both leaked documents, but also services like CrowdTangle that provide a direct sort of API feed of content that's being shared widely on the platform, as well as a widely shared content report that Facebook prepares. Can I just ask, and this is, I want to be specific, I'm not talking about moderation issues here, I'm not talking about transparency about things that are banned or taken down, I'm talking about transparency about the way that your recommendation engines work, allowing outsiders to understand that and academic and external researchers to validate that understanding. Why doesn't TikTok produce things like the Facebook's widely viewed content report or the service CrowdTangle?
Thank you, Deputy Chair. Transparency and responsibility is part of the core of our popularity, and you've referenced our Transparency and Accountability Centre. And in fact, within that centre, individuals can come and examine the actual code that drives our recommendation engine. We believe that platforms like us should be completely transparent about the way that our moderation policies work, as well as our recommendation engine. You'll hear us say several times today that we wish to invite you to the Transparency and Accountability Centre because it is concrete proof and the ability to see how this recommendation engine works in real time. In essence, transparency is at the core of what makes us popular and something that we're committed to.
Yeah, but I mean, you can see the limitations of that kind of transparency. I mean, I can come to your Transparency Centre and have a look at that code. I wouldn't know what to make of it. It's a different kind of transparency that is offered by like the weekly rankings or the daily rankings that you see from CrowdTangle around this is the content that's most widely shared. This is the kind of content that is, well, not the kind, this specific forms of content are the ones that are being most heavily promoted via the recommendation engines, by the algorithms of the platform. So I'm just trying to get to the transparency on outcomes here of what the content are. I'm not suggesting there's a conspiracy going on here. I'm just being specific about the kind of transparency that I'm looking for.
Deputy Chair, I'll invite my colleague, Mr. Thomas, to speak more in a moment, but I would say with regards to the algorithm recommendation engine, we welcome experts to come in and examine the code as well. So there is a deeper, fuller understanding of how it operates. But someone who has been to the Transparency and Accountability Centre is my colleague, Mr. Thomas.
Yeah, thanks, Deputy Chair. I think what I'd add to what my colleague said, we do have an absolute ambition to be transparent and to be more transparent than others wherever we can be. We did last year, I don't know if you've seen it, I can forward it to you if you haven't seen it. We did publish some information about how our recommendation system works and how it feeds into everybody's For You feed. When you're on TikTok, it's sometimes different to how some other platforms work, and each person's For You feed is quite individual. And the way we explained it, and I can forward this information to you, the recommendation system prioritises things that are different for each individual user, because you might be interested in material that's quite different to what the chair is interested in, and that might be very different to what I'm interested in. So it's very much based on user interactions, and I can forward that that additional information to you if that's of interest.
Yeah, I get it. I get that the algorithm's different for every user, and I should say that's the same as Facebook's newsfeed. And I get that there's the transparency around the operation of the algorithm. What I'm talking about is transparency of the outputs. The transparency of what does that produce? Like, what is the kind of content that gets the most traction. You know, I'm just like being frank. The CrowdTangle reports on Facebook about the highest levels of engagement with content paints a picture that's very different to day-to-day life in our society. The people that get the most traction and the most engagement on Facebook, as reported by CrowdTangle, don't look like our community, don't look like our normal political debate, and that's why people have so much criticism of the platform. It's possible that there's a similar thing happening on TikTok, but we don't know because there's not a similar report on widely shared content that, you know, in real time that we can look to and make a judgment on. So I'm saying I get your commitment to transparency. What I'm asking for is this specific form of transparency. You know, why don't you offer that? Are you considering offering it?
Deputy Chair, we release a transparency report on a regular basis. I'd invite my colleague, Mr. Bayencourt, to talk through some of the content within those reports.
Mr. Watts, I think, you know, the numbers that we're providing in a transparency report, you're likely familiar with, right, around enforcement, removals, how fast we're going. I think we're still in the early step of our journey in providing more transparency in our practices. You'll see that with every transparency report that we provide, we usually try and add new numbers, provide new metrics. We've shared a series of blog posts around the algorithm and the output of the algorithm and the input of the algorithm to try and, I guess, demystify that, you know, it is a recommendation engine. It is not a black box. More recently, so just a few weeks ago, we published another blog post to explain what we're doing in diversifying feed and some of the experiments that we are undertaken with diversification strategies, in particular to combat things like filter bubble or echo chambers. And I think you will see from us that we will continue being open and transparent on the output of these experiments and some of the things that we're trialing. We're also looking to give people more control, I guess, over their experience and developing new features that they can use. And we're testing at the moment a new feature that would allow people to filter specific hashtags and keywords from their For You feed based on their personal preferences. And then maybe just to finish off, I know we're comparing things here, maybe with what other platforms are doing. We have so much content on TikTok. Our content is 50 seconds short videos. There is so much coming and going every day, so many new trends. I think that's the diverse, broad, kind of rich nature of the platform means that what is served in people's For You feed or what people are sharing, you know, among friends virally evolves all the time. So it's hard to pinpoint at any moment with so many new things being surfaced and being created.
And it underlines
if I might,
fun information. Have you considered the adopting something? I mean, Twitter offers an API to approved researchers, academic researchers, external validators, to test the proliferation of content in this platform. Is that something that you currently offer, are considering offering in the future?
Deputy Chair, we stand by our commitment to transparency. I'm not familiar with those particular tools that you mentioned, but perhaps my colleague, Mr. Thomas, might have something else to add there.
Yeah, Mr. Watts, I think the two things, what I'd add to this discussion is we do publish, we do regularly sort of report out what some of the top trending videos and genres have been, but I think you're asking something a little bit more. And I think what I'd say is TikTok as an office in Australia has been here for about two years. We established an office in late 2019. We're really open to the feedback of you and others on this committee. If there are additional transparency measures that you would like to see from us, I think we are keen to hear those and to take those away and see what's possible, because that's a genuine question. If that's a genuine interest for you as a policymaker, we'd love to see how we can help. And so I'd love to take that away. Yeah,
I'd appreciate that if you could, particularly the kind of the API level sort of feeds from your platform that academic researchers, external third parties could use to validate the transparency you're providing on how the algorithm operates. And in that context, I suppose if you could take this on notice as well, there are proposals in the US Congress around giving the Federal Trade Commission authority to force platforms to disclose in real time the information that is spreading on them in particular categorizations. So that legislation also extends to not just that API level validation, but also structure in cooperation with academic researchers studying the way that platforms operate and the impacts of those platforms more broadly on society. So taking that on notice, if you could also come back to me with your thoughts on that US legislation that I'm sure globally you'll be familiar with.
Yeah, Mr. Watts, I think we heard your similar line of questioning to one of the other industry participants. I think we would like to take that away and come back to you with some better information.
Great. Chair, do you want me to continue? I've only got a few more.
Look, I'm mindful of time. Are those ones best to place on notice, or very happy to continue? I don't want to curtail things, but I'm just mindful of that. Mr. Simmons does
I'll
have
take
some
the
questions.
Chair.
Thank you. Questions from Mr. Simmons?
Oh, thanks very much, Chair, and thank you very much for our witnesses for appearing. I mean, TikTok has got a large number of users who are young, and I think there's a special duty of care there to our young Australians from 13 to 24 about the content that your algorithm is driving to them. Are you aware of a recent report last year by Reset Australia, which actually opened new TikTok accounts, did an experiment by watching the videos that TikTok recommended, and within 4 hours, they were getting videos to these young people who they'd signed up as 13-year-olds that was questionable content. It was promoting racist material, was promoting ethnic stereotypes, was promoting unhealthy weight loss techniques that push kids towards anorexia. Have you taken the time to read that report, and how have you responded to it?
Thank you, Mr. Simmons. I am not familiar with that report. I haven't seen anything of that nature. I would say that TikTok is absolutely a platform for only users 13 and above. And we're trying to balance the right for teens to express themselves and have meaningful social interactions, but also recognize that we have a duty of care. And within that, we have age restrictions and age-appropriate experiences on TikTok to ensure that our teen users are well cared for and maintain a safe, enjoyable time on our platform. If you would like, I can take you through some of those age-appropriate and age-restricted features.
Well, perhaps we can start with what efforts have TikTok made to identify users who are under 13 and to have them removed from the platform? How many people have you removed?
We make significant efforts there, both in terms of prevention, ensuring that they don't get on the platform in the first place, but also detection. So making sure that when we do encounter users that are underage, we take swift action to remove them from the platform. I'd like to pass across to my colleague, Mr. Vaillancourt, to talk about some of those detection measures and some of the detail around the numbers of accounts we've been removing.
Mr. Hunter. Yes, obviously prevention isn't enough, and we're very keen to make sure that we create a safe space for users on the platform, and that we remove those that are not old enough to join the service. On the detection side, we do have our moderation teams who are quite large, who are trained to potentially recognize signs that someone is under the age of 13 and swiftly remove the account if that's the case. We rely on user reports, of course, but parents and teachers and family friends can report users under the age of 13 to us. And then we don't want to stop here. We want to make sure that we surface potential accounts based on publicly available information. We use keywords and we try and flag those to remove them. As my colleague mentioned, we have been providing these numbers in our transparency report, and in Q2 we removed 11 million accounts of suspected underage users. That's about 125,000 a day, and that's a step up from the previous quarter where we had removed 7 million accounts of underage users. So overall, 18 million for the first half of the year. obviously we don't want to stop there. There's you know, a lot of work for us to do to make sure we keep under 13s away from the platform. A lot of work in educating teens and parents. A lot of work in improving, I guess, our detection and our ability to weed off those accounts. And then for those you know, who are 13 and above, who are left on the platform, as Mr. Hunter pointed out, we want to make sure they have safe experiences, age-appropriate experiences, and indeed to have a lot of guardrails built behind the scenes as part of our safety by design approach. I hope this answers your question.
Can I ask, no, thank you, and look, and I appreciate the figures. Is the 11 million across the global platform? Do you have a Australian specific figure?
No, but what I can tell you is that it is less than 1% of the overall amount of accounts that are on TikTok. And I think actually I forgot to mention, but I think we were the first ones to provide these numbers, around our removal and our efforts to weed out underage accounts from our service.
So less than 1% of all accounts on TikTok, which is favoured by young people around the globe, and particularly in Australia, are under 13. Do you think that's really an accurate reflection of the number of young people under 13 who are on your platform, or do you think you're missing a large portion of those who are viewing TikTok but are under the age of 13?
I think considering our progress between the 7 million to 11 million over a quarter, I think there's more that we can do, obviously. And we're, again, always keen to understand how we can innovate. This is an industry-wide problem, as I'm sure you've heard in the context of this committee. And there's no silver bullet at the moment for this, but we're very keen to know where we can do better. We certainly do not want any users under the age of 13 on our platform. And again, we'll try and think creatively alongside regulators, experts in industry to make sure we can keep improving our detection.
No, look, I appreciate that, and I appreciate the efforts you made. I just get the feeling that tech companies like to throw out big numbers of people they remove from their platform, but as a percentage, I mean, they're really minuscule, and they have a long way to go in terms of the efforts that they make. Can I ask then, I mean, your algorithms would be designed to drive videos that are getting a lot of views onto people's pages. Now we know that the videos that get the most views are often the most controversial or aggravated, or there's a variety of adjectives you use to describe it, but you know where I'm getting at. So what are you specifically doing for those aged 13 to 18 to ensure they're not just being pushed the most viewed videos, when in fact those videos could be extremely harmful, especially if they're not outright racist or violent, but they promote, for example, very unhealthy eating habits, which if a 13-year-old was to adopt could lead to decades of harm.
Yeah, I
Thank you,
think
Mr.
this
Simmons.
is
Excuse me,
sorry,
Mr. Mason,
I
might offer something and then invite you to add something. Look, safety is part of our popularity, Mr. Simmons, and steering users to controversial or harmful content would be counter to our values and, frankly, our commercial interests. Talking a little bit about how our For You feed operates, it is based on the individual's preferences. It's powered by their feedback to continually improve and give them a content experience suited to them. Part of that is informed by the content they engage with, if they're sharing it, as well as where they might be located. So, for example, if you're in Sydney, you might see content related to people around you within your locale. Diversity is crucial to this platform as well. So we've had the benefit of seeing some of the harmful effects that filter bubbles and continually delivering the same content, the same perspectives and viewpoints to individuals. We've seen how harmful that can be. So with that idea of diversity being built into our platform, we intersperse recommendations that might fall outside of a user's preference, but might deliver to them something new that they can discover and enjoy. Our recommendation system is designed with safety in mind, and we want to empower users to be able to influence that recommendation as well. So there are tools within TikTok to enable them to diminish and remove the type of content that they don't enjoy. I'll offer back to my colleague, Mr. Bayencourt, to add some thoughts.
Can they directly report videos they find offensive? Is there that functionality?
They absolutely can.
They can indeed. Thank you. Thank you, Mr. Hunter. They can indeed. Anybody can report any piece of content on TikTok, and this will be reviewed by our team in a really swift manner. I think building on, what my colleague, Mr. Hunter, was saying around this safety, which is at the core of our experience, really. Content that is surfaced to people in For You Feed is obviously personalized, but we want to make sure that it is appropriate and age appropriate. So content that you were describing that may be viral or getting a lot of views would have been reviewed, first by our detection, our machine learning and detection models, as well as people in our team, to make sure it is indeed safe and appropriate for all audiences. Just going back to the point you were making around maybe potential fitness diets or weight loss diets, as I've mentioned earlier on, I think to Mr. Watts, we have shared some information in December around the efforts that we're putting to prevent disrupt repetitive patterns and diversify our feed. And you really hold on to one of these examples, which is in isolation, one video related to fitness or weight loss is probably not so bad, but in aggregation, this is probably not something that we'd certainly want to serve our users coming to our platform. So for this, we're testing lots of different mechanisms to disrupt repetitive pattern related to weight loss, related to fitness, as well as related to other themes such as breakup, loneliness, and this is obviously informed by experts. And we will again hope to share more information on this as we progress in our experiment. But we're very much intent on making sure that people, engaging with their For You feed, have this diversity of content that is so core to our platform.
Look, I appreciate that, and look, I'm just very wary of platforms who say that they're putting the power of users, the power back in the hands of users to moderate their content, because I just don't think a 13-year-old is properly equipped, frankly, to recognise some of the harm that might come their way from these algorithms. But look, I'll leave it there and I'll hand back to the chair. If there are any specific Australian figures about under 13s you've identified as both the percentage of Australian users and as an overall number that you can take on notice and provide the committee, I'd be very grateful.
Yeah, Mr. Simmons.
Thank you very much. Sorry, please.
Chair, could I just quickly circle back to that question Mr. Simmons had earlier about those younger users? I just wanted to make the point that there is sometimes a common misconception about TikTok that it is just for those teen users, and the organisation, the platform's really come a long way. It's now multi-generations. You've got people in Australia like Dr. Karl Kruszelnicki, the Prime Minister, a whole range of others of all generations and all stages now using the platform. And so I think those numbers we gave earlier that we publish every quarter, they're actually significant when you look at it in that context.
Thank you very much. Further questions, Mr. Simmons? Okay. I believe if with the indulgence of TikTok, if you don't mind us just going a couple of extra minutes, I believe Mr. Kelly has just indicated some questions. Mr. Kelly, I've been asking this of other committee members too, just mindful of time. Are there some that you can place on notice and then ask others?
Yeah, there's a few I'd like to ask, yes, if I could.
Thank you. Thank you.
Thank you, Chair. First, I'd like to declare an interest. I did have a TikTok account that was suspended by TikTok, and I did have a discussion with Mr. Thomas, and he acknowledged that it was taken down incorrectly. My first question is, does TikTok have any ownership with the Chinese government? Does the Chinese government have any ownership of TikTok?
Thank you, Mr. Kelly. No, the Chinese government does not have any ownership stake within TikTok.
Okay, so who is TikTok owned, managed, controlled by?
TikTok Australia Proprietary Limited, the entity that we have here locally, is part of the TikTok group of companies known as TikTok Limited. Our leadership locations for that are primarily based in Singapore and the US, which is also where our user data is held. TikTok does not operate in China. It operates in 150 markets around the world, and it's part of ByteDance globally, which is a private global company.
Okay.
Mr. Kelly, can I just add, and it's always interesting to talk with you, Mr. Hunter mentioned the United States and Singapore. We also have our lead for trust and safety based out of Dublin. I just wanted to add that, which is where Mr. Baincourt's joining us from today.
Okay, fine. Okay. I understand you do not allow political advertising on your site, but you allow political commentary.
That's correct, Mr. Kelly. TikTok is primarily an entertainment platform. We're not known as the go-to place for political content, but political commentary is allowed on our platform. In fact, as my colleague mentioned before, many members, including yourself and our Prime Minister, are on TikTok. We want to make sure that as long as the content that is uploaded adheres to our community guidelines, it's absolutely okay. But where it is a paid political advertising component, that's where we draw the line.
Right. Okay. So I could advertise McDonald's, but I couldn't advertise, the Republican Party in the US.
Our advertising policies are transparently explained, and there are a number of different aspects of which we don't allow advertising for. That includes alcohol, gambling, weight loss programs and supplements, and political advertising.
Okay. What's your process where you would go through where a particular post would be deemed to in breach of that advertising? Is it people reporting it to you? Do you rely upon the number of reports that you automatically deleted? Is it looked at by a human? Is it algorithms? How would you go about determining that something is unfit for the platform and should be removed?
Our advertising policies are strict and go beyond many of the industry standards that are out there. All advertising goes through review, and that incorporates not just
advertising. I'm talking about just everyday people making everyday posts on the TikTok platform.
Okay. Mr. Kelly, absolutely. It goes through a thorough review in line with our community guidelines. Mr. Baincourt is our trust and safety expert on the panel here today. I will pass across to her.
So the example,
Mr. Hunter,
if someone puts a post up on TikTok, what do people, it's for some reason it's taken down, do people report it to TikTok, investigate it? What's the process?
Sure. I think any content that is posted on TikTok is first going through our detection algorithm to make sure it doesn't contain any graphic, violent content, any pornography. After this, obviously, people have the ability to report, a video to our team, and it is very swiftly reviewed by a human. Sometimes reviewed multiple times if we think that a piece of content may go viral or that it is accruing a lot of views. The number of reports doesn't make any difference. It can be reported once or it can be reported 50 times. It will still be reviewed with the same care by our team. And then, we strive to be transparent when we take action on something. So if a user posts a video that we remove, we will let them know that we have removed this. If you report a piece of content to us, we will also let you know, when we've received the report, when we've actioned it, indeed the action that we have taken. And then for pieces of content that we remove, such as videos, or if we ban an account, people always have the ability to appeal our decision, and they can contact us back and say, they believe that the content has been removed in error, or that their account has been removed in error. And in that case,
I think and I found great difficulty in finding out how that could actually be done.
Yeah, I think the notification that we give the user that includes, the information in relation to the status of the account includes an appeal process.
Okay. If that's the case, how is it possible that a TikTok video that I posted that was nothing more than still photographs of people holding up signs saying freedom, 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 how is it possible that was banned?
Mr. Kelly, I know you've been in contact with my colleague, Mr. Thomas, about this case. I'll pass across to him.
Yeah, thanks, Mr. Kelly. I think at the outset, as my colleague, Mr. Baincourt, described, our governing body of rules for everything and everyone, yourself included on TikTok, is our community guidelines. They apply to everything. And I think what I would say as well is that our machines and our human moderators, we potentially, compared to some other platforms, take quite a conservative view around making, we really try to keep off any content that's in any way breaching those guidelines. I have seen some of the content to which you're referring, and yes, we did have a separate conversation about that. Let me be very, very open. The machines and the humans are absolutely trained to do their very best to enforce those community guidelines, and we publish data about those numbers and how we're going every quarter. Are there instances occasionally where something is over-moderated? There are instances of that, and that's why we provide the opportunity for people to appeal those. And in your particular case, I'm aware there was one that was over-moderated or mismoderated, and we were able to have that addressed. And everybody's able to, as my colleague, Mr. Baincourt said, go through a process to have any takedowns reviewed. So everything's okay as long as it doesn't breach those guidelines. Everything's not okay if it does.
Okay, and who sets those guidelines?
I think that's one best for Mr. Baincourt.
Yes, my team would, Mr. Kelly.
Okay, and what about where the issues are of contentious debate, where there is expert opinion, expert medical opinion that may differ from what those guidelines are? Do the guidelines rule?
I'm just going to indicate this, given the time, this will be the last question.
I'll make that I'll make that my last question.
Thank you, Mr. Kelly.
I think the bar is what is indicated in our community guidelines, which we've clearly explained. I think I'm not sure if I understand your question specifically. When it comes to creating our guidelines, we do have a range of experts advising us, and we update these regularly to make sure that they stay up to date with, including new trends. And that's it. So we do have the ability to just review them and update them as we see new things emerging that need to be covered by those guidelines.
Okay, thank you, Chair.
I'm not sure if that answers your question. Sorry.
That's fine. Well, I'll have some questions for on notice.
Thank you very much, Mr. Kelly, and thank you also for your understanding. And can I also thank representatives from TikTok, and also just indicate to Mr. Thomas we appreciate your understanding when we had the earlier technical glitch before as well. I assure you we weren't. Some of the technology has been a little bit challenging, but thank you, and we will definitely incorporate that into Hansard. Just to ask representatives of TikTok that if you have been asked to provide any additional information or questions on notice are provided to you, please forward it through to the Secretariat please forward your responses through to the Secretariat by the 3rd of February. To also advise that you will be sent a copy of the transcript of your evidence, and you will have an opportunity to request corrections to transcription errors. I would like to advise the committee that I'm mindful we have gone through the earlier break and also through lunch. DG, who are our next witness, are scheduled to appear at 1:15, and I therefore propose that we have a 5-minute suspension and resume again at 1:16. Thank you.
Thanks, Madam.
Momentarily. And now welcome representatives of Fiji to give evidence today, and ask that for the Hansard record for you to please state your full name and the capacity in which you appear before the committee.
Hi there, my name is Sunita Bose. I'm the Managing Director of the Digital Industry Group, or Digi for short.
Good afternoon, Chair. My name is Jenny Duxbury. I work with Sunita at the Digital Industry Group. I'm responsible for policy, regulatory affairs and research.
Thank you very much. These hearings, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. I advise that the evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'm just fiddling around with your submission, 35-page submission. I thank you very much for making that submission to the committee. The committee members have a copy of that. I'm mindful of time and of the number of questions that I know members would be interested in asking. Unless there's any objection or preference, otherwise I propose we move straight to a discussion and questions from the committee, if that is okay. All right, I see a couple of nods. So I'll do so, and in the manner in which we have become accustomed this morning, I might throw in first questions to the Deputy Chair.
Thank you, Chair. It's a good teamwork on the show today. Thank you, representatives from Digi, for attending. As the Chair said, thank you for your extensive submission. I just have a few questions about what's in the submission. Your submission calls for the federal government to develop a, quote, comprehensive legal standards for hate speech and hate groups, and argues that there's currently no legal standard defining hate speech at the federal level that could incentivise industry-wide action amongst your members. To this end, your submission argues that, quote, Australia continues to adopt a narrow approach to hate speech under anti-discrimination laws and in the Online Safety Act that are aimed at protecting individuals rather than groups based on their protected characteristics. Digi believes that hate speech should be a broader category of harm that is not limited to religious, gender or race-based discrimination, but includes hate speech relating to characteristics including but not limited to sexuality, gender identity, disability and national origin. So my question on this is, what might a legislative framework that defined hate speech as a broad category of harm look like? And are there international models that you're aware of that you can point us to in this regard?
Thank you, Deputy Chair, for the question. And thank you to the Chair and committee members for the opportunity for Digi to be here today. Look, thank you for going through our submission and picking up on this recommendation. It is an important one to us and also to our members. Each of Digi's members all have long-standing policies with regard to hate speech, but from where Digi sits, we try to look at what are the industry-wide sort of standards. We think that government plays a really important role in ensuring that there are safety nets, not just when we look at our members, but across the digital industry in Australia, whether that be sort of startups, new entrants to the markets, to make sure that there are really clear standards so that ensure accountability. And I think, as you pointed out, Deputy Chair, hate speech is an area where we don't see that safety net as we do with other areas, and a lot of areas that will be covered under the Online Safety Act that come into effect on Sunday, and then this is not one of them. Look, in terms of the specifics of how this should look, I think it is a bigger conversation. It's not one that we certainly wanted to bring to this inquiry, but would necessitate a longer conversation with many experts. And I know that many of those experts have appeared before this inquiry as to what the right outlet is for it, whether it's in the Online Safety Act or elsewhere. Look, to briefly touch upon your question about overseas frameworks, I don't have the details to hand, but I do know that there is a framework in the EU that certainly many of our members engage with that could potentially provide a model there, but I would have to sort of potentially take that aspect of your question on notice.
Thank you. I'm not sure whether you were following the evidence earlier this morning, but are you aware of the issue with that the Australian Muslim Advocacy Network's flagged with Senator Anning's Facebook page and the state-based anti-discrimination action that they took against him, and the issues in having that flow through to moderation enforcement action up at the platform level? Some witnesses have suggested we ought to tie the state-based anti-discrimination regimes to the Online Safety Act to sort of empower the E-Safety Commissioner to action those state-based decisions. Is that something that you've considered?
I have to kind of consider any regulatory proposal in detail, so I don't have a specific view on that particular idea.
Okay. So your submission further highlights that, quote, a legal gap persists in relation to hate speech with respect to the Online Safety Act, and that regulatory guidance for the Act states that, quote, a particular Australian adult means one specific person, not a broad range of group of people. For example, racist abuse targeting a group rather than an individual, such as a post that says that all people of a certain background should be wiped out, would not be adult cyber abuse for the purposes of the online safety scheme, because it is directed at a group rather than a specific person. Is it your view that this legal gap, as you describe it, should be addressed by the government, and if so, how?
So it is our view that it should be addressed. I mean, we've certainly included in as one of the 8 recommendations in our submission to this inquiry that it is a gap, and that we do think that guidance from the government will sort of create a legal threshold and guidance, not just for digital platforms, but across a wide range of actors in relation to having sort of a holistic approach to this issue of hate speech. So I would just kind of relate back to my remarks earlier in terms of how I think this is, this is a discussion that requires extensive debate and discussion, and like any reform process would require putting forward of various options and public consultation with experts, etc. So to the extent that something like that might occur in the future, we would be very willing participants in that discussion.
Okay, thank you. So following on from this, your submission also notes that, quote, the Australian government may also provide further legal clarity by reviewing the protocol for listing terrorist organisations in response to the growing threat from the far right, and consider whether new organisations should be added to further efforts to address hate. This might be similar to the FBI list of foreign terrorist organisations, the UK's list of prescribed terrorist groups. Clear and comprehensive guidance will assist industry players seeking to promptly remove content from terrorist groups. What kind of legal clarity are you looking for in this listing process?
Thank you, Deputy Chair, for the question, and I will just sort of say with some level of context that the questions around countering violent extremism are of keen interest to Digi. It's something that's been a focus of us. We've partnered with the Department of Home Affairs around a specific youth-based initiative around countering violent extremism. So this is something that we've kind of engaged with experts over the last few years around sort of the increasing threats from the far right. And look, I think with this, again, it's sort of, I don't have very specific, I'm certainly not, I don't have very specific proposals beyond what we put in our submission, but I do know, and I hark back to sort of my own previous personal experience as a content moderator, that the more clarity you have when you're trying to implement things, the less that you take the judgments out of, the room of, realm of content moderators, and there's something clear to look at. And I think this is an area where major platforms, large, smaller platforms, the whole industry would really benefit from clarity, and to the extent that the threats have changed, that and other countries have looked at this, that we think that there would be value in doing the same in Australia.
And the reason that this is important is because the Online Safety Act codes that relate to Class 1 materials under Australia's classification code will require platforms to minimise the risk of harm to Australian end users due to the accessibility of Class 1 materials, which do include, quote, pro-terror content. But sort of reading between the lines in your submission, at present, that definition doesn't adequately incorporate the new threat of far right, right-wing extremism, terrorist content. Am I understanding that correctly?
Look, it's a really good question, Deputy Chair. I haven't actually thought specifically about that recommendation with regard to the work that we're doing on the code specifically. We are looking at Class 1 content as a whole. I might see whether my colleague, Dr. Duxbury, has anything to add here, because she is taking the lead on Digi's efforts with regard to the codes under the Online Safety Act.
Thank you, Deputy Chair, for your question. It's a really good point that you raise, because the codes are intended to deal with Class 1 materials and Class 2 materials. As you would know, the way that those concepts are defined under the code, under the Online Safety Act, is actually quite interesting, in that it talks about materials that would be classified as Class 1 or Class 2 by a National Classification Board. But of course, that board does not have jurisdiction over online materials. It is limited to looking at videos and games and films, for example. So it is actually quite difficult concepts to deal with from an industry perspective. And one of the things that we are looking for is greater clarity on those concepts, one of which is pro-terror materials, but the other things that were in scope as well similarly need greater clarification and guidance from the E-Safety Commissioner in terms of how the industry is expected to interpret those concepts.
Just one more question before I throw back to the chair. I think your submission talks about the sort of need, well, the benefits that would accrue from consolidating the regulatory approach in this area, and that there are, I mean, just describing that regime there, it's a sort of a complicated thing that's agglomerated since the 99 BSA reforms. Is the fact that despite the best intents of the Online Safety Act, this regime still is spread across multiple legal instruments and regulatory instruments, creating issues for compliance and clarity, certainty for your members? And is there a case for a renewed effort to consolidate regulation in this space?
I'll take a first pass at this question, Deputy Chair, and then I might throw to Dr. Duxbury for more detail. Look, yeah, certainly this was the first recommendation in our submission. And I think Digi is an industry association. And I will just add, I would have made this in my opening statement, that, we obviously do work with the largest technology companies, but we also work with smaller companies. We have an associate membership program. We work with smaller Australia companies and, like Redbubble, product.review.com.au, changelog. So when we approach these sorts of questions, we do look industry-wide. And certainly the government's approach to a lot of these questions is to look at industry-wide. When you look at the definitions under the Online Safety Act and under various pieces of legislation, they do have a very broad definition of social media services that's around sort of interaction between, two or more end users. So when we look at these questions, we're not just thinking about the capacities of larger companies, but we are looking at across the board, and particularly as Australia tries to be a leading digitally enabled economy, what does this look like? So look, I mean, it's our job to sort of engage with these pieces of legislation, and we do find that as we engage with all the various pieces, the Online Safety Act has various components, as you all well know, that basic online safety expectations. There's also the restricted access scheme. There's the mandatory codes that Digi and Communications Alliance and other industry associations are currently developing. So look, I do think that when you put it all together, that there is quite a fair amount of complexity. And it is something that I think we should consider as we move forward in trying to, I guess, be a leader in this space, because certainly having clarity does help compliance. It makes people be able to, companies large or small, be able to make quick, right decisions based on the guidance that they have. I don't know whether Dr. Duxbury, you want to add anything to that?
Yes, thanks. Thanks again, Deputy Chair, for the question. Look, as Sunita says, there are a wide number of overlapping initiatives in the e-safety space, particularly relating to content. One of our concerns is the extent to which there is a risk of having inconsistent approaches to same or similar issues. So, for example, National Classification Scheme, the content classification process and the decisions of the National Classification Board are publicly available, they're very transparent, but the approach that is taken by eSafety is not managed in exactly the same way. So there's a slight disjunct there, and that makes it quite difficult also for the online industry to make judgments about how the scheme applies in the online space. And as Sunita says, we've got a number of overlapping initiatives, and we see the potential for slight differences in approach. So, for example, the codes that are under development at the moment, the E-Safety Commissioner is suggesting we take a different approach to certain classes of pornography, Class 1C pornography, than the approach that would be taken under the restricted access system declaration, and potentially be taken in relation to the takedown of that material under the Online Safety Act.
And then potentially there's another layer of definitions as well with this new proposed anti-trolling bill that catches an even broader range of groups.
Look, we'll be putting forward a submission to that. I know that they're due tomorrow, so we'll be turning my attention to that shortly after this hearing. But so happy to provide our submission once we formulated a view on that bill. But look, I will just to touch upon the point you raised in your question. It does adopt the same definition, I think, for the most part, as the Online Safety Act around capturing social media services that that enable interaction between two or more end users. So we are looking, at a very broad range of organisations that are potentially caught in scope in that, and other bills that adopt that similar definition.
Yeah, do you want to jump in now?
Deputy Chair, thank you very much, and thank you again to our witnesses. It's interesting that you were having this conversation, because I was sort of looking at the same area from your submission, actually, looking at you wanting comprehensive legal standards for hate speech and hate groups. And you may have heard, if you were listening to any of the earlier inquiry today, that I've been having a look at issues around abuse and abuse and degrading, demeaning, dehumanising treatment of individuals. And so I was interested in your comments there, but I guess my first question is, why is it the government's role to ensure that highly profitable entities, highly profitable entities that make so much money every single year, comply with basic community standards? And if I go further, if I look, from at some of the words used, I don't have a legal degree background, but I do know that, for instance, there is the reasonable person test, what an ordinary reasonable person would consider. Why is it necessary for government to actually mandate that? And what is your view of platforms accepting their duty of care in relation to their users and a consistent duty of care across all platforms in Australia?
Thank you, Chair, for the question. And I think I caught most of it. I don't know whether it's my connection, but a few words dropped out. But I think I got most of it. Please let me know if I've missed anything. Look, where DG approaches these issues is from an industry-wide perspective. We work with a wide range of companies, and I will say that many of our members are the leading mainstream platforms, and they certainly do have policies in this area. But the reason we think that in order to have a comprehensive approach to online safety, it's very much a multi-stakeholder effort. Industry, certainly the companies, and when I say industry, I mean it's a tough one, because we work with a set of companies, but there is a broader industry there. But certainly from the perspective of our members, I mean the issues around cyber abuse are incredibly important, and they have a huge investment there. Those policies and their enforcement mechanisms need to continue. They can't be set and forget. They need to continually evolve in the face of feedback and evolving community standards. That needs to exist. That needs to continue to exist. So by Digi saying that we also need government support in this area, that's certainly not to say that category of platform effort needs to continue and continually improve. The reason that we think that sort of standards need to exist here is when we're looking at this industry. I mean, there are a wide range of digital services that Australians use every day, and so it is around having those safety nets, ensuring accountability across a wide range of those services. So, look, with regard to cyberbullying, I mean, as we've talked about in this hearing, the Online Safety Act comes into effect on Sunday. That does have an adult cyberbullying scheme. Where platform policies fail in relation to taking down any of that content, there is recourse for consumers to go to the eSafety Commissioner and to have that material taken down within 24 hours. And so that does provide us a safety net.
Yeah, I hear that, and that does come into operation from next week, which is something I applaud the government in doing, and that's its initiative. But can I say, why should it have to? These are companies that are making money off the very services that they provide, that have all appeared before our committee and told us hand over heart. They have an obligation and a great duty of, that they talk about, lots of talk about how important online safety is and their duty of care. And yet, my observation is there seems to be very inconsistent application of what that actually means. For me, it seems to be a very basic standard around a reasonable person test in relation to upholding community standards, which seems to be a very common term among all of these platforms. Why? So Digi is the umbrella platform, the umbrella organisation, a not-for-profit, I think you said, not-for-profit industry association advocating for the interests of the digital industry. My question is, surely it's in the interests of the digital industry to get to align in this regard and to have their interests match community interests and to ensure that its users are safe online and to help to reduce and hopefully stamp out incidents of abuse, violence, harmful behaviour, etc. But you're advocating for the government to pick that up. Am I hearing that correctly? I guess my question is, there seems to be something missing in the middle here.
Oh, well, I'm saying that both are required. So I'm not trying to oversimplify the approach that we need to take to such online harms. I think to answer the sort of earlier part of your question, yes, it is in the interests of digital platforms to be in line with community standards. And look, community standards evolve, and so I think most of our all of our members have made evolutions of their policies over the years to reflect evolving community standards and changes to attitudes. So look, in terms of the question, which is around why does government need to have a role? Look, we think that government can play a role as a safety net when the systems don't work as intended, and I think that the Online Safety Act does provide that safety net.
Okay. So let me just ask you in relation to that. Do you believe that the existing safety net is not working with each of the platforms?
I'm not sure I understand the question.
We have a need?
I think there are existing safety nets under the Enhancing Online Safety Act.
Sorry, no, that's not my question. My question is specifically in relation to duty of care, statement of community standards, the so-called policing or moderating of those standards. And in fact, I think TikTok used a very good word in reference to over-moderating when it came to disinformation and misinformation. So they're able to moderate. My question is, are those standards by each of those platforms sufficient, or are you saying the safety net, those standards, are not sufficient and therefore you're asking government to step in?
I guess as an industry association, we have an industry view. So I can't make a comment on the specific safety nets of specific platforms. But when I look at this from a macro picture, I think there is a need for an overall safety net, because who knows what service people will be using tomorrow or the next day, or what service people are using now that we're not even talking about.
Yep, I would certainly agree with that. So if we were looking at, or rather if the industry was looking at a code of practice where there was consistency, and certainly that was my key takeout, was some inconsistency. So I'd love to have this discussion around what the industry could do and could look at in relation to consistent standards, particularly, as I said, in line with stamping out abuse and abusive behaviour that we say is not acceptable in our lounge rooms, in our bedrooms, anywhere else, but somehow online there are different standards and we get told it depends on the context, or that's not the application, or the algorithm missed it this time, but, surely it's a simple thing in 2022 when we're all having these conversations around respectful, healthy relationships and communication and the importance of that. Surely this is something that the industry could come together and have a consistent, well understood standard that meets the pub test of ordinary Australians.
Look, in terms of creating consistent standards, Digi does see itself as a key partner with the government in this regard. And this is an area where, we have led on the development of the Australian Code of Practice on misinformation and disinformation, which we've detailed in our submission, and we're happy to discuss further over the course of this session. And we're also in the midst of developing other mandatory codes of practice under the Online Safety Act with regard to Class 1 and Class 2 materials. So, we're not just working with our members here, we're we're working with companies, across the spectrum around creating that consistency of standards. Those codes relate specifically to Class 1 and Class 2 content, and I can hand over to my colleague, Dr. Duxbury, just to elaborate a little bit more on the scope of that effort.
Yes, so thanks, Chair, for your question. So the point that you make is, what can industry do to create more consistent responses to safety issues across the diverse range of businesses that participate in the digital industry. So one of the initiatives that we are currently working on is creating a standardised approach to how a diverse range of businesses across 8 different industry sectors respond to Class 1 and Class 2 materials. Part of that effort also involves looking at measures that involve industry cooperation and also measures that will facilitate better cooperation with the eSafety Commissioner on areas that affect all Australian users across the sector.
Okay, so this committee is interested in what we can do to improve and enhance online safety. And I guess part of the thing that we're having a look at today is what role platforms, or, in sort of more colloquial terms, big tech has to play in terms of improving and enhancing online safety, particularly given the massive, it's particularly given the fact that every witness, every entity says how important it is to keep its users safe. So my question, I know you've probably heard some of these from this morning, but if I was to read out to you, because it shouldn't, I guess my point is it shouldn't require a legal framework. There should be a common set of community standards and a code of practice with the industry, I would have thought, that would be common to this. I guess my line of questioning is, how come this doesn't actually get picked up in the first tranche of, the sweep that the algorithms and everything else does in relation to removing harmful content online? I'll give you some of those examples, but before I do, I'll give you some of those examples, and I have read some of them out, and these do appear on various platforms. Cavorting whore, spoken about a female. A woman in desperate need of a vibrator. A whiny little bitch. Set on fire. I toast marshmallows in the flames, and in the same comment, deserves to have their sliced open with a chainsaw. None of these met the standard. None of these were addressed in the algorithms or anything, and I'm now quoting across a couple of different platforms. My question to Digi is, what could Digi do, what could the industry do to help protect women, to help protect children, to help protect any individual who may be subject to vile, offensive, derogatory, abusive, demeaning, dehumanising and degrading attacks and slurs, particularly given that there seems to be, well practiced in terms of misinformation. I guess my point is, isn't this misinformation against an individual that causes great harm to them personally? That long trail of violence can last for years, and yet, I guess, what more can we do? What can the industry do to help?
Look, thank you, Chair, for the question and for raising those examples. Certainly that language is very upsetting to hear. Obviously, as an industry association, I'm not across what platforms they're on. I can't comment actually on the specific individual platforms' comment policies or with regard to that. Again, all we can do is offer an industry view. And to your question around what industry can do, Digi is always very willing to engage with government on these issues of shared interest. You know, we've mentioned the codes of practice that we are working very long hours to work on those codes of practice, and have done the same with the misinformation and disinformation code. So it is certainly something that we, you know, our vision, Digi's vision, is around you know, a thriving digitally enabled economy, but one where online safety and online privacy are protected, and we bring companies together behind that vision. And again, it doesn't mean that everything is perfect and everything is working as it should. I mean, we certainly get a vantage point into the extent of work that industry does in these issues, and the extent of work that industry does together. But I mean, conversations like this are important for the, you know, the continual improvement. But certainly, look, if there are specific suggestions with regard to, you know, what role industry associations can play, you know, we're very open to that. We do engage very regularly with the e-Safety Commissioner, particularly in the context of the codes that we're currently developing.
I'd actually really appreciate, or perhaps on notice, your response to what an industry-wide common community standards code of practice would look like, specifically with reference to abuse, intimidation, and online safety issues. Abuse, cyberbullying, I guess, is what I'm sort of specifically saying. And also the industry-wide, did you view on an industry-wide perspective on what might be able to be done in relation to rapid response of those, like rapid response of those from the industry itself, not the e-Safety Commissioner, not the government, but the industry, the relevant platforms, what more might be able to be done. And I guess I'm looking particularly at how comments, how moderation, and even how consequences such as banning could be applied to perpetrators who choose to use these platforms to abuse, to threaten, and for cyberbullying. Thank you. I know Ms Hammond has some questions, and then there may be questions from others.
So briefly, thank you, Chair, for that, and we're happy to take that on notice.
Actually, Chair, you did just cover a large part of my questions, but just picking up on that, I note that Digi has, you've developed the disinformation code. You developed that, but you haven't developed the agreed community standards code yet, have you?
Sorry, what do you mean by the agreed community standards? Is that what the Chair was just referring to just now? No, our work on code development has been on the disinformation and misinformation code, as you pointed out, but we're also working on the mandatory codes of practice under the Online Safety Act that industry associations have to develop, and that's in relation to Class 1 and Class 2 content. So if it's helpful, we can provide an overview of what's in scope for that particular code.
Yes, that would be great. Thank you.
Okay. I'll hand over to my colleague, Dr. Duxbury, who's leading that effort.
Thank you. When was Digi established?
In Australia?
Yes.
It's an Australian Industry Association, a non-for-profit industry association, as the chair. I actually would have to take that on notice because I believe it existed under a previous name prior to, I've been managing director since February 2019. I believe it's existed in its current form since 2016, but I would have to take that on notice in terms of the specifics because I believe it had a previous name before that.
Yeah, and so you're an industry representative body, correct?
We're an industry association. We work with a wide range of companies. We have 8 founding members and 4 associate members of varying sizes. Some are Australian companies, some are global.
Right. And so your primary role is to represent the interests of the industries that found you and you are members, correct?
We have a certain organisational vision that, you know, our members have gotten behind, and as I mentioned to the chair earlier in response to her questions, it is around a thriving digitally enabled economy where online safety and online privacy are protected. So those two issues are areas that we focus on, and we focus on, you know, we engage very, you know, thoroughly across a wide range of regulations in that space and others. You know, looking at making recommendations around what we, you know, are reflective of industry experience of these issues, what we think are effective and will be practical for a wide range of industry participants to implement.
So how is Digi governed? Do you have a governing board?
We don't have a governing board. We're accountable to our founding members.
Oh, okay. So you're a not-for-profit association?
Industry association, yes, that's
Industry
correct.
association. So I don't know the legalities behind that. You don't have to have a board. You just have members and you're accountable to your members.
Oh, sorry, the members form part of the board. I'm happy to take this on notice. You know, we do have a constitution. I'm happy to follow up with this. This is something that, you know, I'm looking at in terms of these structures. But yes, look, the governing board is effectively comprised of several founding members.
Okay. So how many staff do you have?
We have 2 staff.
Right. Okay. And so do you engage with the public relations arms of your founding members, or at what level, you know, like CEO level or executive level?
We engage with primarily the public policy and legal arms of those members.
Okay. When you engage with them, is there often disparity, or is there discussion and disparity in their views and approaches on various issues?
Look, it would vary, but I think that we aim for consensus in the way that we operate Digi, and so we are able to sort of move forward on things, you know, finding those areas of commonality. But no, I don't think it's you know, it's common that there are vast areas of disagreement. I think the point of Digi is really to work on areas of shared interest, and so we work hard to find sort of those areas of shared interest. And as I've said, you know, our vision is very much around online safety and online privacy, and so we do find you know, quite a fair amount of alignment across quite a diversity of companies in those issues.
Yeah, I think that you've got a vision and mission, and your values: openness, responsibility, education, and collaboration. I think is, yeah. So you're bringing it together, and you just work in the Australian field.
Yes.
So do you know why members, or I don't know whether it was Digi or the members themselves, who decided to focus on the disinformation code as the first thing to focus on?
Well, it certainly wasn't the first thing to focus on. Digi in its current form has existed since, you know, 2016, and I've been the managing director since 2019. The government in December of 2019 announced its policy in the digital space in response to the digital platforms inquiry. And in December of 2019, they as part of that policy announced that they wanted to see a voluntary code of practice in relation to disinformation. So, you know, Digi, in discussion with its members, decided that it would put its hand forward to take forward that task, and we did that over the course of 2020, and we launched it in February of 2021.
Okay, so and I'm taking a slightly different slant to the chair here, but so that was developed in response to government action. The sort of evidence that we've been receiving suggests to me that. And not surprising, they're all for-profit companies, I get that, but they don't necessarily respond unless A, it's going to affect their financial model, or B, there's government or significant public pressure to do something. Now, the chair was suggesting, why can't you do things, you know, but rightly, when there's common and acceptable standards and well-known standards, our digital companies aren't responding, digital platforms aren't responding at present. I guess my point is a lot of the digital agencies, and sorry for being so long-winded about this, have raised concerns about the level of regulation, the level of legislation, the level of attention being focused on them at present. And yet what has come to us is that they don't appear to be responding unless government does do something and gives a bit of a kick up the butt. There doesn't seem to be that proactive recognition by our digital companies that of their responsibilities.
Thank you for that question. Look, with regard to the disinformation code, this is a consistent, public, transparent framework for a wide range of companies beyond our members, or any company can adopt it, and that sort of sets certain, you know, safeguards that they're committing to adopt in their efforts. It is certainly not our experience. Not use the negative to avoid confusion. It was our experience that all of our members certainly had long-standing policies in relation to misinformation and disinformation well before the code, and the code provides that added layer of consistency and accountability with regard to those efforts. So it's certainly not the case that they were waiting for this policy or this code and then they were taking action. It's actually the case that they were all, you know, in our experience, had, you know, a huge body of work and existing work that was continuing to be refined. And, I will note that we started developing this code in March of 2020, which was, Australia's, first set of lockdowns in the face of the pandemic. So certainly the pandemic and, the rapidly evolving approach that companies did have to take to the unprecedented threats that we were all facing, certainly, I guess, codified in the code, because that was something that we were all kind of experiencing at the time. But look, it's certainly not our experience from Digi's vantage point of working with these companies that they're waiting for this in order to act. It is the case that they are all working on it in their own ways, in ways that are specific and effective to the user bases that they have, and that these sorts of initiatives are a way to sort of work across the industry and have that sort of consistency and added layer of accountability.
Yeah, I think that some of the concern is that they've all produced policies, and we've seen that there are policies out there. There's no doubting that there's policies. There's no doubting that there's public statements saying everybody's concerned about the safety and security and misinformation. The question, and it's come up with submissions, is that it's great to have a policy, but is it effective? Is it usable? Is it being enforced? And are there repercussions? I mean, what if somebody breaches the misinformation code? What happens? What if a company breaches their own misinformation code? Is there any repercussions from that?
Yeah, so in October of last year, we announced a strengthening of the code through appointing an independent complaints committee and a portal on our website through which the public can make complaints about material breaches of the code, and that's an independent complaints committee.
And so if it's upheld, what happens?
I'm sorry, I didn't catch the question.
If a complaint is upheld, what actually happens to the company?
So I'll ask to talk about the different kind of approaches that we have based on the different types of complaints that we might receive.
Thanks. So just to clarify, the way that the code works is that it sets out a series of objectives and outcomes. There are 7 objectives and 10 outcomes that the code seeks to achieve, and signatories required to commit to 2 of those, which are mandatory measures. One of those is to implement safeguards against mis and disinformation, and the other is to file annual transparency reports. And then there remain a range of other commitments that they make depending on their business model. For example, commitments around transparency of political advertising.
Okay, sorry, Ms. Duxbury, I'm just really mindful that we've got such limited time and the chair's going to wind me up soon. What are the penalties if a digital company breaches the code? If we could just get to that. The code's there online. It's good. Yeah, very transparent.
Happy to do that, to jump to that. So any member of the public can make a complaint of a breach of those code commitments by any of the signatories. The complaint is then assessed, and those complaints that are of a material nature are escalated to the complaints subcommittee to make a specific determination about those complaints. Like other self-regulatory mechanisms that are in place, the aim of this mechanism is to get the signatories to agree to rectify the breach. And so the complaints committee assesses that. Here's evidence about the issue, and then we'll seek to get a resolution of the complaint. If they are unsuccessful, then there is a remedy for the committee to remove a signatory from the code.
Okay, so that's the remedy, right? And just then one final question: who are the members of the committee? How are they? Well, no, I don't need names, but how are they appointed?
The members of the committee were appointed by Digi. They are very experienced, independent members. They have a range of experiences. We have a very respected academic who is well known for her research in this area and works with First Draft, also an organisation that's very well known for the work that it does in this area. We have a former journalist who also is a well-known consumer advocate, and a very experienced policy professional who sits on the ACAN board.
Okay, thank you very much. Chair, I will finish there. I'm not sure, did the chair just disappear?
No, she is definitely here. It's just I'm doing a hybrid combination of a phone and the video conference, but I think it just refreshed itself. Ms. Hammond, there's a question, a brief question from Mr. Simmons, then I'll throw to Mr. Kelly, then if we have time to the Deputy Chair.
Thanks very much, Chair. And thanks to our witnesses. We've been talking about protecting people from online abuse on this committee, obviously, and I'm particularly focused on direct messenger services when I ask this question, because obviously a lot of your members are moving to full encryption, most notably Facebook very soon, and law enforcement predicts that that will reduce their self-referrals from Facebook by 60 to 70%. This is referrals from Facebook of harmful or abusive messages on their platform. So the encryption is such that not even Facebook's algorithms will be able to tell when somebody is abusing somebody directly via their platforms. So my question is, what conversations have you had with your members about the move to encryption, and how satisfied are you that they have put measures in place that as they move to encryption, they will still be able to identify if somebody is being targeted and abused via their direct messaging platforms?
Thank you, Mr. Simmons, for the question. Look, the child sexual abuse material is obviously an abhorrent crime, and our members have zero tolerance for this, and it is something that they have extensive policies and procedures in place. In the interest of time, I won't go through all of that and the extensive partnerships they have to make actionable referrals for law enforcement. That is detailed in our submission. We are working with our members, but across the industry, around coming up with consistent measures under the Class 1 codes under the Online Safety Act that do cover child sexual exploitation material around, how they go well beyond just sort of the removal of this, but measures that can address child sexual exploitation material. Look, so that's one thing that Digi for its part is working on, but look, I will just say that it's from our vantage point. I mean, this is something that industry is not is entering into. The participants that are entering into encryption that we've spoken to are doing so thoughtfully, talking, having conversations around these challenging, I guess, safety trade-offs, because certainly encryption provides a level of safety around people's accounts being hacked and their intimate images being stolen, but obviously we understand the interaction with this really challenging issue of child sexual exploitation material.
No, look, I bet it's not just child exploitation. I guess, it's good that you're having these conversations, but what I'm hearing is that the platforms you represent are moving to encryption before they've put together any meaningful way that if somebody is abusing somebody via direct messaging, their messaging services that they host, that they're able to pick that up as a platform, because my understanding is with encryption, they simply won't be able to pick that up. So you're moving to encrypt without having putting in place safeguards, or at least your members are. You've been in favour of government regulations in other ways, such as defining hate speech, which you've spoken about and is in your submission. What should government be doing if these tech companies aren't going to put these safeguards in place before they move to encryption? What should government be doing to ensure that somebody is still protected? Should there be the kind of criminal offences as there is in the AVM Act for tech company executives? Should they be classified as telecommunications services? So if they're used to menace or harass, then there is greater legal avenues for somebody who is being harassed on those platforms. Would you be in favour of that kind of government regulation on behalf of your members?
In terms of what government can do in this area, I mean, I do know that there is, in the sort of national security space, an extensive kind of legal architecture that allows law enforcement to work with encrypted services in order to obtain information pertaining to criminal activities. So I think that sort of cooperation with law enforcement around those sorts of inquiries, needs to continue.
Can I perhaps just jump in here too and just point out that, the Online Safety Act contains a number of strengthening of protections, particularly for adults in relation to cyberbullying. and of course that act is yet to be implemented. Amongst the things that the Act provides for additional information gathering powers. It also provides for some new regulatory instruments, including the basic online safety expectations. And industry will be
sorry to cut you off. Sorry to cut you off. I understand all of that, but that requires that requires tech companies to be able to identify these messages. And with encryption, they simply won't be able to. And you're saying that they haven't figured out a way or had a conversation about how to help in that process, as they are currently helping law enforcement now, which will dry up when encryption happens. So you're relying then on the people who are being abused, who might be fearful of coming forward, having to come forward, because there won't be the moderation on the platforms under when they move to encryption, of them being able to identify these harmful and abusive messages, which might be pushing people towards suicide, might be pushing them towards all sorts of things.
Mr. Simmons, if I could just sort of say that I think there's the premise here that I think we should question around whether encryption means that that the platforms can't take action. I mean, we're certainly seeing that some platforms are innovating in ways to make sure that they can have actionable referrals to law enforcement on the basis of analysis of non-content signals that aren't necessarily encrypted. So I don't think that this is an impossibility. I certainly understand and appreciate the challenge, and would just say that this is in our experience, it's not that the companies are moving towards any moves towards encryption are happening sort of slowly and thoughtfully, and with these really serious challenges in mind.
Okay, well look, I'm happy to leave it there because we're out of time. But if there are those things that are taking place where companies are putting in place ways to break the encryption so that they can view harmful messages, I'd welcome you providing that information in writing so that we can understand how the industry is going to tackle abuse individual to individual on their messaging services in the age of encryption.
Thank you very much. Thank you. Thank you very much, Mr. Simmons. I understand that Mr. Kelly has some questions, and in the interest of time, the Deputy Chair has indicated he will post the rest of his questions on notice, and in the interest of time, I will also do the same. Questions from Mr. Kelly.
Yeah, thank you. Twitter is a member of your group?
Yes, that's correct, Mr. Kelly. Twitter is a founding member of Digi. Okay,
I've just gone online on Twitter this morning, put in a certain person in my electorate's name, and it says, there's a link here, it says from Twitter, this person, I won't say what his name is a massive F-head, with the word F spelt with the 4 letters. And when you click on the link, it makes a false and defamatory statement, and it says, suck SC, with S being the 4-letter word and C being the 4-letter word. How does something like that pass the current algorithms?
Look, I can't speak to that specific example for Twitter. I know that Twitter, I believe, are appearing before the committee tomorrow. Look, Digi can sort of provide an industry view, but certainly, I mean, the companies that we work with have platforms and policies in place and reporting mechanisms, but I can't speak to that specific example.
This particular example we're talking about, it's had 435 retweets and 1,371 likes. It was posted on the 17th a few days ago, and it's still there. I just can't understand. Isn't this a massive, massive failure from these platforms if something like that is enabled to be put up on their platforms, remain there for over 3 days, and have thousands of likes?
Look, Mr. Kelly, without knowing the specifics of what you've seen or that specific example, and without having context,
the specific part, it says this certain person is a massive F-head. Now, either that's the specifics. So, do you think that's acceptable or not?
Look, I can't make a comment on that specific example without seeing it.
So if I'm clear, you're not prepared to say that Twitter posts something saying a certain person is a massive F-head, and when you click on the link to it, it says suck SC. You're not prepared to say that's offensive and should not be up there. Is that what you're saying?
Look, I think that platforms look at these issues with a range of things in mind. I don't know what that's in relation to, but there are certainly questions of.
Do you think there's an acceptable circumstance? You think that in certain circumstances could be acceptable?
Look, I think when companies make policies, they need to make considerations of a range of things, and that is, Australians'
No more questions, Chair. This witness obviously has a different community standard to what I do and most of my constituents do, and I think what most of Australians have. If they're not prepared to say that's unacceptable.
I'll take that as a comment, Mr. Kelly. Thank you very much. To our witnesses, can I thank you very much for appearing and also for your willingness to be available to us at a later time. I would just request that any additional information that you have been asked to provide, that you please forward it through to the Secretary by the 3rd of February 2022 to advise that you will be sent a copy of the transcript of your evidence and that you will have an opportunity to request corrections to transcription errors. And I'm just going through actually the last interaction, and I'd just like to make it very clear for the purpose of the record that I'll be taking that last statement by Mr. Kelly as a comment and only as a comment and will be disregarded for the purposes of the report. And I now am just going to indicate to the committee that we will suspend briefly to the Secretariat. Can we resume again at 2:30? Is that timing acceptable for our panel?
Chair, the panel members are already online, so they're good to go whenever you are.
Okay. In that case, what we might do is just suspend briefly for 5 minutes and then commence again. Thank you.
Thank you, Chair and committee members, for the time today.
Good afternoon. I understand from the Secretariat that we have our witnesses online. So can I thank you very, very much for your attendance and your time here today. We do appreciate it. I declare that we will resume the Select Committee on Social Media and Online Safety. And I now welcome, as part of our panel discussion, Edward Santow and Michael Douglas to give evidence today, and ask that for the Hansard record for you to each state your full name and the capacity in which you appear before the committee.
Edward Santow, Industry Professor, Responsible Technology at the University of Technology, Sydney.
Michael Douglas, Senior Lecturer at the University of Western Australia and Consultant at Bennett & Co in Perth. I make this submission in my personal capacity.
Thank you very much, Mr. Douglas. I just some technical matters before we begin, to advise that although the committee does not require you to give evidence under oath, that I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And Mr. Douglas, I note that you indicated a previous submission, and we thank you for that. Mr. Santow, would you like to make a brief opening statement before we proceed to our usual mechanism is by way of discussion and questions from the committee?
Thank you, Chair. I'd appreciate that opportunity. For 5 years until July, I served as Human Rights Commissioner and led a major project on human rights impact of new technologies, especially artificial intelligence and algorithms. That project involved extensive public consultation and culminated in the Australian Human Rights Commission's Human Rights and Technology Final Report, which was tabled in Parliament in May 2021. Some of the key conclusions from that community consultation and the Commission's recommendations are relevant to this inquiry and I'll draw attention to 3 key issues, if I may, noting also that as I've finished my term as Commissioner, I of course no longer speak on behalf of the Human Rights Commission. First, the most frequent concern I had in the public consultation process that I led was that people said, in effect, I've just realised that my personal information can be used against me, especially online. That is, there's growing community concern that too many companies are collecting individuals' personal information and using that information in ways that cause harm to those individuals. The Commission recommended better enforcement of existing laws that protect against discrimination and other harms, and the Commission also recommended the government introduce a statutory cause of action for serious invasion of privacy, something that Australian law reform bodies have repeatedly called for over 2 decades. Secondly, this select committee inquiry is considering the effect of algorithms used by social media platforms. To be clear, there's nothing inherently unlawful or harmful about the use of algorithms. The problem arises where an algorithm deliberately or inadvertently is used to cause harm. That problem is compounded where the organisation operating the algorithm cannot be held to account for its actions. The Commission recommended important reforms, especially to require companies that use AI to require companies that use AI in their decision making that affects individuals' legal or similarly significant rights, that those companies should notify any affected individual, and also to ensure there's no accountability gap when a company uses AI. Finally, this inquiry is considering further reform to keep Australians safe. A key recommendation from the Human Rights Commission's report is that the government should establish an Artificial Intelligence Safety Commissioner. That new role would draw on the successful model introduced by former UK Prime Minister Theresa May, namely the UK Centre for Data Ethics and Innovation. It would also complement the work led very ably by Australia's eSafety Commissioner. So what an Australian AI Safety Commissioner would do is 3 key things. One, regulators face an extraordinary challenge to respond to new threats that arise because of new technology. The Prime Minister has said on a number of occasions that the rules that apply in the real world should apply equally online. I agree, but that vision can be achieved only if Australia's regulators are supported in responding to the massive technological transformation happening around them, something that's been described as the 4th Industrial Revolution. The proposed AI Safety Commissioner would work with existing regulators to build their technical capacity so that they can exercise their community safety powers amid this unprecedented rise in AI. 2, an AI Safety Commissioner would be an independent source of expertise for government, monitoring and investigating developments and trends in AI, especially where those trends can threaten human rights. That would help government respond in a timely way to new threats and opportunities in the space. And 3, the proposed AI Safety Commissioner could provide guidance, including to social media companies and others, in how to fulfil their legal and ethical obligations when it comes to the use of algorithms. I'm happy to answer questions, but as I communicated to the Secretariat, many of the terms of reference for this inquiry go beyond the Commission's report and beyond my expertise to provide evidence, and I have, unfortunately, a hard stop at 3 o'clock this afternoon.
Thank you very much for that. It's a really interesting concept, an Artificial Intelligence Safety Commissioner, I have to say. But when I'm thinking beyond the scope of just the online safety inquiry and into the realm of artificial intelligence itself, way beyond the scope of this inquiry, of course, I mean, it's got some very, very interesting applications, particularly for the future. If I go back, and I would invite a response from yourself and then perhaps Mr. Douglas as well, if you have any additional comments. If I go back to some of what's become, I feel like I keep saying it over and over today, but I've just been really interested in what seems to be a disjunct or a mismatch. So algorithms can be used for great good. If I think about my own, I've said this before, if I think about my own user interaction with, say, Instagram in particular, I'm finding some great helpful information that gets targeted to me. I'm really appreciating it. I'm using it for my own research and benefit and all sorts of things. So I know it can do great good. I know as well that if I'm looking for a particular product that, you know, all of a sudden I get targeted advertising that can be extremely helpful, but it's very targeted, it's very specific. And then I also know that, there's been a lot of talk about disinformation, misinformation, moderating, automated moderating, which is, so all of these things that are happening at advanced or varying degrees of advanced levels. And yet when it comes to, and I have cited, I'm not going to do it again, I've cited just a few comments. They're by no means the worst, I have to say that. Just a few comments. I've not been able to get any clear, consistent picture of what online platforms believe artificial intelligence could help do to moderate or to help address online harm. What do you think is the reason for that? Is it just simply a lack of willingness? Because I'm sure the technology is there. Is it a lack of willingness? It's hard to imagine that community standards, with the ordinary person test, which of course changes as society changes, but the reasonable person test, it's hard to imagine that that's really difficult to quantify. So just sort of looking at the barbecue conversations around the nation, is it that hard for artificial intelligence to be able to look and moderate these things? And what would an artificial safety commissioner, if that was to be implemented, do in terms of addressing online abuse and proactive removal of online abuse, threats and cyberbullying? Sorry, it's a very long question.
Do you want to take that first, Mr. Douglas? Then I can jump in on the end.
No, I'll defer to you, Ed. I was just going to mention, Chair, if possible, I'd like to make a brief opening statement as well at an appropriate time. Thank you.
Of course. I can come back to that.
So I guess to take your question, Chair, one way of looking at this is to flip that question on its head, and not to kind of ask or try to answer what for us would be an impossible question, which is whether a number of technology companies have the kind of capability using AI to fully automate a content moderation process, which would be quite a challenging task. But flipping that question on its head would be to say there are certain activities that a social media company, let's say, has to be in control of. One is defamatory content that is posted on their platform. Another is racist abuse and other very offensive abuse that is posted online. And fundamentally, it is those companies' obligation to use whatever kind of old and new technology that they need to be able to put their hands on in order to fulfill those obligations. That is their obligation. If they choose to really lean in using artificial intelligence to try and achieve that goal, and it works, good luck to them. But if they choose to use AI and it's simply not effective, then they have to wear the consequences for that. And so that's really how our laws tend to work. They set an outcome to be achieved, namely you create, in this case we're talking about here, you create an online space that is safe, that does not promote defamatory and other highly offensive conduct or content. And it's up to the companies that operate in that space to make sure that they choose the best way of achieving that outcome. I think the second part of your question was, what about the role of an AI Safety Commissioner in this space? I think one of the key things that an AI Safety Commissioner could do is provide some guidance to those companies and say, well, look, there are a number of ways of doing this. Here are some best practices that we've been able to glean from Australia and around the world in order to achieve that. You can kind of find your best way of doing it, but here is some advice.
Thank you. Mr. Douglas, would you like to add to that? And then, of course, I'll go back and formally invite you to make that opening statement, and I apologise for overlooking that.
No worries. Other than to say that I think the idea of an AI commission is a good idea, I think the more resources from the federal government dedicated to making the online space safer, the better. And I think having statutory agencies with a mandate to look at the technical side of things is better than what we have now. So I commend that idea. Turning to my opening statement, which touches on some other issues, I'll start by saying thank you so much for affording me the opportunity to speak today. This inquiry considers important issues and touches upon diverse areas of law and, in turn, diverse law reform activities. If online harm is simply understood as harm caused via the internet in some way, then online harm may amount to physical or mental harm, which are the subject of the Online Safety Act. It could amount to harm to dignity, which often underlies privacy laws, among other things. Or it could even comprise economic harm, for example, where a business person has their reputation damaged online and it has a consequential impact on their business. These issues have been the subject of various federal and state-led law reform inquiries. Some of them, like the defamation reforms commissioned by the Council of Attorneys General, those activities are still ongoing. Which brings me to the so-called anti-trolling legislation. There are aspects of the legislation that I do support, and I'm happy to speak to those in a moment, but overall the legislation is problematic for a number of reasons. First, as I mentioned in my submission to this committee, trolling is not an appropriate subject for law reform. Not all trolling is harmful. Some is silly, some is even good for democracy, like the satire of the Batuta Advocate. Online harm is an appropriate subject for law reform, but in a liberal democracy and one that values a bit of larrikinism, trolling is not. Second, despite its title, this draft bill is not about trolling at all. It's about defamation law. In my view, the bill will do absolutely nothing for young people suffering harm online. The branding of the bill is misleading. Third, and perhaps most importantly, the bill advances a number of problematic policies. The bill will actually undermine the rights of many people who suffer harm online, that is, in particular, reputational harm, to achieve a just outcome. What it will do is increase the rights of commercial media companies to create a moral hazard. It will undermine moderation of comments threads on Facebook content, much of which leads to commercial incentives for these media companies. The result will be nastier comment sections, more harmful defamation being posted in comment sections. And ironically, despite the goal of holding online platforms accountable, this bill will actually increase the rights of foreign companies behind online platforms like Facebook in certain important respects. In my view, this bill is incoherent. Fourth, the purported unmasking of trolls is also disingenuous because media lawyers can already do this, and indeed we have been able to do this for decades. There's a case called Norwich Pharmacal, which produced what's known as the Norwich Pharmacal Order, by which you can go to court and get an order unmasking a troll. We've had that ability for a long time. We can also use pre-action or preliminary discovery or issue subpoenas. The firm I work at has used these mechanisms to unmask people who try to be anonymous and hurt other people. So, and for those who can't be unmasked with those pre-existing tools, because, for example, they're behind a proxy or they're using Tor or ProtonMail or whatever other technology, the bill will make absolutely no difference. And further to that, anonymity can even be a good thing. Reading Hansard, I noted that this committee has been looking at the rights of sexual abuse survivors, which is, of course, important. Well, those survivors can blow the whistle through the benefit of anonymity. So this may actually undermine the ability of people to protect themselves from online harm. If the Commonwealth does want to dabble in defamation law reform and improve online safety, I have a few ideas. For the sake of time, I'll pause now, but I encourage you to ask me about those other ideas. Thanks again for having me.
Thank you very, very much. Questions from the Deputy Chair.
Thank you, Chair. Rest assured, I have questions for both of you. They don't have much of an overlap between each other, though, so don't feel offended. I'm going to deep dive with one person. I will come back. But Mr. Santer, I just wanted to start with you. One of the issues that we've been asked to consider as part of this inquiry's work is the issue of age verification and assurance techniques. Other jurisdictions that have looked at this have considered the use of facial recognition technology as part of these age assurance technologies. sometimes that's been mandated. That's a common application of artificial intelligence technologies, is to do this facial recognition work. I just want to ask you a high-level question. The eSafety Commission has really emphasised to this committee the importance of safety by design, so that when we're building systems, when we're building not just applications, but building systems to engage with content, that it's designed in a safe way from the beginning. I just want to get your observations on the way that governments in Australia, including the federal government, whether they've met that mark on safety by design in the way that they've considered the use of facial recognition technologies for things like age verification or identity verification, for example.
Yeah, look, Australia is, I guess, one of many jurisdictions where government as well as the private sector is increasingly wanting to use facial recognition, if I can call it that, for a range of purposes. So one is to verify or identify someone, and it gets pretty exotic pretty quickly. So it could be trying to assess someone's age, right up to assessing their emotions and so on. And what we have to accept is that there is a significant gap between what we see on TV in police shows and so on, and what is the reality of what can actually be achieved, particularly when you're identifying a person in a crowd or from a large database, or if you're trying to assess characteristics about that person, including their age. The best technology is often less accurate than anyone you or I are likely to know who is not blind. So it can be subject to very, very high rates of inaccuracy. And that inaccuracy is not spread evenly around the community. So, for example, we know people with dark skin, women, people with physical disability tend to be subject to errors when it comes to this technology much more frequently than, if I'm going to put it crudely, someone who looks like me, a white middle-aged man. And so those kind of elements of the technology need to be understood and applied in two really important ways. And really getting to the nub of your question now. The first is in how government actually uses the technology itself. So it needs to make sure that whenever it uses the technology, it's using it in a way that it is absolutely reliable, and at the very least is no less reliable than the alternative means it has available to it to perform a legitimate task. So it doesn't work to use a technology like facial recognition if it's going to lead to errors more frequently than an existing technology or human that is itself imperfect. Okay, so that's the first thing. The second thing is we don't have law in Australia that is dedicated to facial recognition. We've got some very limited privacy law. We've got some other very limited laws of general application, but we have no law that specifically deals with facial recognition or frankly, other biometric technology. The current government introduced a bill, the Identity Matching Services Bill, that was an attempt to deal with this, and that was important, but it was a flawed bill. And the Parliamentary Joint Committee on Intelligence and Security unanimously decided that it should be significantly rewritten. It's been several years since that Parliamentary Joint Committee reached that conclusion, and we still don't have legislation, and yet we do have an increasing use of this technology. So I think that's very concerning. So we clearly in Australia need more effective law that encourages good innovation using facial recognition and other biometric technology, but sets clear red lines that prevent harm, misuse, and inadvertent error.
So in the absence of a specific legislative framework dealing with potential harms from misuse of biometric information, biometric data like facial recognition data sets, what's your view on regulations requiring the use or permitting the use of of facial recognition technology as part of age verification processes by private sector operators?
I think if you don't have proper mechanisms in place, legal mechanisms in place to essentially prevent misuse and overuse of the technology, then there is no social license to do that. We've seen that a number of large technology companies have, in a sense, been ahead of government, a lot of governments, including Australia's government, in saying, well, we need to pull back in our use of facial recognition. That's well understood. What is less well known is that doesn't mean that companies aren't using facial recognition. What it means is that there's a number of other companies that the Australian public generally would never have heard of their names before that have kind of entered that space. And some of those companies are less concerned about their reputation. And we've seen, with the Office of the Australian Information Commission, a recent determination in November last year in respect of Clearview AI and its use of face matching or facial recognition, that those companies sometimes are not acting in accordance with Australian privacy and other laws.
Clearview got a very sound letter, so I'm sure they've learnt their lesson there.
I mean, the point that I don't want to kind of jump in.
That's being facetious for the benefit of Hansard.
I understand that, but just drawing that out, unless you empower the regulatory ecosystem to take really firm action that is there to uphold Australians' basic human rights, then all there is that sort of non-binding opinion, and that's not sufficient, I think, to protect Australians' basic rights.
Spreading the love around, Mr. Douglas. I note from your submission the point you make that despite the name, the anti-trolling bill is not about trolling at all. It's about defamation law, and that's something that a number of witnesses to this inquiry have I think, rightly pointed out. It's also significant under this draft bill, isn't it, that in order to engage in the unmasking tools proposed in the bill, that you need to initiate defamation proceedings?
Yeah, it is. And in my view, one of the reasons I don't like this bill is I have in mind those genuine plaintiffs. So sometimes defamation law is abused by rich and powerful against people that criticise them. I'm not a fan of it. I do like defamation law, however, when it's regular people with small businesses or just regular people who are getting legitimately abused in a way that actually harms them, and all they want, and 9 times out of 10, is to have the content gone. They're not there trying to make money. Defamation isn't an economical cause of action. You don't see someone in defamation to make a fortune because you probably pay a lawyer as much as you'll get back. What they actually want is the content gone ASAP. And by ASAP, I mean right away, because once it's online, it spreads. There's countless dicta in the law reports about the propensity of defamatory matter to spread through unknown springs and pop up in unhidden wells. Well, the modern version of that is known as the grapevine effect. So once something's online, people share it, it goes nuts. So removing the ability to go after the intermediary, so the company behind Facebook at the outset, removes one of the most effective ways to get the content removed quickly. So for Facebook and those sorts of entities, if you just ask it to be removed, they're unlikely to do anything. But if you say, this is defamatory and we're going to issue a writ and join you as publisher, then they're more likely to act quickly. That's an imperfect solution because it's effectively only open to rich people that can afford lawyers. But nonetheless, it's a solution that this bill would remove. So I think rather than forcing people to go to court and engage lawyers like me and spend what could amount to the cost of their house on lawyers, there should be mechanisms by which a person with genuine concern can have defamatory content removed quickly and cheaply or for free. That's.
We may want to see how the provisions in the Online Safety Act dealing with that operate before legislating again.
Absolutely. And sorry to interrupt, Mr. Watts. I was just going to say, in one of my proposals for how to make the law better would be just do nothing. Let the Online Safety Act do its thing for a year or so, and then maybe have an Australian Law Reform Commission referral where they look rigorously at the impact of the Act and take submissions from a broad range of stakeholders on how it's actually working. I think it's too soon to mess with law reform that's so fresh.
So just give us a ballpark. There are a number of steps before you get to initiating proceedings in the federal court. Just for someone who hasn't gone to law school, if you're wanting to get a concerns letter drafted, what's the kind of a ballpark cost that you might expect to confront just to get to that point?
It depends on who you're talking to, what sort of firm. So at one end of the spectrum is the firm I work for. We often act for plaintiffs, where we specialise in defamation, among other things. Could be looking at thousands of dollars to several $1,000s. But there are a number of firms that are seeing that defamation can be lucrative, and they're trying to create, I guess, cookie cutter concerns notices that are a lot cheaper, maybe a few hundred. However, in reforms that were implemented in most Australian jurisdictions last year, it's no longer the case that you can just sue someone. Now, I think it's a month after the concerns notice is issued, at least a month goes by before you can commence proceedings through issue of a writ or an originating application in the federal court. And to have that writ issued, again, is a filing fee that'll be several more $1,000. All the way you're getting advice from lawyers who charge by the hour. It's going to be a significant amount of money. And to take a defamation case all the way through trial, where a media company is actually fighting it, or, for example, in a matter my firm worked on where we got indemnity costs, it was over $1 million. So who's got the money for that? This is not something that helps working families. This is something that helps politicians and celebrities and business people.
And for those that have indicated this might be a useful tool for dealing with trolling of children and young women. Have you had any? You're a plaintiff lawyer. Have you had any clients that are?
I don't know of a single case of a defamation plaintiff that was a kid. I'm sure they exist somewhere. I actually looked up a book because I saw this discussed in Hansard. I was like, are there any cases? Gatling on libel and slander says that the general principles of standing in torts apply to defamation. So proceedings would have to be commenced by a guardian ad litem, which means that it's the only time this would ever happen is when you have an oligarch who is upset that their kid got slagged off on Facebook and decides to commence proceedings on their behalf. This is not helping anyone other than one kid in 50 years. I don't even understand where this came from.
Sorry, Chair, we can't hear you there.
Thank you. I apologise. I've been talking to the screen. If I could just if I could just interrupt for a moment, just to ask a question related.
Sure.
That's okay, Deputy Chair. Thank you.
Of course.
Mr. Douglas, I'm just interested. Again, I'm not a lawyer. I'm listening very carefully to your comments and observations, and if you'd seen any of my earlier questions, you'll sort of see I'm really, one of the things I'm interested in today is this whole area about abuse, removal, identification of abuse, how that's dealt with. I guess if some of these comments, you know, the unmasking of some, and some of the comments are horrific, and even before I was a Member of Parliament, I will say and disclose I was subject to very vile, very horrific, highly defamatory comments all online, and I was an ordinary private citizen doing a very ordinary, you know, role, and so I have first-hand experience of the lived impact of what those comments can do. I didn't have any recourse. I had no way to be able to clear my name or to go and, you know, this was some years ago, I guess. So as somebody who's sort of been in the situation, I don't mean if you've got, you know, lots of money and all the other things, but if you didn't go through a court process, how would you decide what was defamatory? So if this legislation was not to proceed, do you have sort of a way through? Do you have an alternate? Well, like, what are you sort of proposing instead?
Yeah, well, I put a couple of different ideas in the submissions I've made to this committee and also to related inquiries relating to privacy law reform. I think the right to erasure contemplated by the discussion paper published by the the Attorney General's Department late last year, that you may know is in the ballpark of what European data protection and privacy law has had in force for some time and was reaffirmed with the GDPR in the last couple of years. And under that scheme, if you make a complaint to an intermediary like Google and you say, this search result relates to something I did as a kid, it's 20 years later, it's not relevant anymore, Google, you can make a complaint for free, you don't have to go to a lawyer. It's Google's obligation to assess it according to the standards of law in force in Europe, in the EU rather. And then Google will remove it if they think it's objectionable. I think we shouldn't necessarily support that regime wholesale, but I think that sort of regime is what I'm proposing in the alternative. I think the Online Safety Act, I think it could do a really good job. I think the fact that your government has looked at that is a good thing. You consulted with a lot of different people, but we just don't know yet if it's going to get the job done well. So sometimes the best strategy is just to not do something. I think this could be one of those times where just see how the Online Safety Act works and at the same time give a right to erasure serious thought. I contemplate in that article, which I annexed to my submission to your committee, the idea of a right for defamation to be forgotten. That was me having a brainstorm. Enough, but nonetheless, it's something you might take submissions on from the broader public.
Thank you very much. In the just given that Ms. Hammond does need to leave very shortly, with the Deputy Chair's indulgence, if I could just interrupt him once again, noting that this is his place. Questions from Ms. Hammond?
Thank you, and thanks, Deputy Chair. I don't have all that many questions, but this question is to Mr. Douglas. In your submission, you referred to the jurisdictional veil. Could you just explain that? Because I think it's a really, really important point.
Thank you, sure. So you may be familiar with the idea of a corporate veil, whereby a company can shield itself from liability, so protect itself from being sued by having subsidiaries and saying, well, this subsidiary is in charge of that. And so, for example, you may be familiar with the asbestos cases of the last few decades where people who suffer mesothelioma struggled to get an effective remedy because it was a corporate structure and they couldn't sue the right person. Australian courts have pierced that veil, so the language of piercing the veil usually relates to that sort of corporate context. What I mean by jurisdictional veil, and here I'm evoking some language used by Professor Mary Keyes, who's at Griffith Uni and is an expert in conflict of laws or private international law. Jurisdictional veil denotes a situation where a business that operates at a global level puts subsidiaries in different jurisdictions in order to shield itself from litigation risk. So you see this already with tax havens. You've got companies incorporated in British Virgin Islands. Base erosion and profit shifting is a result of this phenomenon. But we also see it these days with internet intermediaries homing themselves in jurisdictions like the United States, even though they're deriving massive income from jurisdictions like the Commonwealth of Australia, which means that when you want to sue someone over something that Australians have written in Australia, you will probably need to sue an entity based in the US. And the difficulty of that is that under Australian law, the authority of Australian courts is territorial, which means that its authority to decide is limited to the geography of Australia. There are rules called long-arm provisions, which allow you to get the court to go after someone overseas. In most Australian courts, you'll need to make an application for service outside the jurisdiction. And long story short, some internet companies like Facebook Inc., Google LLC, Twitter Inc., etc., have fought even that preliminary stage on the question of whether an Australian court has even authority over them. I think that is abhorrent. It's taking all the benefits of deriving massive revenue from Australians without taking the responsibility that comes with that. And I think that's something that this committee could meaningfully look at.
Yeah, actually, we heard evidence earlier this morning from one of the companies that said, oh, yes, we try and show respect to Australian law. And it's just like, well, actually, you know, the rest of us have to abide by Australian law.
Yeah.
And, you know, yeah.
Ms. Hammond, would it be helpful? I might be able to give you a practical example of what Michael Douglas was just describing, if there's time.
Yes.
So prior to being Human Rights Commissioner, when I was acting as a lawyer in a community legal centre, we were approached by a number of Indigenous clients, and they were concerned about a practice which, I hasten to say, no longer exists, that then existed on Facebook, where an individual, when the company became sort of aware that an individual user died, they did what's known as memorialising their Facebook page, which sort of created this carousel of photographs of the individual and others, you know, that were part of their Facebook page. Now, for Indigenous people, that can be hugely harmful for cultural reasons. And they tried to engage directly with Facebook to get them to stop that practice after, you know, an Indigenous person had died. And it was incredibly difficult. We, as a community legal centre with, you know, relatively well-resourced, literally just finding a part of the company that was willing to take responsibility to have an informal negotiation, let alone when proceedings were commenced, was exceptionally difficult. And it shouldn't be that hard. It should be that an individual, if they have a complaint of that sort of nature, that they should be able to reach an informal resolution much more simply with be it a big social media company or any other company.
Yeah, thank you. That's a really good example. I am actually got legal background, so I am also familiar with the costs, and you know, the community legal centres do actually step up in a lot, but but their ability to do is limited. But speaking on behalf, the legal system is out of the reach, not just in defamation, but let's face it, the legal system in terms of costs, and we can't attribute that all to government, and we can't just blame lawyers. Let's just say the legal system is inexpensive, but it's also an emotionally taxing and process to engage in. Most Australian parents, and we've got submissions to this effect, just want to know that if their children engage online, that there are mechanisms in place that they're safe, and that there's a quick and easy steps or things to do if they're not safe. One of our witnesses 2 days ago, Ms. Noelle Martin, actually didn't support the Online Safety Act. She said it didn't go, from recollection, didn't go far enough. She also wasn't in favour of the Trolling Act. I think she mentioned something about criminal sanctions and or being able to pierce the veil and actually get it direct, or maybe that was my suggestion, like we'd sometimes do in work health and safety. But effectively, and I'd like both of you from a legal point of view, let's try and think not about legal actions, but about what we could do in terms of regulation and enforcement to make companies just be proactive in this space, to provide that level of assurance so that people don't have to go out to the legal system, that there are other steps first.
Yeah, if I may jump in. One way you can do it is say that if this sort of content is on your platform, or you could say you need to have rigorous systems in place, and for to have those systems in place is a civil penalty provision, and it could be a proportion of revenue derived from Australia. I think one issue with the current regimes is that although damages or fines may be significant from a human point of view, not from a Google or Facebook point of view that's dealing with many billions of dollars. So I think if there were significant civil penalty provisions, which basically gave them a financial incentive to have a system that created a just outcome from a utilitarian perspective, I think that might help.
Yeah.
But I'm not sure if I share Ms. Martin's view on the Online Safety Act. I think it's too early to tell. And that's why I keep coming back to, I think it ought to be reviewed after we've actually seen how it works.
Okay. Now, I hope I'm not misquoting Ms. Martin there. That was my recollection. But, yeah, I think that she had concerns across. Yeah. Did you have anything to add there, Mr. Santow? If not, I will pass it to the chair. Thank you. Thanks, Chair.
Thank you, Ms. Hammond. I am mindful of time, including of Mr. Santow's indication of his need to depart. Deputy Chair, would you like to ask further questions or place on notice?
Sorry, struggling with the technology, Chair. Thank you.
Thank you. Are there further questions? If not, I will request that committee members place further questions on notice. I'd very like to thank both witnesses for attending today and for the thoughtful discussion that we've actually had. I found that to be very interesting and appreciate both your perspectives. If you have been asked to provide any additional information, please would you forward it through to the Secretary by the 3rd of February 2022. Also to advise you that you'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request a correction to transcription errors. Thank you again for your time, your attendance and your willingness to appear before this committee. We do appreciate it and wish you all the best for the rest of your day.
Thank you, Chair.
Thank you very much.
And I'll just confirm with the Secretariat that we have our witnesses for Reset Australia online.
Yeah, that's correct. They're both they're online now.
Lovely, thank you. Well, we won't suspend. We'll just move straight to our next witnesses, and to thank you very, very much for appearing today. We do appreciate your time and your contributions, including your submission. So I now formally welcome representatives of Reset Australia to give evidence today and ask you that for the Hansard record for you to please state your full name and the capacities in which you appear before the committee.
Hi, my name is Reese Farthing and I'm the Director of Data Policy at Reset Australia. And my colleague Dakshayani is with us.
Hi, I'm Dakshayani Suryakumaran. I'm the Director of Tech Policy at Reset Australia.
Thank you very much. Although the committee, just some formalities to start with, the committee does not require you to give evidence under oath, but I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I note that you have made a submission to our inquiry, which we have received and has been published on the committee's website. I'd like to thank you for your detailed submission to our inquiry, and just to indicate that we're happy to have you either provide an opening statement, or if you would also like, we can proceed straight to discussion and questions from the committee.
No, we'd love to give a short statement and summary if we could.
Sure, go for it. Yep, of course.
We'd love to start by just saying that myself and my colleague Dakshayani are really thankful to the committee for having us here today. We're really delighted to be giving this evidence, and we're joining you from Gadigal Mat. I think from our point of view, when you talk about tech regulation in Australia, it's quite often talk about what we don't have, what we need, and indeed that's the perspective that we're talking about. But it's worthwhile starting from a position that highlights that Australia really has been world leading in a lot of ways when it comes to regulating big tech for safety. Having worked in the European context over the last few years, it was clear that a lot of the first moving developments in this regulatory space were coming out of Australia. And this includes some of the world's first online safety regulation with the Enhancing Online Safety Act way back in 2015. And it also included setting up the world's first online safety commissioner a couple of years following that. Then we look at, the ACCC's 2019 genuinely landmark comprehensive inquiry into digital platforms that looked at data, safety and competition practices before, the global antitrust movement gained the momentum that it currently has. And more recently still, we look at the News Media Bargaining Code, which has really cut a path that a lot of jurisdictions are now seeking to replicate as well. So Canberra really has been carving out a new policy path in a lot of ways. And while this path has been incredibly helpful for Australians and indeed for policymakers from around the world to look at and build on, it's becoming clear that a pivot from this approach would be beneficial now. And our submission framed what we thought the pivot ought to look like. And Dak Shahini, I think, is going to summarise that for us.
Yes, as Teresa Farthing mentioned, I'm also joining you from Gadigal land today. There seems to be a consensus building around the need for a more comprehensive regulatory response to the social media industry. For instance, we actually concur with industry group Digi's statement that Australia does need a unified and broad framework, similar to what's happening in the EU through the Digital Services Act and, of course, the UK's Online Safety Bill. So as the federal election looms, we really need to consider how Australia is not immune to the unprecedented power of big tech. And if the equivalent of, a major disinformation campaign were to take place or a foreign interference operation, recent regulatory developments would not afford our democracy any greater protection than what we had in 2019. So in line with this, Reset Australia has proposed a policy vision with 5 key pillars, and just want to briefly talk through those now. So the first of those pillars is platform accountability and transparency. So this would require a suite of upstream duties and obligations on platforms, as well as transparency measures that would require platforms to share data with regulators, with accredited researchers and civil society organisations. The second pillar is the need to target around risks that are across the systems and processes of platforms. So this means expanding our current focus on content moderation. Obviously, that's a very critically important focus, but expanding that to also include upstream risks that include and incorporate algorithms and platform design decisions. The third pillar of the regulatory framework we're proposing is the need for it to be comprehensive. So taking a piecemeal kind of sector by sector or issue by issue approach is not going to suffice in the current digital world that we all know is deeply interconnected with data circulating globally. The fourth pillar of the framework is community and societal risks. So, we're all aware that marginalised groups in particular often suffer from unique and disproportionate harms when it comes to social media platforms. And societal risks that are critically important mean things like, COVID misinformation or electoral disinformation that may disrupt democracy. So the need to focus on risks above and beyond the individual user level. So the fifth and final regulatory pillar is that we need strong regulators and enforced regulation. And so this really refers to the fact that the risks posed by big tech really necessitate us to move beyond self and co-regulatory models that we have relied upon and that haven't adequately reduced the risks. So we'd like to really see a pivot towards primary and subordinate legislation and also regulators that are strong, well-resourced and joined up. Thank you.
Questions from the Deputy Chair, and can I thank you for that thoughtful opening statement. Questions from the Deputy Chair, and then we'll go to Mr. Simmons.
Thank you for that, and thank you for appearing before us today. I just want to jump into one of those pillars that you were talking about in the transparency space. It's been a topic of a lot of conversation through the hearings today and indeed in previous hearings. One part of your submission in particular, you state that, quote, part of the problem of making social media safe is that legislators, regulators, researchers and civil society often do not know enough about the specific mechanisms of how platforms work nor their consequences. Requiring transparency through, for example, algorithmic audits and impact statements could help remedy this. Now, as you've discussed, in the UK's draft bill proposes information gathering powers. EU proposal's got mandatory algorithmic audits. There's a proposal in the US Congress about authorising the FTC to have this information gathering powers. Do we have adequate regulatory structures in place today, or regulatory institutions in place today, to both impose these kinds of transparency and algorithmic audits on social media platforms? And if not, what are the kind of institutions we need to be building to do this kind of regulatory intervention effectively?
You can go first, Ruth, and I'll jump in after you.
Okay, AJ, you sure? Yeah, look, I mean, I think, the short answer is no. I don't think that the Australian regulatory framework at the moment has enough strong requirements around genuine transparency around the systems and processes and the risks that those systems and processes generate. We have some accountability requirements that look at content moderation, and also, reporting requirements about how that content moderation system has operated. But if you move sort of beyond the content space, while fully acknowledging that the basic online safety expectations and the codes that are being created under that haven't yet been released, we haven't sort of seen them in their fully operational form yet. They may have some of these requirements, but right now, we currently don't have those. And actually, when we look at, international examples from the rest of the world that are sort of cropping up, those sorts of requirements are almost key in a way to enabling both legislators and regulators to understand the nature of the risks that these platforms are creating and tweak their regulation to match. And so the sorts of regulatory frameworks we need to do that include new legislation, new regulation, but also new regulatory powers and better funded regulators. I think one of the things we mentioned in our submission is that a lot of our regulators comparatively are smaller and less well funded, and actually for them to be able to step up, contain and really hold these companies to account and review their transparency reports, really demand that level of transparency and make it mean something. We need to look at our regulatory framework and provide the resources and skills for them to turn transparency into accountability.
Just to add to that, I think the mis and disinformation space is a particularly pertinent example given the looming election. And I guess, looking at how that's currently operating with a voluntary code that's opt-in through transparency reporting that doesn't have kind of clear KPIs or metrics, and then the kind of committee that's charged with that is meeting on a 6-monthly basis. There's no clear kind of compliance mechanisms or penalties in place. So, given the scope and scale of the problem that we're dealing with, it's quite clear that, ACMA is not currently well set up to, and the regulatory framework around it, and the fact that the code is voluntary is certainly not adequate. And we're seeing with mis and disinformation the interconnected nature of traditional and social media, and we're yet to kind of navigate that complexity with the adequate kind of, as Ruth mentioned, the kind of adequately resourced regulators that can deal with the seamless flow of disinformation across traditional and social media.
So, parking the resourcing issue for one moment, but the point is well made there. What about the kind of capabilities and expertise that we would require within regulatory agencies to do this kind of regulating effectively? I mean, it's a non-trivial thing to look at something as complex as the algorithms that feed something like Newsfeed, for example, and understand not only how it works, but what the implications of it throughout the company are. Are there any examples from other industries that deal with extremely complex subject matter that is not readily comprehensible to outsiders that we can learn from in this space? I'm sort of broadly aware of financial services regulation where complex financial products are dealt with regulators sort of co-located with inside financial institutions, people that have that not just technical capability, but also contextual understanding of what is going on inside organisations. Have you looked at those kind of models where those sort of analog issues that we might learn from in this space?
I can jump in. Our submission didn't particularly focus on this. My background is as a former engineer, so I'm kind of quite familiar with that as a space. But I just wanted to, I guess, point out this really interesting aspect of the narrative, I guess, around big tech regulation, that it is a really uniquely complex or technical issue area or industry. When, coming from, I was formerly a civil engineer, a hydrologist, that you just in other, and you mentioned financial services, which I've also, relatively familiar with that regulation. It's really interesting how there's not that same narrative of the fact that, the assumption is that you have to be an ex-Facebook employee to be able to understand the black box of these algorithms. But actually, the methodologies that we're talking about in terms of algorithmic audits and undertaking those with rigour require like a broader skill set and understanding of risk assessment methodology primarily, and a broader set of skills above and beyond the technical knowledge that's required. So I think there's a bit of a, I just wanted to point that out because I think it's quite important. I don't think that there is a capability. I think that the capabilities exist and could be built if the regulators were resourced adequately. But I think our position at Reset Australia is actually that it's the framework that is really essential to get right in the first instance, and the fact that we need to move towards finding regulation and ensure that algorithmic audits are a part of the regulatory process, and the data sharing, I think, is really critical, and the capability is there and can be built and developed.
Okay, no, I certainly wasn't proposing that this is a sort of a unique context in any way, but the information asymmetries that I'm sort of talking about are common across a lot of sort of microeconomic regulation. Yes, I was just thinking if there was anything that we could learn from in that space. Sort of following on from this sort of systems approach that you're taking, the submission also suggests that Australian law currently defines harm like narrowly, focuses on content or bullying behaviour targeted at an individual, and instead you suggest that by expanding the definitions of harms and risks addressed in Australia's regulatory framework would better protect Australian communities and society at large, and this means tackling misinformation, disinformation, and explicitly addressing hate speech. Can you speak to why the current definitions in these spaces are insufficient, and the approaches taken to defining these harms and risks in other jurisdictions, what advantages that might have?
Sure, I'm happy to look at this. I mean, if you take a sort of comparative perspective, a lot of other regulation jurisdictions around the world are building these regulatory frameworks that include what we've described as societal and community risks. So there's risks to individuals, there's content risks, and those are really handled very well actually by the Online Safety Act. But actually what's missing is this sort of newer approach that we see, particularly coming through the EU's proposed Digital Services Act, but also the UK's Online Safety Act, where the definition of harms and what's considered a risk to address and a harm to hold a platform accountable for includes things like what are the impacts on societal structures, be that Parliament, healthcare institutes, all of the sorts of actual institutes that hold our society together, but also what are the risks that are emerging to specific communities, because sometimes actually the risks that communities, particularly marginalised communities, are facing are a bit more than a sum of a collection of individual risks, and if your regulation can only sort of really pick out this individual piece of content is offensive to this individual person or could reasonably be held to be offensive, you can miss this sort of pattern of content or these sort of patterns of behaviour that actually create an environment that encourages and creates content that would finally cross that threshold to be considered more offensive. And so, you know, it's a broader framework, and we can see Australia's framework really struggling to cope with some of these, you know, societal and community risks. When we look at, for example, how our Online Safety Act looks at COVID mis and disinformation, or electoral mis and disinformation, or even things as simple as for young people, well, I guess actually for all people, but particularly for young people, content around pro-anorexia and pro-eating disorder content. It falls beyond the scope of what our Online Safety Act can look at. And it means that, you know, there's almost a suite of risks and a suite of harms that our regulatory framework is too narrow to focus on. And I think there's a real opportunity to learn from what other jurisdictions are looking at, which is sort of taking that step back and taking a risk-based approach to systems and processes, and saying, actually, platforms, we're going to hold you accountable for all of the decisions you make, for the risks and, you know, for the systems and processes you build. You're going to have to identify these risks, mitigate these risks, and be held accountable to them. And actually, your set of risks, if you take an approach that's systems focused, you don't need to sort of identify, here is the type of content that we will take down by this, you know, in this particular time. You can talk about risk assessments, and that sort of approach that really will, I guess, address a more broad set of risks than the current regulatory framework does.
Just to briefly add to that, I think an example that was raised earlier just by Ed Sandhow previously was a really excellent example of what Chris is talking about. So the example around memorialising people on Facebook and how, had a systemic risk assessment been undertaken about that feature, you know, that would have been raised at that stage, at the upstream stage, prior to First Nations communities having to be impacted by that harm. So that kind of really tangibly demonstrates what Chris is talking about.
Just one more question before I proceed to other members. In the past, in sort of during certain specific events like, you know, the start of the pandemic and the last federal election, Reset's argued for requiring social media platforms to operate live lists of widely shared content that are accessible by academic researchers, policymakers, to provide that kind of real-time transparency about, you know, what is happening on platforms to allow misinformation, disinformation to be identified and responded to. Is it still your view that this is a useful sort of transparency intervention to help us understand what's happening in terms of algorithmic amplification or these recommendation engines during these acute times like the upcoming federal election?
Great question. Yes, so Reset Australia, as you said, has called for this at those particularly acute moments where that level of transparency and the understanding of what is the most viral mis and disinformation is particularly relevant and important to understand. I guess we have been thinking in terms of, you know, what's really critical in the short and medium term and what's critical in the longer term. And so these kinds of proposals that you're referring to, so originally it was a COVID live list policy, and then we've more recently proposed an electoral live list policy. Those are kind of short-term measures and kind of a first step towards the types of transparency that we really like to see from social media platforms. And so we believe that could kind of be a first building block towards the infrastructure that would be required for larger scale transparency mechanisms and larger scale risk assessments like the algorithmic audits that we're calling for. And so in the longer term, building on that, we would like to see the ability for, as we've discussed already, the more upstream systems and process assessment of risk at a kind of a broader level, so that we could look at, you know, algorithms, platform design, how specific features are impacting not just individuals but communities and societies at a broader level.
Thank you.
Thank you very much, Deputy Chair. And questions from Mr. Simmons.
Thank you very much, Chair, and thank you to the witnesses for appearing today. I know you've done a lot of good work in this space. Can I just pick up where the Deputy Chair left off and just talking about transparency? You know, we had TikTok as witnesses earlier today, and I raised your study that you did last year where, you know, you started these TikTok accounts and within 4 hours of viewing, you were being pushed videos which would be unacceptable for a 13-year-old. Does it concern you that their answer to that was that they weren't aware of it, hadn't read it, hadn't seen it? How troubling is the disconnect between people who are trying to address the ills of abuse on social media and the disconnect between them and the actual tech companies? And given what Frances Haugen has told us, how over-reliant are we on the tech companies' own internal research and efforts?
Yeah, I'll jump in. I think that, you know, you're absolutely right, and it speaks to a much broader issue in how, I guess, policymakers and also, you know, civil society is able to engage with these, you know, large tech companies. At the moment, the sort of default approach has been, you know, self-regulation or co-regulation. And actually relying on these tech companies to identify their own problems, and we have to sort of trust them to fix that without you know, requirements around transparency. So we sort of almost operate in blind faith. And actually, what's become increasingly apparent over the years is that approach has absolutely demonstrably failed. It's particularly failed for children and young people. And I think what we need to move towards, again, which we're seeing right around the world, is a sort of recognition that actually the risks that these tech companies create a sort of high impact. You know, they include really significant public health and community concerns, and also, you know, really significant issues for individuals. That there's a real public appetite for, you know, not leaving it to tech companies anymore. The community, particularly the Australian community, acknowledges, you know, after we witnessed Facebook turn off services in the middle of a bushfire season at the start of a pandemic, you know, we can't leave it to them anymore. And that our approach, you know, the sort of lighter touch self and co-regulation, leaving it to them to identify their problems and fix them, just doesn't work. It's an issue that has a track record, a sort of demonstrable track record of systemic compliance issues with what little regulation there is, let alone, you know, to improve itself. Yeah. Actually, this, I mean, to me, this just seems, you know, what we need is really strong regulation and regulators that are enforced enough to sort of demand that actually these companies take note of what's going on, that they proactively investigate and identify problems, and that they proactively fix them, and that they tell us about this.
Yeah, so I mean, I don't want to put words in your mouth, but what you're saying is we can talk a big game about safety by design, and they can talk a big game about their algorithms and AI and all the rest of it, but we're essentially at their mercy still on this issue to a great extent, aren't we? In terms of protecting safety, public safety.
Yeah, I mean, I'll give you another example, if I can, about children and young people. So one of the pieces of research that Reset Australia did, I think it was the sort of early last year, was looking at how Facebook used young people's data to target them for advertising. And we were able to identify that Facebook was using young people's data in all sorts of ways that we'd consider unsavoury. So identifying young people who were interested in alcohol or interested in gambling, and that advertisers were able to use that as a category to target. And I think in response to that sort of research, but also in response to regulation that was coming through in the UK and Ireland and Europe, Facebook announced, they made a big announcement that actually they were turning off the ability for advertisers to target young people by selecting alcohol and gambling and these sorts of things. They'd listened to youth advocates, as their press release put it, and they turned those features off. But actually what they didn't say in that announcement was that actually Facebook, Instagram, all of the platforms that Meta run were still using young people's data about what they did in the platform. So, you know, the multiple hours young people spend on Instagram, they were tracking that, they were identifying what they were interested in, and that information was used by their advertising algorithm to place ads for them. So as Frances Haugen put it, if a young person is interested in partying, and someone has a slightly dubious ad that they want to reach young people who are interested in partying, the algorithm will still feed it there. So what we sort of saw was, well, Facebook as it was then, Meta as it is now, delivering a sort of inadequate solution in response to a concern raised by civil society. And I just think that that demonstrates, if anything, a sort of anemic response for big tech in particular to prioritising young people's safety.
Yeah, look, we talk about this issue all day because we had the platforms on earlier, and their kind of response to this is, well, they accept the terms and conditions. But how a 13-year-old can understand the data they're giving away when they accept the terms and conditions of TikTok is beyond me. But just because there's a couple of other issues I want to focus on. You talked about we need more regulation in this space to take back the power. Some of the, like Digi who represents the tech companies, were talking about the government, seeking the government to define things like hate speech and the others. And my concern there is that if we try and define a box of what is acceptable conduct online and what isn't with these tech companies, the moment it steps outside the box, the tech companies won't feel the need to take it down, and they'll blame the government for not having a wide enough definition. So how important is it when we're regulating to have instead to regulate more of a duty of care for these tech companies, which can be broader and still keeps the onus on them to police their platforms rather than government doing endless definitions?
I'll jump in there again if Dee, if you're all right with that. Yeah, look, I think ultimately that's the solution. Social media companies have demonstrated that they will act within the letter of the law, if not, they won't act within the spirit of the law. And when you take an approach that sort of limits it to, here are the 8 types of content that we want you to address, you may get an adequate response to the 8 types of content. But actually what we need is something more systemic, something deeper. And when you start placing duties and obligations on platforms to mitigate risks in their systems, and that goes beyond content, but including algorithms, so looking at how they recommend particular types of content, but also features, like actually does launching this new feature create a suite of risks either for individuals, a community or society, and you hold companies to account for the risks that they're creating. You should start to see platforms, I think, changing the way that they develop and release their products in ways where safety and risk reduction are more centralised in their process. And I think what's going to be really interesting is watching the wholesale changes that we see coming in platforms as a result of the EU's Digital Services Act. And I think that that's the sort of approach. If we look at where I have seen systemic regulation, that upstream regulation implemented, it's for children and young people in the UK when they pass the age-appropriate design code. And all of a sudden, in advance of the enforcement of that, we saw these tech companies suddenly making these really simple decisions that you'd imagine that they should have done from the first place, like defaulting young people's accounts to private. Why were children's accounts ever public by default in the first instance? Or turning GPS tracking off of children so you didn't broadcast their GPS location. Why was that ever a feature that anyone thought would be appropriate on an account for an under 18-year-old? It was only when we got this upstream systemic regulation in the UK that came in that companies thought, okay, well, fine, we will risk assess. We will look at how we use children's data, because it's quite specifically data focused. We will look at how we use data and design for children and look at what are the risks that creates. And that sort of, for me, it demonstrated that a lot of these simple solutions are implementable, they're possible. We just haven't found a way to incentivise or regulate these companies so that they have to do that.
Thank you very much. And look, just finally, if I could, we've spoken a lot as a committee about online abuse, obviously, and we've heard from individuals who've been subject to it. These messaging platforms, and obviously I'm going to infer here about Meta, but who are moving to encryption to the extent that they're not even going to be able to intervene on their own platform because they're not going to be able to pick up what the messages say when it's end-to-end encrypted, and law enforcement is trying to drop 60 to 70% of the referrals from these tech companies. How have the tech companies failed us by turning on encryption before they have safeguards in place? And is there anything in other jurisdictions or in your suggestion that government can do in terms of protecting people from online abuse on messaging services as encryption becomes the norm?
I'll pick that one up again. Yeah, look, I mean, encryption and child safety is a really complicated and important discussion and debate to have. And I think what we've definitely seen from large social media platforms is a move towards end-to-end encryption, which for security, safety and privacy is important. But they've been doing that, before they've found a solution to systemic issues of child sexual abuse material and those images being shared online. And a cynic could say that part of the reason Meta is so suddenly excited about users' privacy that they're embracing end-to-end encryption might be because doing that it will remove the ability for them to or the obligation for them to have to scan material for child sexual abuse material and take it down. But I think that we're seeing a push towards the implementation of a feature in their products and in their systems before we've had a proper risk assessment of what that might mean and before we've identified what a solution might be. And there is the possibility to do scanning for CSAM content at the device level before messages are in progress and before encryption can take place. But that isn't fully developed yet. There's like broad consensus around this. And so what we're seeing almost is children's safety and security used as a bargaining chip or a debate starter in the discussion around privacy. And I just don't think that we've seen tech companies or many tech companies really do adequate risk assessments around what that might mean, nor identify what are the solutions that they could implement, because at the moment what we're seeing is a singular push towards the introduction of encryption, towards the introduction of this process, without any energy being invested into finding, okay, well, what's the solution for CSAM then? We are going to backslide. We are going to lose, the one hashing technology that we have that can work around this. And I think that, again, this speaks to the need to regulations to sort of tell social media companies, you have to look at all the risks, you have to balance these out, because at the moment it's just left up to their whim to decide which one to prioritise.
Thank you. I'll hand back to the chair. Much appreciated.
I really appreciate your conversation today. Thank you very much for the views and perspectives that you have provided for us. I might just ask a question, and I think it's just something I'm using, so it might come out a little bit clunky, but I listened very carefully to the language of the platforms, the various platforms that we spoke with this morning. And there was some discussion in each of the sessions around misinformation and disinformation. And the way I'll put it, the proactivity there. And then I think one of the witnesses used a word which I wrote down because I thought it was a good word to refer back to, over-moderating, that they acknowledged there had been potentially the risk of an over-moderating in one example that had been given. But I'd also provided some other examples on a different topic, but side by side a different topic in relation to abuse and, threats of harm and all sorts of things on social media that had not been moderated through algorithms, that had not been identified except through active pursuit by the individual who was harmed. And I'm sitting there comparing the two side by side and taking that word over-moderated. I'm looking at this other area and I'm thinking, why is it that this area is almost, for want of a better word, under-moderated? What would need to be done, what could be done in order to get the balance to where it should, should be. Does that make sense? If it's way below the mark, what do we need to do to get the balance of moderation back into, back out, it's a bit out of kilter, I guess is my thinking. What do we need to do to get the balance? And if I went further, why would the preferred risk, when it comes to misinformation and disinformation, it seems to be weighted on, and this is just a general principle, no other comment about specifics or anything, but it seems like it's okay to over-moderate in order to protect. Why wouldn't we sort of look at over-moderating in order to, or at least, being a little bit more disciplined in order to keep more Australians safe online? Why is it that the individual has to firstly be subjected to some pretty awful comments, and then secondly have to process them, and thirdly have to take the relevant steps to try to get these things identified? Is there something that we could do to balance it? I hope that makes sense.
Yes, thank you for that question, Chair. It's a really excellent question, actually, and something that we have thought a lot about. And I think part of the challenge that you're referring to in terms of both kind of over moderation and then in some cases content being missed, it kind of reminds me of when the Haugen revelations first came to light, and we had Facebook's Nick Clegg, the VP of Global Affairs, say that 0.05 there was only 0.05% of hate speech left on the platform because that's how effective Facebook's content moderation system was. But it's quite clear. So what kind of gets sometimes missed in the conversation is that much of the content moderation is in itself an algorithm, an automated system that has errors, and that in some cases, like you say, Facebook itself, their internal documents showed that there were several users, particularly kind of mainstream, not high-profile users, that often were inaccurately moderated. And so I think part of this is really, really excellent evidence as to why we can't rely on the tech platforms' automated content moderation systems. If we were to look at best practice content moderation, we wouldn't be solely relying on AI to do it, but it also just demonstrates how the downstream focus is so misguided when, if we were able to, as we've been discussing, look at the actual functioning of the content moderation, the actual recommender algorithms and the way that content is amplified to begin with, and look at more of those upstream risks, how we wouldn't then be in a position to kind of do an impossible task of trying to moderate mis and disinformation at this scale. But it's a really excellent question, and I think it calls into question, automated content moderation, its efficacy, and it also points to the need for more the regulations of systems and processes. So as we've been discussing, the regulation of the actual algorithms, the regulation of platform design decisions, and the specific features of the platform and how they actually function, because they are driving much of this very harmful content.
Thank you very much. I appreciate your contribution to that very much. Thank you. Okay, we might request that further questions, unless there's any further questions from any other member of the committee, be placed on notice. And to thank our witnesses for your time and your attendance and your contribution, as well as your submission to this inquiry. We very much appreciate that. To ask you that for any further additional information, if you've been asked to provide that by way of this discussion or questions on notice, that you forward that through to the Secretariat by the 3rd of February 2022, to advise you that there will be a transcript sent to you of today's proceedings, and you'll be given the opportunity, of course, to make corrections to that transcript. Again, I thank you for your time, to request corrections to transcription errors. And I thank you very much for your time and attendance here today. Given that we are miraculously actually running slightly ahead of schedule, I might suspend this committee hearing for a few moments with the indulgence of the committee to give our next witnesses some time to appear, and we will resume in a few minutes. The public hearing of the Select Committee on Social Media and Online Safety, to thank our witnesses for attending today, and to welcome the Australian representatives of the Australian Communications Media Authority to give evidence to the committee today, and ask for the Hansard record for you to please state your full name and the capacity in which you appear before the committee.
Thank you, Chair. Nerita O'Loughlin, Chair, Australian Communications and Media Authority.
Thank you. Kathy Rainsford, General Manager, Content and Consumer Division, Australian Communications and Media Authority.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'd like to thank you for your submission that you have made to the committee, which has been published and is available on the committee's website. And I just ask whether you would like to make, in addition to that, any other further opening statements or comments before we move to questions and discussion from the committee?
No, thank you, Chair. Nothing to add, and we're happy to answer the committee's questions.
Thank you very much. We appreciate that. I might, given that we have set this precedent for the day, I might invite the Deputy Chair to start.
Thank you, Chair. Happy to lead off one more time today. Thank you to the witnesses for attending today. We've had a lot of evidence today about the issues of misinformation and disinformation and regulatory approaches to that. And I know that ACMA has some involvement in this space. In February 2021, the ACMA issued a media release welcoming the new Australian Code of Practice on Disinformation and Misinformation that was released by the Digital Industry Group. Has the ACMA registered the Code of Practice on Disinformation and Misinformation?
Thank you, Deputy Chair. The ACMA doesn't have a role in the registration of that code. It is a voluntary code developed by Digi, so we don't have a role in registering the code, as we may do in other areas. As you know, in December 2019, in response to the Digital Platforms Inquiry, the government asked the industry to develop a code. We assisted in that process by developing a position paper, setting out what the expectations of the regulator, we as the regulator would like to see in that code, and the DG took that into account in the development of its code, which, as you said, they made public in February 2021.
Yeah, it's been some time since I practiced as a communications lawyer, and I do know that word registration has some significance in this area of law. But I'm just slightly confused though, because the Minister for Communications, Paul Fletcher, in his book Governing in the Internet Age, wrote that the ACMA has, quote, registered the Code of Practice on Disinformation and Misinformation. And at page 41 of his book, he states that, quote, in February 2021, our media regulator, the Australian Communications and Media Authority, registered a voluntary code of practice on misinformation and disinformation that was developed by the digital industry. Is the Minister correct or incorrect to say that you registered this code?
I'm not quite sure. I'm not aware of the language in the Minister's book in that regard.
He says you've registered it, so is that correct?
In other areas of our remit, there's a formal registration process. So, for example, with broadcasting codes, they are co-regulatory codes. So we register those codes, and then we also have responsibilities to address complaints against those codes. We don't have that formal registration approach in regard to the voluntary code developed by Digi to cover misinformation and disinformation on digital platforms at this point in time.
it's not accurate to say that you have quite registered a voluntary code of practice on misinformation and disinformation that was developed by the digital industry.
Deputy Chair, I don't know what the Minister had in mind when he used that language, but it was not a process of registration, of formal registration, that we have in our remit in regard to broadcasting and telecommunications.
Yeah, I'm just, let's cut the Minister out of it. I'm just saying it's not accurate to say that you have registered a voluntary.
We don't have a regulatory remit around the code. We did input into the code. The code was released as a voluntary code, not a co-regulatory code by Digi, and we continue to look at that code and provide an assessment to the government of the efficacy of that code, which we provided to the government in mid-2021.
So I'm wondering whether the Minister misunderstood the meaning of the term registered. I suspect not. He, like me, suffered many years as a communications lawyer. Or does he misunderstand the scope of ACMA's powers in relation to this code? Has the department or the ACMA brought this error to the attention, has the Minister or the department brought this error to the attention of the ACMA to clarify the status of things? Or alternatively, has the ACMA brought this error to the attention of the Minister or the department to clarify the status?
I think, Deputy Chair, we're very clear about the status of the code and our role. Our role has been to assist the industry in developing a code which is as effective as it possibly can in covering misinformation and disinformation. We provided a position paper to guide that development. We also have responsibility, as requested by the government, to provide a report to the government on how that code is working and also the broader elements and impacts of misinformation and disinformation in Australia, and that we provided to the government in June 2021. So I think we are very clear in our role in regard to the code, and we continue to work with Digi as they enhance their actions. You'll be aware in October 21, they released some additional information around complaints handling frameworks and a new complaints board. We continue to work very closely with Digi on what is a voluntary code.
So you've confirmed today, and you've previously confirmed in Senate estimates, that the Minister hasn't formally empowered the ACMA in relation to online disinformation and misinformation, that the ACMA has been granted no additional powers or funding to address online disinformation and misinformation. So that's all still accurate?
That's correct, Deputy Chair, but we have been able to work very closely with Digi in the development of the voluntary code, and we continue to work with them on enhancements of how they deliver on that code and the framework that sits around it, particularly in regard to complaints handling.
I wonder whether part of the reason the Minister hasn't formally empowered the ACMA in relation to disinformation and misinformation is because he thinks the ACMA is already empowered, that indeed he thinks that you've already registered this voluntary industry code.
I think the government's announcement was very clear in 2019 that it wanted to hold the platforms account in the first instance to develop a voluntary code. But the government at the time also said that it would assess whether that code was effective, and that's the role we've played in providing some advice to government on that assessment, and that if they felt it necessary to take further action in this space, then that would be a future decision of the government, indeed possibly the Parliament.
Okay, so as you said, on the 30th of June, the ACMA provided a report to the Minister on the broader impacts of misinformation in Australia, and provided, and in response to questions on notice, you provided further information about this, indicating, for example, that the findings that you've included in that report dealt with broader impacts of misinformation in Australia in relation to bushfires, the COVID-19 pandemic and elections. So given those specific dimensions of the impacts of misinformation in Australia, as well as the adequacy of the voluntary, have you engaged with the Department of Health and or the Australian Electoral Commission about your specific findings on, say, COVID-19 for the Health Department or election issues for the AUC?
I think we engage with a very broad range of government agencies, civil society representatives as we worked our way through that report to the government. And as you indicated, we had a particular focus in some of our research that we undertook as part of that report on people's attitude to and what they were experiencing around misinformation and disinformation on digital platforms, particularly around COVID-19. So we've undertaken new research in that area, and throughout the process we were heavily engaged with colleagues in other areas of government to test their views and what they were seeing as well.
And presumably that report went to the adequacy of the voluntary code in addressing these issues related to COVID-19.
That was the scope of, that was included in the scope of the report to the government.
Okay, so given the ongoing pandemic and the upcoming federal election, you'd agree that there's some urgency to this work and to progressing ACMA's oversight role, or your involvement in dealing with misinformation and disinformation in Australia. Would you agree with that? I mean, the election could be, a month away.
I think we are continuing to engage in this misinformation and disinformation space. While we don't necessarily have a legislative remit at this point in time, we have been given an oversight role by the government of the development and the implementation of the voluntary code. So as I said earlier, we continue to work with Digi, we continue to work with them about the whole complaints handling framework that they're putting up, their review boards that they're developing. So I think we are still very well engaged, even if there is not a formal regulatory remit at this point in time.
But since you gave this report to the Minister, we've had 6 months of a pandemic where these COVID-19 mis and disinformation issues have continued to run rampant. We're approaching the next federal election. I mean, presumably the issues you raise in this report would need to be addressed in some way. We're almost running out of runway, aren't we, before the next federal election to actually take action on the issues that you'd want to be resolved in this report, aren't we?
Well, I think the voluntary code itself is designed to encourage and incentivise those digital platforms to take actions themselves. So the platforms have put in a range of approaches to dealing with disinformation and misinformation, and taken a variety of approaches, some of it based on what type of platform they actually are, but also the design of the code was outcomes-based and it was also risk-based. So it was very much saying to the platforms that they should assess what harms may be caused by misinformation and disinformation on their platforms and take an appropriate risk-based approach to dealing with those, be that putting it down search lists or be that taking it down. So I think there is a framework that has been put in place through that voluntary code, which is in place at the moment and which the platforms and Digi have been taking very seriously.
Yeah, so you say that it's outcomes based, the code. Yes. I suppose another way of looking at that is that there are very few prescriptive requirements in that code, are there? I mean, essentially all that a signatory to the code is required to do is to do something about misinformation and disinformation. What that something is really up to them to interpret. I think there's an obligation to have a complaints mechanism in there, but really that's all there is, isn't it?
Well, there are a number of mandatory obligations, including complaints handling, and you're right, though, there are a number of opt-in requirements or obligations. And that was really, the code was developed because it needed to reflect that digital platforms are quite different, both in terms of the way they operate, but also in terms of what they carry. So Google as a search function is quite different to YouTube as a function, as a service is quite different to Facebook. So what the industry was trying to strike was a code that gave certainty that something was in place across the biggest platforms, but also recognised that some of them may not actually produce material or carry a product that may be of concern, particularly, for example, if they didn't carry news services, then those are less likely to be open to misinformation and disinformation. So you're absolutely right. It is a quite flexible code and it is outcomes based, but the platforms have committed to it and have committed to deliver on it. And as a code that's been in place for under a year, we have been had a role in reviewing it, but the Digi itself is intending to review the code in the coming months, and that will be an opportunity for them as platforms to deal with its effectiveness, but also for the public to understand whether or not those codes are actually working for them.
Yeah, as you say, the effect of this voluntary code is to have something in place, but it really does nothing to deal with, for example, an issue we've been covering throughout the hearings today of a member of parliament and a political party serially sharing COVID-19 misinformation. In fact, the member himself told the committee that he had breached the guidelines of YouTube countless times on sharing COVID-19 misinformation. YouTube continues to take advertising funding to promote that content. The YouTube and Facebook have enabled the accounts to Phoenix from a personal account in the MP's name to a political party's account. But there is nothing in the code that could deal with those issues, not only because the code only requires the platforms to do something, and what that something is totally up to them, but also because all political content is excluded. Is that correct? Political parties, authorised political content is excluded under that code.
And I'll pass to my colleague, Kath, but that's, while that's certainly the case, it is fairly consistent, I have to say, with the way that political communication is dealt with traditionally through broadcasting and other activities, in that the code, like anything, is trying to balance the tension between freedom of speech and political and other communication, and what are the protection of harms. So that's the tension that is inherent in the code and very clearly spelled out by the platforms in the code. And that's very much a balance that also exists in other areas of political communication, including for many years advertising on television or other areas of communication. But I'll ask my colleague Kath if she had anything to add to that.
Thank you, Chair. You're correct, Deputy Chair, that as part of the definition of excluded content that's authorised by Australian state or federal government, or subject to some exceptions set out in the code, political advertising or content authorised by a registered political party is outside the scope of what's captured in the voluntary code.
Yeah, I should say that I'm not proposing anything radical in this respect, except that the platforms meet their own stated moderation policies, which in my view, they're not in this context. One last question.
Can I just ask a question on that? Sorry, Deputy Chair. Can I jump in for a moment on that? Just with reference to what the Deputy Chair just said there, are there any observations you would make about what additional requirements, perhaps from ACMA, or suggestions you may have in order to encourage or require platforms to be able to comply with their own stated policies?
Chair, I think some of the issues with the code and some of our observations would be included in our report to the government. So I think, and that is under consideration by the government at the moment. But I can assure you that as part of our report, we looked very carefully at what we as the regulator might see as improvements to the code. Some of that based on a position paper that we put out in June 2020, but those where we thought that improvements could be made and where it could work more effectively, and also where greater clarity perhaps of reporting by the platforms on their performance might be useful as well. So our recommendations and our findings are included in our report, and that's currently under consideration by the government.
So just one final question there. Obviously, the minister's been considering this since the 30 June, so it's getting some high quality consideration. In this time, has the minister or any other minister discussed the ACMA's report with you since it was delivered to the minister 6 months ago?
Deputy Chair, we have had discussions with the minister in regards to the report, yes.
Okay. Have you sought funding for misinformation, disinformation work, research work as part of an MPP in this budget cycle, considering there's a federal election coming up?
We've been undertaking our work within our own resources.
Okay.
Thank
you for that.
Do that.
No more questions, Chair.
Thank you very much, Deputy Chair. I'm just interested, I'd like to go back to something. I understand the e-safety, that ACMA makes staff available to support the work of the e-safety commissioner. And I could be reading it wrong, but the remit around, and the remit of the e-safety commissioner is obviously in relation to the Online Safety Act in terms of addressing issues of online harm and abuse. And we've had some conversation and discussion around this. Just given the Deputy Chair has raised the issue about the disinformation, misinformation, and I was talking to Reset Australia before about this concept of a word was used by a previous witness about acknowledging sometimes they might over-moderate there. My question is, as a result of the evidence today, my question actually is around what is appropriate in terms of moderation for, from a platform perspective, what is appropriate in terms of moderation? So, not for the e-safety commissioner to have to step in, but with the platforms themselves. What's appropriate around moderation in relation to abuse and, this demeaning, dehumanising, degrading cyberbullying that we, too often see can be anonymous. Maybe it's somebody you know, maybe it's just Joe Blow from the street who takes a dislike to something you've said or done or your role or your business or something. And, some really harmful material is put out there. But I just note, on the one hand, there seemed to be a very strong awareness when it came to misinformation and disinformation by the platforms. On the other hand, this area seemed to be a lot more opaque, a lot less certain, a lot more wobbly, if you like. I'm just wondering if you'd like to provide any commentary or thoughts as to what could be done or what recommendations you feel this committee might be able to make or could look at in relation to getting the balance right when it comes to online safety, particularly with reference to individuals and stamping out abuse and cyberbullying.
Thank you, Chair. Obviously, our role at the ACMA is, in terms of digital platforms and social media, is confined to the disinformation, misinformation role, our role in online gambling. So I don't think I can comment on the more individual abuse aspects that you've raised importantly today, which do fit possibly more so within the remit of the E-Safety Commissioner, our colleague. What I would probably just observe is that platforms have not internationally, as you well know, been very used to being regulated. And in the Australian environment, for a long period of time, there was not really that much physical representation of those global companies in our country. I think the actions that have been taken over some years in regard to online safety and other concerns about social media platforms has very much brought those digital platforms to the table. And you're seeing a growing maturity around how they understand how to deal with governments and regulators. And I think the disinformation and misinformation code demonstrate that was a new action by those digital platforms. They had not worked together before to come up with something that was appropriate for the Australian environment. They very much usually work in terms of their global outlook, but they came together and produced that code. And I think that says that there may be further opportunities, and there's obviously mandatory codes under the Online Safety Act, that there is an opportunity for those platforms to work more constructively together to develop things which will address the harms that the Australian community is concerned about increasingly on those platforms.
Thank you. Deputy Chair, do you have further questions? I'm happy to put my additional questions on notice, unless there's another member of the committee who would like to ask questions.
No further questions from me, Chair.
Thank you. All right, well, given that, I would like to thank you very much, all our witnesses from ACMA, for attending, for your time and your contributions today. I'd also like to thank you for making a submission to this inquiry. It is appreciated. And just ask that if you have been asked to provide any additional information, to please forward it through to the Secretary by the 3rd of February 2022. To advise you that you will be sent a copy of the transcript of your evidence, and you will have an opportunity to request corrections to transcription errors. I now declare this public hearing closed.